Every day in the USA, people find themselves in court.
Court calls the case Katrina Pimentel versus Haley Wilson. There you go. They're both on Zoom.
I'm here. Can you hear me, Judge?
Yes, I can hear you.
Okay.
It's Katrina Pimentel and Christopher Pimentel versus Haley Wilson.
Yeah,
Ms.
it's actually
Wilson?
Karina.
And
I'm
it's actually
sorry?
Hallie.
Okay. Where are we on this case, folks?
So I filed a motion to reopen the matter and proceed with eviction. Last time we were in court, you ordered her to pay, I believe it was, let me just pull it up here,
1035.
1035
Yes.
plus April rent. And she made the payment, I believe it was last week of the 1035, but she still owes April and May rent. And
I can't hear.
because of
Ma'am?
whatever, I'm here.
Ma'am, you're going to have to stay someplace stationary because you keep going in and out.
I'm sorry. Is this okay right here? Can you hear me good?
Yep, I can hear
Be
you.
because of whatever issues she's had with Section A, they have not paid her April and May rent either. So we actually have she's owed we are owed the entire month of April and May. We spoke to Section A. They said that they did not receive recertification paperwork from her, and that's why they held April rent. And that they said they would release it, but as of yet, they have not released it.
That would be because they have sent 2 notifications to you about the inspection that they said that you have not responded to. And I did send you the correspondence that
No,
was sent.
Haley, we spoke to Section A, and they said that they had trouble getting in contact with you concerning recertification. That's why April rent has not been paid. You sent us a letter, and I have the messages for May, where you said you just received this May 1st for the inspection. That is the first time that I'm seeing that one.
Right, you're saying May. I'm just saying in April, I've got the email from her that says that they released it immediately. I mean, I sent you directly what they sent me. I mean, and they sent on that form is where it says that they wouldn't be doing May's because of the inspection that they hadn't heard back from you. And I can get that paperwork right now.
You're you muted yourself, so you were saying something and I didn't hear you.
I'm sorry. The only reason why we even found out about April rent is because we had to get on the phone and speak to Section A for hours trying to get a hold of someone to figure out why we weren't paid for April. And as of yet, they have not released payment for April. They said that the reason why they held payment is because they did not hear back from her concerning recertification, and that normally they would just cancel her voucher, but she ended up getting a nice case manager that said they just held payment instead to give her the opportunity to be able to provide the recertification paperwork so that they can release payments. But as of now, we have not been paid April and we have not been paid May, the entire rent amount. And, as far as last time we were in court, you set the amount of 1035 for her to pay plus the April rent. She just paid that last week. I'm just at the point where I just feel like this is going to be an ongoing issue, and it's been going on for too long. We've been patient. I just don't want to, be back in court again.
Well, I don't have anything that indicates she has a voucher, correct?
Correct.
Have you finished your research?
Oh,
Who
yes, and I've got
administers who administers your voucher?
CMA out of they're like in a 231 area code up north, I believe.
That may be part of our problem. Amy, you have something to tell me?
Refer to the HCV retention team over at SOS that might be able to assist with teasing out the issue.
That's the other
Okay.
things I had I filled out for a SER, and my caseworker, Miss Lamar, she sent for shelter verification to be filled out by the landlord and had not received anything.
Okay,
So that
look, are
hindered
you
me.
guys gonna sit? Let me ask you a question. Are you guys gonna sit here and blame each other about everything, or do you guys want to try to solve this?
I'd love to solve it.
I mean, I would like to know what the options are. What's gonna like? What are going to be the options? Because right now, April and May rent is not fully paid. So I just,
All right.
and it's kind of been an ongoing thing with her. It's, we started in September, and yes, she, once we filed for eviction is when she started becoming responsive and making payments, but I just don't want to
in the
become.
hospital for a month. I died on the operating table 3 times due to sepsis, but I'm sorry.
All right, look, couple things. First thing is, she's paid up through then March, correct? You're muted again.
Correct.
Okay, so she's paid up through March. It's April and May. There is I call it a division, but anyway, part of the housing programs here in Washington that will look at and try to assist the defendant in sort of working through the process so that she can get recertified, so that whatever the holdup is on the inspection, so that all of that can be accomplished. And I think what I'm going to do is refer her to that. Ms. Wilson, would you like to work with those folks?
Yes, please, please.
All right. Now, I'm going to explain this to both parties, and particularly to the plaintiff. I'm going to allow your case to be reopened. I think part of the thing that you should look at, ma'am, is that a lot of times some of the difficulties that may occur with a voucher are not related to the tenant. You may think that it is. You may contact Section 8, and they may say that it is the tenant doing something. I've been doing this for years on end, and particularly right now. And when I asked who administers her voucher, I can tell you there are issues with that group. So while I don't know for sure, this indeed may not be Miss Wilson's fault. If it's not Miss Wilson's fault, so that you can get this into your head, I'm not going to allow her to be punished for what may be the actions of a bureaucracy that she has to try to wind herself through, which somewhat has people who can't even do that bureaucracy right. And they will tell you things, they'll tell her things, and sometimes they'll even tell me things. So we're going to try to work it through. So,
Thank you so
Amy,
much.
if she's referred over there, how much?
I did an updated email and phone number. What I see here is not this year.
Pardon?
I just need an updated email.
For me,
Okay, Miss Will. Well, hold on. I don't want you
Okay.
saying it to the whole
Okay.
world, because
Okay.
then goodness knows who'll be emailing you. Do we have her email? Well, Ms.
Your
Wilson,
Honor.
do you know how to use the chat?
I do not.
Okay, what's it
hardly got
start with?
unmuted.
Well, what's the provider? Ms. Wilson,
Yes.
is the Gmail address the good one?
That is correct.
Okay, then you don't have a problem with us turning that over to Amy, do you?
Not at all. She's more than,
Okay.
I would love that.
And-
Your Honor, is there any way that, I mean, she can at least pay her portion of what she's supposed to pay for April and May? Or, I mean, at least April something?
Well, here's part of the problem with that. What's her portion?
Haley, I think your portion just recently changed, correct, for May?
$610 a month, correct.
I'm sorry?
$610 a month is my
Okay.
portion. And
When
if
did that change?
No, 610 is been, that's the same one. I thought that you said your portion was going to change again.
No.
That's the reason I'm asking. Okay, so $610.
But like I said, I mean, that's what I was filling. That's what I had filled the SER out for, as the judge had asked, told me that that was an option for me last time, and you didn't get back to my caseworker, so she had to close it.
I have not received anything.
I sent you it as well, but okay.
You know what? If you guys want to fight, I can just leave you alone and I can just, I
No,
got other
please.
stuff to do.
I'm so sorry. I just like Amy, if I can. I mean, I apologize, Your Honor.
Okay, so Ms. Wilson, do you agree that your portion is 610?
Yes.
Do you have the 610?
No, I do not. Not till the 17th. And like I said, I mean, my caseworker, they were going to help me through DHS. I mean, get that caught up so I wouldn't be in this bind.
I know, ma'am, listen. Right now, then, there's 2 months of that portion owing. Is that what you have, ma'am?
Are you, if you're asking me, yes.
Okay, Ms. Wilson, do you agree, based on at least the last recertification, that there would be $1,020 owed by you?
Yes, that is correct.
Okay, so now come the 17th, what will you have?
I will have half of that. I will be able to just catch up on 1 month, because somehow in my paperwork, I thought that 1035 was out of the like $4,000 that I paid in the past month and a half. I somehow thought April's was in that amount. However, I guess it's not. So that's my.
So through all of that, you're going to have $610
Correct.
on the 17th.
Correct.
Okay. So what I'm going to indicate is defendant to pay $617 or $610 by the 17th
Got it.
of May. Okay.
It will
Now
be
that's going to be at least the April payment. Now I'm
Correct.
going to warn both. I'm going to warn both of you this. Well, Ms. Wilson, did you send in paperwork regarding your recertification?
Yes, sir. And I've also got the email from my CMA caseworker that stated that they have received it, that everything has been turned in, and that the payments for them would be reinstated effective immediately. And I like I said, I've got an email from.
Okay, I hear you.
Okay.
I'm just trying to make sure that your portion didn't change.
No, until my daughter has her third baby here in September, I think I'll be
Pardon?
the same. I said, until my daughter has her third baby here in September, the amount will still be the same, because it's still the same dwelling, because they all live with me.
All right. You pay that, you'll have somebody from OCD Hawk send you, you'll be getting an email. You need to
Okay.
follow the instructions on that email and contact.
You said
That
it's going to be
person.
through Hawk? Is that?
Well, it's going to come from you.
Okay, I just want to make sure, you know, if I check for spam, you know, like the emails sometimes don't all come through, so.
Okay, just look out for the email, follow the instructions. Got it?
You got it. Yes.
Okay, now I'm just gonna warn both of you. You get the 610 in. The problem for the plaintiff is this. I don't know how quickly I'm gonna bet part of the logjam in all of this rests with CMA, doesn't rest with the plaintiff, doesn't rest with the defendant. And so it's going to be having the individuals from the county sort of unblock that for both of you. So both of you are going to have patience. All right. Now, if you come here and you don't have patience, then I just won't hear anything. And you guys can go be impatient someplace else.
Judge, I would just ask, can we have a status hearing or something just to make sure that there's some type of progress on everything? I just don't want this to sit and months go by and
well, when am I gonna? I haven't given you a date to come back yet, ma'am. I was just respectfully requesting a status hearing. That's all. Okay, I've been doing this about 25 years. I know how to do it. I get it. Amy, if they start working on that, what are our averages trying to get through with CMA? Is there a feel for that?
2 weeks.
2 weeks out? All right. So you pay on the 17th to 610. I'll adjourn this matter to May 24th, 2024 at 3 p.m.
May 24th, 3 p.m. You got it, and I'll have that in by next Friday.
The motion to reopen the case is granted.
Okay.
We'll see you then. Thank you.
Thank you. Appreciate it, Your Honor. Have a good one.
Mr. Williams? Mr. Williams?
Yes.
All right. You're not even gonna attempt to sit up, huh? No. All right, Mr. Williams, I've made an error. I know you're supposed to have counsel today. For some reason, it didn't get over to that office that needs to appoint counsel for that. So I need to give you another date so that you can come back. I'll make sure that it gets sent over today for your violations. Okay?
It's the same thing you told me last time, though. I keep missing work. I lost my job in a minute. That's my 4th time coming to court. And you had a problem with me saying this last time. Because he kept saying it was going to go to trial. This is my 4th time.
All right, let me see if I can get somebody appointed. Mr. Bachman, can you take this case for me? I'll get you appointed.
Yeah, absolutely.
Okay, I'm gonna have you talk to Mr. Williams. I'll have you MIDC appointed to this case.
Yeah.
And this is your 3rd time, not your 4th time, 3rd.
So we'll set it for trial today. I'll speak to Ms. Mason about all your concerns, Mr. Williams. I know what you need, the information pursuant to what you're being charged with. And you and I will hear that sometime soon in my office, like probably next week, okay?
All right, I can set it for a quick trial too, Attorney Bachman.
Thank you.
You're welcome.
Can I take Mr. Williams in the breakout room? I'd just like to have his personal information myself.
No, I was going to say, talk to him real quick and get all the information, and I'll set it for a bench trial.
Thank you, Mr. Williams.
Or jury trial. I got the quick jury trial days too.
Okay. Mr. Williams, you're still in the breakout room. I think you are in room 18. Can you return there?
I don't know how to do it.
Okay, I'll move you to a different room. Let's go to room.
Do I hit the box up in the front where it says join breakout room?
Yeah, I'm going to send you to another room. Now that's easier. Just see me there. I'll be right back.
Okay. All right. Please listen for your name to be called. Now calling the matter of the people versus Timothy Williams. Ticket number SP 1481587, count 1, no insurance misdemeanor, count 2, failed to stop upon request. Ticket SP 1482523, count 1, failed to signal, count 2, violation of the basic speed law, count 3, vary course without signal observation. Appearances for the record, starting with counsel, please.
Good morning, Your Honor. Harry Boffman on behalf of the defendant. Would you, sir, state your name, please?
Timothy Williams.
Judge, we're going to continue a not guilty plea at this point. Set the matter for a waiver trial by Zoom.
All right. Let me give him a quick date. All right, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights?
Yes.
And it's my understanding that you want to have a bench trial. That's a trial before me as the trier and finder of facts. Is that correct, sir?
Yes.
All right. 3 weeks from now is May 31st. That's the quickest I can get you in because it has to be at least a 3-week notice. Does that work for you, sir?
Yes.
All right, I'll set this May 31st at 8:30 a.m. I'll let his bond continue at $0 personal.
Thank you.
Okay.
Your
You're
Honor,
welcome.
before the defendant excuses himself, I'm asking him if he would please chat to me the information that I requested. Do you know how to access chat, Mr. Williams?
No.
Did you need his personal information? I have it. I can send it to you, Attorney Boffman, if you need it.
Yes, I just want to make sure I have it. Thank you, Your Honor.
Okay. All right, no problem. All right, you're all set, Mr. Williams. Adrian Williams.
Yes, ma'am.
Yep.
You're welcome, Mr. Wynn. Okay, I'll see you then.
All right.
All
Thank you, Your
bye-bye,
Honor.
sir. You're welcome. Willie Watson.
Okay. How you feel?
Yes, ma'am. Yes,
Not calling the matter of the people versus Willie Watson Jr. This is ticket U 691295524. This is one count receiving and admitting another for the act of prostitution. I also have ticket number U 691201241, one count possession of drug paraphernalia. Appearances for the record, starting with counsel, please.
Good morning, Your Honor. Ben Werbling, P64889 on behalf of the defendant. Your name for the record, sir?
Willie Watson Jr.
And Judge, we'd ask any warrants be recalled for purposes of arraignment. We will stand mute and waive formal reading at this time.
This time, the court's going to enter a plea of not guilty on behalf of your client. How are we proceeding?
Judge, he wants to continue his not guilty plea. He's requesting a bench trial.
All right, if that's the case, sir, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Yes, Your Honor.
All right, is your phone plugged in? Is that why you laying down like this?
Well, I have an injury.
Okay, that's fair enough. You good, sir. Okay, if I don't want you to injure yourself anymore.
Well, I can say it for a second.
Okay. All right, did you have a chance to talk to Attorney Werberline about your case and about your rights?
Yes, Your Honor.
And it's my understanding you want to have a bench trial. That's a trial before me as the trier and finder of facts. Is that correct, sir?
Yes, ma'am.
All right, I'll set this for a bench trial on the date of August 14th. August 14th. That'll be at 9 a.m. I'll set your bond at $0 personal, okay? All right, Mr. Watson, that's via Zoom. So the same way you're doing today, Zoom in that day, okay?
Hello?
Hello, can you hear me?
Yeah.
Okay,
on everyone.
okay, August
I didn't hear anything
14th.
that was said.
Okay, I said August
14th.
14th at 9 a.m. via Zoom. Okay, the same way you zoomed in today. Zoom in on that day, okay?
At 9 a.m. Okay.
9 a.m. Okay.
August 14th.
Yep.
Okay. And Your Honor, may I ask a question? I don't know if I might be
Sure.
in like I don't know if I might have to be in chemo and radiation treatment at that time. So right now I'm going through a bunch of health issues.
Okay.
So if I'm not able to make it, what do I need to do? Contact the court or my attorney?
Yes, you need to call the court and let us know you're not going to be able to make it so that we can adjourn it. If you're going to be down for a while, then let us know so that we can try and take care of it. Okay.
Yeah, because right now I'm supposed to be going to I'm having some treatment to take care of a wound right now that I got back in February from E. coli bacteria infection.
I'm sorry to hear that.
That's for
When does that
hyperbaric.
take?
That's going to be hyperbaric consultation I have on Monday.
Okay.
But I think about 15 to 20 days in that. And then after that, I'm going to be dealing with my oncologist and radiologist for, going to start treating the cancer, which is going to probably, going to probably be 30, 40 days of treatments and stuff, things like that. So I'm not exactly sure right now. And then I have, different things going on right now with, nursing, wound care and all that stuff right now. So
I can either try and bring it closer or I can set it out farther. But so what's going to end up happening is I'm only going to adjourn it so far, and then we'll just let it go into warrant status. There won't be any money attached to that, but that way, when you feel better, you can come and take care of it, because I can't just adjourn it indefinitely. I'm empathetic to what you're experiencing, what you're going through, but I can't just have it sitting on my docket indefinitely. So
let's try to move it closer.
Okay.
Maybe. And then should just so happen to one of the radiation and chemo therapy sessions happen to be on the court date, I would just have to miss that session. Hopefully, be able to recover from later on. Taking
Hopefully
an extra
that won't
day.
happen. We'll try and find some day we can use. Okay.
All right. So August 14th is the date that you have right now, or are you going to try to?
Oh, I'm gonna give you June 6th.
June 6th. Okay.
Okay. Much sooner.
Yes,
that way we can try and take care of this before you have to go through all of that. Okay.
Yes, ma'am.
All right. June 6th at 9 a.m., sir.
All right. Thank you, Your Honor.
You're very welcome. Have a good day. Okay.
You do the same.
Thank you, Judge.
Thank you. You're welcome. Larry Warfield.
Yes.
All right. Now calling the matter of the people versus Larry Lee Warfield. This is to get Warfield. Okay. All right. Miss Ware, you got to go to breakout room to talk to the attorney. I'm going to put you in there to talk to him, okay?
Yeah, I'm ready.
Okay. All right. Go in number 9. Mr. Walls?
Yes, ma'am.
Have you been in contact with your attorney? Because he hasn't checked in with us.
I've been waiting in the conference room, Your Honor.
I know. Have you tried reaching out to them in the meanwhile?
Yes. I talked to the prosecutor. He came in, but he said he didn't have my case up before him. And he said he'll be right back.
Correction, you didn't talk to, correction, you did not talk to the prosecutor.
I talked to the prosecutor, talked to a defense counsel. He didn't realize who he had talked to. So it's okay, Attorney Mason. I'll fix it. I won't throw you under the bus. Don't worry. All right, Mr. Walls.
Yes, ma'am.
Mr. Walls, you didn't, where's your attorney at? So he hasn't checked in, or they haven't checked in. So I can't give you an adjournment to try and get them here, but otherwise you're gonna have to utilize the services of House Counsel or find another attorney, because there's not much
I
I
didn't
can
even
do.
know. I apologize, Your Honor. I didn't even know I had an attorney signed to me.
What do you mean?
I have never met him.
Did you? Okay, all right. Did you tell someone you had an attorney assigned to you? Because I have a name beside it.
I know. No, this just on paperwork, and I never talked to him.
Yeah, Judge, that's the name of the attorney that he told me he's attached to. That's why I typed that in there.
No, he put down the name of the officer who stopped him.
Oh, is that?
All right. Yes, that's the name of the officer who stopped him. Okay, Mr. Walls, I thoroughly apologize. So on the card that you get, it always puts the officer's name. And so that's not your attorney. You get assigned attorney when you actually come here today.
Oh.
And so that's the officer who stopped you on that day. So that's not an attorney you are assigned. So Attorney Bachman, you here? Can you talk to him in the breakout room about his case and about his rights, please?
Of course.
Thank you so much. All right, so I'm gonna assign, do you need to be co-host again? You got that capability?
I can just access the single room. I can access
I'll
the
put you in
breakout
room
rooms.
number 4. All right, sir, I'm gonna move you to room number 4 so that way you can talk to the attorney about your case and your rights, okay?
Thank you, Judge.
You're welcome. Now I call in the matter of the people versus Taiwan Jamal Walls. This is
Yes,
ticket
Your
number
Honor.
That's
it. Oh, I was saying yes, Your Honor. I was listening to you.
now calling ticket number SP 1498754. Count 1, drive unregistered untitled motor vehicle. Count 2, no insurance misdemeanor. Ticket SP 1498772, expired plates. Also having default ticket number SP 1513792, no proof of insurance. Ticket number SP 1120438, no insurance. Ticket number SP 1265709, count 1, drove while license suspended. Count 2, improper plates. Count 3, drive unregistered untitled motor vehicle. Well, imagine in this case has been collections. Ticket number SP 1299081, 1 count disregard signal red and amber, and ticket SP 1299087. No, it's scheduled for today. Oh my! I get a 21. Ticket number SP 1299087, count 1, drive unregistered untitled motor vehicle. Count 2, no insurance misdemeanor. And ticket number SP 1265710, count 1, failed to stop for a stop sign. Appearances for the record, starting with counsel, please. Unmute yourself, Attorney Bachman.
Hoffman for the defendant. State your name.
Thank you. That's you, Attorney. Mr. Walls.
Oh, Taiwan Walls. I apologize, Your Honor.
It's okay. All right, counsel. Today's the date and time set for arraignment, I think, on a bench warrant.
You were waving.
Proceeding, counsel. Uh-oh. Want to waive any formal hearings that would take place or formal readings of the information and enter a plea of not guilty on your behalf, sir.
Okay, Your Honor.
I'm gonna set this matter for a pre-trial on the date of July 31st. July 31st at 8:30 a.m. I'll set your bond at $0 personal, okay?
Okay.
All right, if there's nothing further, you're all set, okay?
Okay, so you say, can I get that date again, Your Honor? I apologize.
Yep, July 31st at 8:30 a.m. via Zoom. So the same way you zoomed in today, Mr. Wall, zooming on that day. Tell them you don't have counsel though, okay? Remember that, because then we'll put it beside, okay? You'll get the house counsel for that day who will help you, okay?
So is it anything that I pay right now or nothing?
No, don't pay anything right now. Just try and follow the advice that Attorney Bachman gave you, okay?
All right, thank you, Your Honor.
You're very welcome.
Sir, you need to go to the Secretary of State and find out why your license is suspended and take care of that.
Oh, I didn't know it was suspended.
Yeah, I know. I know you didn't.
Mr.
Go to
Suspended.
Secretary of State. It's probably something simple.
Okay, I will be
All right.
there.
Have a good day.
Yes.
Bye, Mr. Walls.
Thank you, Your Honor.
You're welcome, sir. Thank you.
All right.
All right. What's Attorney Werberlin doing?
Yes, I'm here, Your Honor.
All right. Now calling the matter of the people versus Edward Lee Wynn Jr. This is ticket SP 1385976. Count 1, drove while license suspended. Count 2, no insurance misdemeanor. Ticket SP 1492335. Count 1, drove while license suspended. Count 2, no insurance misdemeanor. Count 3, holding or using mobile electronic device. Ticket SP 1528733. Count 1, open alcohol motor vehicle passenger. And ticket SP 930880. 1 count, drove while license not valid. Appearances for the record, starting with counsel, please.
Good morning, Your Honor. Ben Werbeling, P64889 on behalf of the defendant. Your full name for the record, sir?
Edward Lee Wynn Jr.
And Judge, this is the day and time set for a pretrial conference. My client wants to continue his not guilty plea. I explained to him the difference between a jury trial and a bench trial. He's electing to have a bench trial set over Zoom.
All right. That's the case, sir. Please raise your right hand. That's your left. That's the hand that was behind here because we chilling. Do you have a
I've been in my car on break. I've been at work on break. I done fell asleep and everything. Sorry, Judge.
It's okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. You can put your hand down, Mr. Wynn. You had a chance to talk to Attorney Werbeling about your case and about your rights?
Yes, ma'am.
I understand you want to have a bench trial. That's a trial before me as the trier and finder of facts. Is that correct, sir?
We can probably do the jury.
Okay. If you want to have a jury trial, we got to get you counsel assigned. So that way I can be able to have them follow you on this. So that's what you want? You want a jury trial?
I really just want the fastest process. So if the bench is faster, I'd rather just take that route.
It's your constitutional right. So you can't just be like, I just want to take whatever route. You gotta like make so with the misdemeanor, certain rights check in, including the right for me to put you into jail. So you have to have counsel advise you so that you can understand which way you want to go. So it's your decision. You can have a jury or a bench trial. You can't just say whichever fastest route, though. It has to be your decision based on the conversation that you've had with counsel and what you believe will be best for your situation.
All right, well, we'll do the jury.
Okay. All right. So I got to get you counsel. You need to take down his phone number so that we can call. Are you ready?
No, give me 1 second. Hopefully I have the pen handy. Matter of fact, I'll probably just program it in my phone, probably. Let's see.
You ready?
Yes, come on.
313. Come on, Mr. Wynn.
Oh.
965. It's okay. 2293.
96522.
Call at noon, okay?
Okay, so I have 313-965-2293.
That's correct. Okay. I'm gonna give you a pre-trial date of June 3rd. That way we can get counsel assigned. Then I'll see how quickly I can get you in. I might be able to get you in pretty quickly or pretty close to that other date I was gonna give today, okay?
Okay.
All right, I'll set it at 8:30 a.m. Call the court at noon today, though. Noon today, that number I gave you, okay? So we can get some personal information so I can get counsel appointed, okay?
Can I ask you a question, though, Your Honor?
Yes,
brief
sir.
question. Like, I would just wonder, I know you probably can't give me a response that I really want right now. I would just wonder why they feel like they couldn't take that open intoxicant off and make me take the other things. Why was that one the one they wanted to stick to me? Like I had
That's
other
the offer
problems.
that they have. Well, because they valid.
Okay.
I can tell you why generally why it's such a harsh one, but I don't have the reasonings behind why counsel does certain things. But one of the reasons is because it's dangerous to have open intoxicants in your vehicle. So if you haven't drove, you were driving, or you're going to begin to drive. And we know how dangerous it is sometimes in our society when people drink and drive and cause accidents. So they take it very serious because we don't want anybody to get into any type of incident where they're now driving and drinking and then endanger other lives as well as their own lives. So they take it very serious. That's why, Mr. Wynn. Okay.
I understand. I was just happy. Last thing I'm gonna say is only like 10 seconds. I was just riding with someone else. And
okay, I don't want,
he's not gonna say anything.
Well, it's okay. He's gonna do a jury trial, so he can tell me he was riding with somebody else. I can't decide.
I was riding with someone else.
I gotta advise him not to. I just don't want it to be used against him later on by the prosecutor.
I understand. Yeah. Because they record these and I take it down. So whatever you can be you under oath, so it can be used against you.
I mean, I'm just wondering why the police officer tried to charge me, and I'm a passenger, and they just got somebody in the high speed chasing this car before me, and they knew, they was aware there was a high speed chasing this car, and it wasn't me. They were showing me pictures of people that were driving. I mean, everything I'm saying is true, so I'm not worried about what the prosecutor has to say, because the officers are aware that it was a high speed chasing a car that I wasn't aware of when I hopped in as a passenger. And it was a female, not nobody I was in the car with. That's all, Your Honor, I wanted to say. I had nothing more. That's why I've got a problem with the charge.
I know. So that's why it's very important to know who your friends are and who you get in the car with. Am I right?
100%. 100%.
All right. So we're gonna get it. We're gonna get through it. We're gonna get your counsel appointed, and then we'll get you. I'll try and get you the soonest jury trial I can when you come back. Okay, Mr. Wynn?
All right. Thank you, Your Honor. I appreciate you.
I appreciate it. No problem, Mr. Wynn. You have a good day, and I'll see you on what day?
I think you said June the 3rd, correct?
June 3rd, so that I can be able to have your counsel appointed so we can get that jury trial in place, okay?
How would I know the time? Do I got to call that number?
Yeah, at 8:30. 8:30 though. I'll tell you right now, 8:30. Okay?
Okay, thank you. Yep.
You're welcome, Mr. Wynn. Okay, I'll see you then.
All right.
Thank you, Your Honor.
Sir. You're welcome. Willie Watson.
Okay. How are your kids?
Every day in the USA, people find themselves in court.
It don't matter. Okay, next, step to your right to the T.
Shove somebody up, hit somebody.
Next.
Why you gotta yell?
Yep. Because apparently they didn't hear me when I wasn't yelling. State your name, ma'am.
Tanaya.
Ms. Tony, you're for the court charged with possession of fentanyl, tampering or altering evidence, and making false report or giving false information to a law enforcement officer. Do you understand those charges?
I guess.
Well, it's a yes or no.
Law enforcement was the part that was confusing me, sir.
How's that?
Because he was high and just kind of a joke. Sorry. I didn't think he should be working for law. It's kind of scary. But yeah, besides that, how much paperwork do we need to put on this? You know, that's all. I mean, you know, I'm trying to clean up the law, not make it worse. Yeah, you know, there's 180 pages on it so far. I mean, I don't know, whatever. Sorry.
Based on the application, finds you do qualify. I'm going to go ahead and appoint the public defender representative. So you have an attorney now.
I don't know if I want one. If I had one, it would be Frank Sullivan, but he's the only one I've seen worthy of his job.
But he's a prosecutor, and he's going to be on the other side of you this time.
Okay, well, that'd be great. And then we can work with that.
Okay.
But why do I want an attorney? I want to defend myself. I mean, I don't know.
You need somebody to tell you to stop talking.
There he is.
Okay. Yes, sir. That's what I needed.
All right, deputy, criminal history.
She's actually just got out on a disorderly, and she's also on bond on some felonies out of 23.
Case numbers?
23-1251 CF.
How many people? I would like to be called not intake no more. It's irritating. Inmates call me that. It'd help if we find that.
The fentanyl bond is 10,000. The tampering is 5,000. False report is 5,000. Court date's going to be June 17th at 9 o'clock with random UAs. And I'm revoking release in 23-1251. Good luck, ma'am.
Step to your right to the T. Next. Red X, face the TV. State your, I didn't get the first bond because we were talking. What was it? Court date?
June 13th.
Thank you. All right, you can step to your right. State your name, ma'am.
Joyce Smith.
Ms. Smith, before the court on violation of community control for cases that were originally in front of Judge Stevenson. Judge Stevenson, in his infinite wisdom, has ordered you held without bond. Your court date is May 29th at 9 o'clock. Good luck, ma'am.
Step to your right to the T. Red X, sir. State your name.
Explaining before the court for the violation of conditional relief. You understand that charge?
Understand your charge.
Yes, sir. All right, Judge Gay has revoked your bond. Your court date's going to be June 3rd at 9 o'clock. Good luck to you, sir.
Hold on.
June 13th, 9 o'clock.
Thank you. State your name, sir.
Mr. Bush, before the court charges domestic violence, battery by strangulation, failure to appear for driving license being revoked, and failure to appear for no valid registration. The charges. All right, sir. I understand you've been given copies of paperwork and advised of your rights. Is that true? Yes, sir. Based on your application, I find that you do qualify for the service of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that? No, sir. Yeah, my history.
There's a 20 domestic strangulation, 18 paraphernalia VOP, failure to register marijuana producing, possession of illicit chemical,
No.
dealing and stolen, trafficking, amphetamine.
I'm sorry, Ms. Fanbro, they're preset. I apologize.
I knew that. I was like, really?
Yeah, I didn't. I missed the failure to appear on the domestic violence strangulation. All right, in order to hold out bond on the domestic violence, court dates 5/31, 9 o'clock, no contact alleged victim. On the failure to appear, the misdemeanors have been given a $1,500 bond on each with a court date of May 13th at 1 o'clock. See, the covering for Judge Grammer's throwing me for a loop. It's just not flowing like it usually does. Maybe I should be more grammar-like.
Next. Next. Red X. State your name.
Randall Morgan.
Mr. Morgan, you for the court charge grand theft. You understand that charge?
Yes.
I understand you've been given copies of paperwork and advised of your rights.
Yes.
Based on your application, I find you do qualify, and I'm going to go ahead and appoint the public defender to represent you. So any question about that?
No, sir.
Criminal history?
He has 5 others, but none after 12.
Bond's 5,000. Court date's going to be June 13th at 9 o'clock. No contact with the alleged victim. Good luck, sir.
Step to your right to the T.
Okay, sir. Ma'am.
Step to your right to the T.
Number 3.
Next. Red X, state your name.
All right, is this Mr. Narr?
Yes, sir.
All right, so court on failure to appear for felony possession of counterfeit driver's license, and a failure to appear for a pretrial on a no valid driver's license. You understand the charges?
For the failure to appear, Your Honor, I was already in custody.
That's a problem.
And yes, and they were supposed to take me to court they take me here from Bay County to Santa Rosa.
It was federal, right? Yeah, the feds don't bring you to county. Feds don't care about state court. They never
Yes,
have. They don't even care that we exist. Here's my problem. I can't change another judge's bond, okay? But I understand your son has brought in the pre-sentence investigation report from the federal system showing where you were. And so that's going to be uploaded to Judge Stevenson. So Judge Stevenson will see that, okay? That's the best I can do is tell you that it's in the system because I watched it get filed in the system. So Judge Stevenson will be aware of where you were. All right, so Judge Stevenson's where you held without bond, and I can't change that. Your court date will be May 30th at 9 o'clock. On the failure to appear for the county court case, your court date is June 4th at 9 o'clock, but your bond's $2,500. The one that matters is the
Step to your right to the T. When the green light comes on, sign. Next. Red X, sir. Step on the X. Here you go. State your name. On sign. Red X, sir. State your name.
Kyle Jones. Mr. Jones, you're fully court charged with grand theft. You understand the charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Based on your application, finds you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Thank you, sir.
Deputy, criminal history?
It's already on bond for dealing in stolen criminal mischief and a grand theft.
Case number, ma'am?
24,675 CF.
All right, Mr. Jones, on the grant theft from Best Buy, bond is $10,000. No contact with Best Buy. Court date's going to be June 17th at 9 o'clock, and I'm revoking release in case 24,675. Good luck, sir.
Step to your right to the T. Next. Red X, sir. State your name.
Schneider, you for the court on a violation of community control that was originally in front of Judge Stevenson. You understand that, sir?
Yes, sir.
All right, sir. Judge Stevenson and his infinite wisdom is already held without bond. Your court date's going to be May 29th at 9 o'clock. Good luck, sir.
Yes, sir. Thank you.
All right, step to your right to the T. Next. Red X, sir. State your name.
Mr. Summerlin, you're for the court on a violation of probation for what was originally a felony charge in front of Judge Gay. You understand that, sir?
Yes, sir. I just signed 18 months in another county. I was trying to get on the rocket docket where I could get it ranked concurrent.
I imagine they will probably, Nadia, if you will put a note to his felony attorney that he wants a rocket docket because he's already got a DOC sentence on his other case. Your court date right now is June 5th at 9 o'clock, but if they can move you up, they will. Good luck, sir.
Stand behind him. Nader, stand on the T. Now just stay there. It's neon. You'll see it. State your name.
Mr. Taylor, you're for the court on a violation of probation for what was originally felony cases in front of Judge Gay. Judge Gay and her infinite wisdom is where you held without bond. Your court date is June 5th at 9 o'clock. Good luck, sir.
Stand right here. Stand right here. Next.
Because I won't.
You about to get a copy of it. Step on the T. Red X. State your name.
Thomas Key.
Mr. Key, you're for the court on a violation of probation for driving license suspended revoked and a violation of probation for driving license suspended revoked. You understand the charges?
Yes, sir.
All right, man. Your court date is May the 22nd on the Case number 15953. You're held without bond in that case. And on case number 164153, your bond is 8,000. Your court date is May 31st at 8:30. But you can resolve both of these cases on that first court date. Okay.
Okay. There's no bond.
No, there's no bond. We've missed you for the last
7 years.
7 years.
This has been 7 years, and I came across officers.
You'll get it taken care of. You're going to be on my docket first. We'll take care of it.
Okay.
All right, step to your right to the T.
All right, Jordan is there? And I'm revoking release in 23-1251. Good luck, ma'am.
Step to your right to the T. Next. X, face the TV. State your name.
Sarah Middleton.
Middleton, you're fully court charged burglary of an unoccupied structure while unarmed. You understand the charge, ma'am?
You understand what you're charged with?
Oh, yes.
I understand you've been given copies of the paperwork and advised your rights. Is that true?
Yes.
Based on your application, if you do qualify, I'm going to go ahead and appoint the public defender representative and an attorney now. Deputy, come on in.
Early this year, burglary, unarmed trespass, 22, correct by threat to a public servant, resisting, couple of sentences on some VOPs, 21 resisting, 19 resisting trespass. It goes back to 18, and an older assault out of Arkansas, Arizona.
5,000 on the bond. No contact with the alleged victim. Court date's going to be June 13th at 9 o'clock.
They have a probation violation on here also because she's on felony probation.
Well, I don't have it on my paperwork. Are they gonna bring her back tomorrow?
Case number.
Well,
the police probably just put it on there, so you probably have to do it from the bench.
All right, give me a case number, ma'am, please.
Oh.
I hit you with the please. I hit you with the please.
Yeah, but I didn't write it down because I saw it on the paper. Hold on.
She chose violence today. I don't want to get in the way. You did. You did choose violence today. Look, I'm just filling in for Judge Grammer. I don't know why I'm catching all this attitude. And I need you to prepare because I'm going to be filling in for Judge Grammer all next week. So I need you in a good mood next week.
He can't be all next week because he said he was here all week except Friday.
That's this week. Next week, I'm doing all of it.
That's not what he said yesterday.
Okay, well, I hate to say this, although I'd love to say this. He's wrong, and I'll be here. And I'll go to my grave on that one. I will enjoy telling him he was wrong about that. That's what he said.
I'm telling you what, because he changed my schedule for next week. That's why I said that. He did it yesterday. 24808 is your case number.
CF?
Yes, sir.
Yeah, unless he's going to zoom in from London, I guess. I mean, hey, anything's possible. All right, I'm going to also sign a warrant for violation of probation 24808. Good luck to you, ma'am.
But wait, because I didn't get the first bond because we were talking. Court date?
June 13th.
Thank you. All right, you can step to your right. Yes, sir. Yes, ma'am.
What's going on?
She's having issues, so just put them on that side. State your name, sir.
Mr. Merchant, you're fully court charged of trespass. You understand that charge?
Yes, sir.
You come all the way down here from Clarksville, Tennessee. Go to our Coyote. Our Coyote Ugly?
Just let him have it. Just let him have it.
Our Coyote Ugly?
Yes, sir.
You came from Clarksville to our Coyote Ugly. Really? Like you went to Nashville to get here?
Yes, sir.
To come to Coyote, Panama City Beach?
Yes, sir.
It was a drive. Can I ask a
That
question?
is a drive. I go through there to Paducah when I go deer hunting.
I'm familiar
Yeah.
with
Yeah. That's a heck of a drive to come to our Coyote Ugly.
and I'm in this position.
Yes, in this unenviable position. Well,
Yes,
Mr. Merchant, hold on. Let's take care of some paperwork first. I understand you've been given copies of paperwork. I understand you've been getting advised of your rights. Based on your application, I find that you do qualify for the service of the Public Defender's Office, and I'm going to go ahead and appoint a public defender to represent you. So you have an attorney now.
Thank you.
Criminal history?
No history.
All right, Mr. Merchant, here's the deal. The court date I'm about to give you is going to be Monday afternoon. Are you going to be here? Not in a perfect world, right? The only answer that you really need to say is, yes, sir, I'll be in court.
Yes, sir, I'll be in court.
All right. Yeah, tell me.
You just really want to talk about this, don't you?
Just don't talk about the factual case. Don't talk about the factual case. Because everything's being recorded.
Well, I can't tell you. Do what you want to do.
I have the opportunity to go today.
Okay.
Do I have the opportunity to go today? That's what I'm asking.
We'll get you out. I mean, I'm gonna let you out of jail. But are you gonna be able to be here for court Monday afternoon?
Yes, sir.
Okay. All right. I'm gonna release you on your unrecognizance, but don't go back to Coyote Ugly for any reason.
Yes, sir. I've been told a lot. Yeah, it's like the Tim's power.
They do dance at the bar, but other than that, what is the problem? All right. Your court date is May 13th at 1 o'clock.
Yes, sir.
All right, man.
Step to your right behind him.
I just don't understand. Rue National.
State your name. Say your name. Say your name. Next. Ready, sir? State your name.
Michael Matthews. Excuse me.
All right, Mr. Matthews, before the court trial to sell, deliver, or manufacture methamphetamine within 1,000 places of a place of worship. Can you go anywhere in Bay County without being 1,000 feet of a church? Anywhere. It's impossible. Or a convenience store.
Or a car wash.
Yeah, but that's not one of the places they list, is it?
It's not, but still.
but it would be impossible. All right, Mr. Matthews, I understand you've been given copies of paperwork and advised of your rights. Based on your application, I find that you do qualify, and I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir, I was wondering, I've got a sick wife. Can I have a very low bond to get my affairs in order?
That's gonna depend on what that young lady to your left says. Ms. Fambrough?
22 domestic, making false police report, FTA in 23, a violation of court order earlier this year. You have some thefts out of Louisiana in 18.
You know, allegedly they've got you on all kinds of tape, right? Allegedly. I haven't seen it. All right, the sale of methamphetamine. Bond is 25,000. No contact. Oh no, there's nobody. Random UAs. Court date's going to be May 30th at 9 o'clock. I see. I'm so off.
Step to your right to the T. Hey, what are we gonna do with the Spanish guy still sitting over there from Raymond?
We're going to get them. We're going to have Jordani.
State your name, sir.
Douglas McLean.
Mr. McLean, you're fully court on a violation of probation for possession of paraphernalia ×2 in front of Judge Grammer. You understand that, sir?
I took it up with the City Hall of Callaway to explain to them that they sell these paraphernalia things over the counter at the vape shop for under $10 and everywhere else. Could I please get this taken care of where I don't have no more probation, parole, or any rest of it? And have it done said.
That's when they hit you with indecent exposure and trespass, allegedly. Good.
I got that taken care of about 20 minutes ago.
Yeah.
No.
They
Like,
try to
still-
give me 3 days time serve and 2 days more and they'll let me out.
Judge Grammer said your bond at 10,000. Can you make that?
I don't know, raise the price of fish on a fishing boat.
It's gonna be hard to go fishing in a wheelchair trying to
I
raise
don't
10,000.
fish, my crew does.
Okay. All right. Well, your court date's gonna be May 31st at 8:30.
All right, you can back out.
Why is this being the third time I'm being charged for this?
For which part? Because you
For
okay,
this,
because you're charged. Okay, hold on. You're charged as
The
a
third
felony,
time,
I think. You're charged as a felony. Were you originally charged as a
For
felony?
over the counter paraphernalia?
Okay, and then I'm assuming you're talking about the cannabis oil that they sell in vape shops. I don't know, man. I'm just guessing. It's all I've got.
Well, maybe you should do a little investigation before you hit me with a felony. It's
I didn't hit you with a
$7 for a
But
paraphernalia.
Kramer doesn't put people on probation for paraphernalia, does he? Huh? Nobody puts you on probation in county court for paraphernalia. So it started off in circuit court. They put you on probation for misdemeanor, and then you got picked up because you violated that probation. That's all. Have a good one.
Hell no. All right, come on, we'll get you paperwork in just a second for you.
Barrientos.
Very well, Your Honor.
It's case number 23-3575 for those of you keeping score at home. All right. Mr. Barrientos is for the court for a no valid driver's license.
Señor Barrientos, está frente al juez por no tener licencia de conducir válida.
The offer from the state is for him to plead no contest.
El Estado le ofrece que usted conteste no me opongo,
Be adjudicated guilty of the offense.
que se le condene culpable de la ofensa,
Be ordered to pay a total of $500 within, is that 9 months? 9 months of the plea.
recibir la orden de pagar $500 en un plazo de 9 meses.
He has an option if he wishes to work off most of that through the Bay County Work Program.
Tiene la opción, si así lo desea, de trabajar la mayoría del dinero mediante el programa de trabajo del condado.
And if for any reason he does not complete a sentence, it'll be 15 days in the Bay County Jail.
Y si por algún motivo no cumple con esa sentencia, entonces serían por lo menos 15 días en la cárcel del condado.
Is that what he wants to do to resolve his case?
¿Es esto lo que quiere aceptar para resolver su caso?
Yes.
Yes.
Okay. All right. We're going to accept his plea, adjudicating guilty. He's been going to be released today to pay $500 within 9 months. Buena
Bien,
suerte.
acepto el acuerdo, lo condeno culpable. Usted va a quedar en libertad hoy y tiene que pagar $500 en menos de 9 meses.
Okay.
Okay. Thank you.
Thank you, sir. Thank you.
Gracias.
Your Honor.
Wait,
Thank you, Your
step on
Honor.
the T. Oh, I thought you didn't speak English. Sign right there.
Ah, she got you. She got you.
Well, I had it earlier. I asked him did he speak English. He looked me dead in my face and said no.
Plays good.
No bueno.
Can't speak English, but can stand on a T. Imagine that.
Huh? Well, a T-
Every day in the USA, people find themselves in court.
Good luck to you. I'll remove you and you can get back to work.
Thank you. Have a good day, sir.
Thank you. All right, now, Elizabeth Jenkins has joined us. I have received an order of dismissal in that case, Mr. Fleeman. She was told she probably should appear anyway, just in case, and she is here. What's the status there?
Your Honor, I'm showing that we did file a dismissal just yesterday, or maybe it was the day before we signed in and probably sent it in yesterday. And the clerk your clerk had responded back, can't cancel the hearing until you got back because you were out of the office for a couple of days. So that was that's probably why John told her to go ahead and show up just in case there was some issue. But no, as far as we're concerned, we're dismissing the case.
You hear that, Ms. Jenkins?
Yes.
All right.
Now that I'm, if I can say something.
Yes.
I recognize the last people that were just here, and you said something about some water damage, correct? I have the same issue.
That was a different apartment building.
Yeah, but I'm pretty sure it's the same. It's like really close to mine. And
no, it's in Centerville.
Oh, okay, my bad. But on this complex, I have a problem with some water. Where I take a shower, the people from upstairs, and I already told the landlord, it's been going on for at least 6 months. The people from upstairs, every time they shower, the water, it's like my bathroom ceiling, it's leaking. So all the dirty water that they produce, like literally I could be taking a shower and they could be taking a shower and I would be showering in their dirty water. And I've told the landlord multiple times. I have proof of maintenance records.
All right,
they always say they're going to do it, and they never do it.
Right. Miss Moreno, did you hear all that?
Yes, I did, Your Honor.
All right, you made a record of it. You do have a right to withhold your rent and pay it into escrow if they fail to make necessary repairs. But I'm not going to advise you on that at this hearing. This case is dismissed, but it's on the record. Your manager is aware that you have a complaint about your water, and hopefully they'll address that.
I mean, I have 2 kids, and I'm concerned about my kids. I mean, I could care less about myself, but my kids are on that shower too. And like I said, it's dirty water from the upstairs people. I don't think it's fair for my children.
Well, all right. You've documented it here. I hope they can take care of it. You're good to go.
Judge, I'm happy. Thank you, Your Honor. Have a good day.
All right, just a minute. Would you like to talk to the people from legal aid?
Yes, of course.
All right, let me close the other room, get Mr. Fleeman out of this one. As I indicated, I've only seen anyone do it right about once or twice. Darn it. But there is a way you can withhold your rent until they repair it.
Yeah, I did not want to jeopardize and get evicted. So I'm so glad that I still showed up to this meeting.
All right, well, let me put you in the breakout room with our representative from legal aid. Hit the button that says join.
Okay, thank you, Your Honor. Have a good day.
Thank you. All right, that's dismissed, although it still took some time. You're good to go about the rest of your business.
All right, thank you, sir.
Thank you. All right, I was hoping maybe somebody else would log in so I could get a couple of notices. Mr. Rosario's been quite patient. His case was set for 9:15. This is Guess What LLC versus Jose Rosario. He is here. We've had some cases before. Rent is $8.25 per month. Mr. Rosario, I may have told you of these rights before, but I want to remind you again. As a defendant in a landlord-tenant proceeding, including non-payment of rent, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And Attorney Meg Bauer is here from Western Michigan Legal Services. You have a right to a trial by a jury or by the court. If you do wish to have a jury trial, you have to inform the court at this initial hearing or file a written demand within 5 days and pay the $50 jury fee unless the court grants you a waiver of that fee for financial reasons. You have a right to have the case heard here in St. Joseph County where the property is located. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, I think that's Community Action Agency, a housing assessment and resource agency, or if you're a veteran, you may be eligible for some veterans assistance. You do not need a judgment against you to get help from those places. A copy of the summons and complaint are sufficient, and you have received that. You may be able to reach an agreement with the landlord through a local community dispute resolution program. And if both parties are interested, we can help set that up with Citizens Mediation, Inc. You may be able to reach an agreement with the landlord. That means the case would get dismissed. That would be by a conditional order of dismissal. And if we do get to that point, we'll either provide you with a form or tell you where to do it, or most likely the attorney would prepare it. This is filed also as a non-payment of rent case. Rent is alleged to be $8.25 per month. Mr. Fleeman, what's the status here?
Your Honor, on this one, I'm showing $3,450 in rent through May. Court cost of $198.14 for a total of $3,648.14.
They got paid.
And that would not reflect any payments if he's made any since the 8th when I got this ledger.
Mr. Osario, what's your position?
My position is I did pay May. I mean, I actually paid May. It went through my bank account. I would wonder what the heck happened there, or did something happen?
Something happened.
Something happened.
Well,
okay.
You said this is as of May 8th. Today's May 9th. So if your payment cleared in the last day or two, it will show. It'll catch up.
Okay. Okay. Because I remember.
Have you asked for any emergency help?
Yes, I have. Matter of fact, I have an appointment on Monday with Community Action. I have contacted DHS. I am on assistance right now. I was a little ill for about 3 weeks with that lung thing that's been going around. So I was pretty much incapable of working. But I have reached out for assistance. Josie has been kind enough to actually give me a lot of suggestions on how to help. She is a great property manager. I just want to let you know that. You know,
I know already, but yes, thank you.
She's awesome. I mean, so you
after we heard about the leaky shower, she needs to have a little attaboy.
To tell you the truth, she is but one woman. You know what I mean? And you know, she tries her best. That's all I know.
Well, she doesn't go fix the shower, but I think she'll see that it gets fixed. All right. Mr. Fleeman, in light of the fact that he has requested some assistance, should we do a 2-week adjournment?
We should, Your Honor, and that would put us at the 24th, Friday before the holiday. So let's do it really early in the morning.
All right. Let's see. I don't think you have anything.
I don't.
All right. How about 8:45?
That's early enough. Thank you.
On May 24th. Yeah, we're going to lose Monday, the 27th as Memorial Day, so we may have to finagle our dates a little bit. All right. Normally, we would adjourn this for 7 days, but if the people establish that they have sought financial assistance, the court has the discretion to adjourn it for 2 weeks. So if you have made May's payment, it will get caught up and it will be credited to what you owe. And if you're eligible to get assistance, then that could help too. Now, the only thing that cures this is paying the entire amount of the arrearage. So let's say you paid $850, that brings it down to $2,800 and some, and they give you $1,500. You would still be responsible for the balance in between. So we'll discuss that further on the 24th. If they get what they ask for, you would have 10 days from May 24th to move or be subject to being evicted, which would take us into June, and another month's rent would be due for June. But right now, we're just talking about through May.
Yes, sir. Is there any way that I can talk to Meg from Legal Aid?
Yes.
And Judge, at some point, I would like to try to get a phone number and or email from Mr. Rosario. Can you throw me into the breakout room with him, Mr. Rosario, and Meg for a second? I'll get that information.
And then while you're doing that, I'll advise the Farrells if they're right. Good morning. Are you John Farrell and Jacinda Farrell?
Yes, sir.
Jacinda. Mr. Farrell, could you remove your hat, please? Good morning, sir. This case is entitled Guess What LLC versus John and Jacinda Farrell. This is a demand for non-payment of rent. The file number is 24407. As tenants in a landlord-tenant proceeding, you have the following legal rights. This is a demand for non-payment of rent. You have a right to retain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And as you see, Meg Bauer is here from Legal Aid. You have the right to a trial by a jury or by the court. If you do wish to have a jury trial, which rarely happens, but you have to file a demand within 5 days and pay the $50 jury demand fee unless the court grants you a waiver of that fee or demand it at this first hearing. You have a right to have the case heard here in St. Joseph County where the property is located. If a landlord has asked you to be evicted from residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated agency, a housing assessment and resource agency, or a federal help for homeless veterans program, if you have veterans benefits. I sent that information to you with the packet, and you do not need a judgment against you to get that assistance. A copy of the summons and complaint are sufficient. If you are able to reach an agreement by going through mediation, or both parties wish to do mediation, the court can refer you and help facilitate that mediation. If you're able to reach an agreement with the landlord, that means the case would be dismissed. We would file what is called a conditional order of dismissal, which either we would provide you with or tell you where to find it, or more likely the plaintiff's attorney would provide it. Mr. Tyrone Fleeman has rejoined us. Josie Moreno is here. And this is also a non-payment. I see that you have asked for rental emergency assistance. Mr. Fleeman, what's the arrearage here?
Your Honor, on this one, I'm showing $2,650 in rent, court cost of $253.28 for a total of $2,903.28.
Mr. and Mrs. Farrell, you agree with that?
We do not, Your Honor.
Okay, what do you think it is?
The last total I was given in a piece of paper was 2,550. We have repair issues that we would like fixed. We just want it to be fair for both sides.
All right, well, let's talk about that. Says rent was paid through February. I think some has been paid through then. We're $100 off. They say it's $25.50. You say it's $26.50.
I'm guessing that's $100 late fee.
$100 per month?
It was $50 the month before. I don't know why it's 100 this month.
There should only be 50.
Whoops.
All right.
So Judge, I'm off $50. Sorry.
I don't allow $100 late fee, so it's $2,600. So it's $25.50 plus the late fee for May. And $253.28, $29.0328. Now let's talk about this. You have requested emergency financial assistance from a couple of agencies. Is that correct?
From the Department of Human Services. Yes.
So perhaps, Mr. Thornton, we should continue this to the same date, which would be May 24th. I'll do it at 8:50.
And Judge, if we can go into the breakout room, I'll discuss what are the maintenance issues. I'm wondering if this is I don't know how long Josie's been doing this property, but could be there's issues need to be resolved, and if so, we need to get on them. So.
All right. Well, I've got someone in the waiting room, Devin Thompson. There's also the issue. This came up with another tenant where you can withhold your rent. And if you're claiming that you shouldn't pay rent because there's repair issues, I can have you pay the rent to me in escrow, and I'll hold on to it to determine what would be done. But I'm going to put both of you, well, I've got somebody in the breakout room, so I have to wait till they're done. So stick around for a minute.
They don't allow you more than one breakout room, Judge?
They do. I can set up a couple, but every time I try to do it, I get sideways. I get the sound shut off, or there's a other problem.
Let me tell you, Judge, you're not alone. Other courts that have the multiple breakout rooms do run into crossed signal type of situations.
Yes, and so it's just me and my friend from Grand Rapids who's here in the courtroom with me, but there's no technological assistance. It's just me spinning all the plates at once. So I only do one at a time, but let's bring in Devin Thompson and see which case they're on. Stick with me. I'm going to, Meg, we've got some other parties that we could benefit from a breakout room. I'm going to put you and Mr. Farrell and Mrs. Farrell and Mr. Fleeman. And I might as well put Josie in there too, all in a breakout room.
Thanks, Judge.
All right, let me see if I can pull this off. All right, we'll put Mr. and Mrs. Farrell, Josie, legal aid, and Tyrone Fleeman in a breakout room. In the meantime, we'll take up another matter, and Ms. Thomas, stick around. We are working on another case, so just stay with me. We're going to shift gears to LC or Arrow 6 LLC, Emil Holdings versus Jack Nichols and Stephanie Nichols. Jessica, the property manager, is here. Mr. and Mrs. Nichols are here. And Ryan Buckland, attorney for the plaintiff, is here. Let me make a note. Mr. and Mrs. Nichols, can you hear me?
Yes, sir.
Our friends at the White Pigeon Library have been very helpful helping people log in. Is that where you are, Jessica?
Yes.
All right. Well, they've been probably our most helpful library. We were here on April 28th and we made a record. The arrearage was substantial. $4,750, and we figured out the cost of $238.25. Arrearage was $4,988.25. They were working on getting some help from DHS, and according to the manager, they had not paid anything in quite some time. So, Mr. Buckman, what's the status here?
I'm not aware of any changes, Judge. I know that Ms. Thornton or some representative for the plaintiff had indicated in my office that the current rent to retain possession is $5,290, and then the cost that you mentioned on top of that. So that's my understanding of where we're currently at.
All right, so rent is $5,290 plus $238.28. 5290 plus 238.28 is 5,528.28. That's through when?
They were behind sometime late last year.
No, but 5290 pays rent through when?
That will get them current.
Through May?
Yes.
All right, Mr. and Mrs. Nichols, what's your position here?
Right now, we have the Neighborhood Inc. working on it, and the NCAP Church. We just got off the phone with Salvation Army this morning. They're holding 945 back for us. We have 500 of our own. We're just waiting to hear back from the other two right now.
All right.
Which should be today, because she said it takes about 48 hours for the neighborhood thing to come with the disclusion. Keystone lady said today will be 48 hours. I've left multiple calls with her, trying to get them to speed it up a little bit.
All right. Well, the issue here is you have to pay the entire amount of the arrearage in order to satisfy this. So let's say you get $3,800 worth of help from Keystone, Salvation Army. Well, Keystone doesn't exist anymore, but Neighborhood Inc. and Community Action. You got to pay the entire amount, or you would be subject to being evicted. Let me say also, you have 10 days from today to be subject to being evicted, which would be May 20th.
Okay.
They don't have to evict you on May 20th. They have 56 days from today to ask for the writ of eviction. But the amount due through May is $5,290, $238.28. I want you to immediately share this. Miss Nichols, Miss Thornton, do you have an email address for them?
Yes, I do. Oh, for them, no. For me,
Okay.
yes.
Oh, we will, Mr. Buckland will email a copy of this to the manager, and you can go up to the manager's office and get it.
Okay, sir.
But let me repeat, only paying the entire amount will cure the request for a writ of eviction.
Okay. We're trying our best.
It sounds like you are. So hopefully you got a plan. Mr. Buckland, if you would email me that judgment, the date for the writ is May 20th and the date for the appeal is May 20th. No money judgment is entered. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
Mr. Buckland, you've got our email, don't you?
I'm sure I do.
3B civil at stjosephcountymi.gov.
Okay. I will send that over.
Mr. and Mrs. Nichols, do you have any questions?
No, not today, sir.
All right, very good. I hope this works out for you. It sounds like you've been working on it, and I do appreciate it.
Thank you. Thank you so much, sir.
Okay, you're good to go.
All right. You have a good afternoon, sir.
Thank you.
Judge, would I call that a consent judgment then?
No, it's just a judgment. This is our second hearing.
Okay. All right.
All right.
Thank you. I'll get that sent over.
All right. And he's going to email one to you, Jessica, so they can come to.
Every day in the USA, people find themselves in court.
Mr. Weissman, or shall we proceed?
Sure, I'll call him right now.
All right, so now that you've pulled his file, we're not going to take him up just yet. Let's take up Kyler Dowell.
Here, Your Honor.
We are on the record. Do you have that file, sir? Mr. Dean, do you have that?
Yes, Your Honor, I do.
All right, we're on the record in 2023 TR 1311, State of Kansas versus Kyler H. Dowell. The state appears by and through Paul E. Dean. The defendant appears in person and pro se. His bondsman, Don Kirkman, appears. Now, this is set today, I believe, for the state's motion for forfeiture on bond, as there is a failure to appear at the March 1st, 2024 hearing. The defendant still does not have an attorney. Mr. Kyler Dowell, why were you not here March 1st?
It was a Zoom meeting, and what I got through the Zoom meeting was it was going to be set for May 1st is what I got, not March 1st. And that's why I was not present. I've been present at all the other ones and did all the other required things. I just missed set the date for May 1st and not March 1st because I asked for a continuance because I'm going through divorce in Washington County, Oklahoma.
Well, I show that we've only had two prior hearings. The first appearance, the first appearance, January 16th, 2024. You were here pro se, told me you were hiring an attorney. And so we set this to March 1st, 2024. I gave you that date personally.
Right, and that's where I got, that was the miss. It wasn't because I didn't want to show up. It was because I thought I had it down for May 1st and not March 1st.
All
That's
right.
the only reason. No other.
Okay.
That's I'll take that one on the chin.
So you weren't here March 1st and you didn't have an attorney. Are you still intending to hire an attorney?
I was wanting to, I have talked to Jill Gillette, which is part of that 13th district, and I had a similar incident that happened in Elk County, and I was wanting to see if it could be resolved just like that one, but I haven't had a chance to talk to anyone yet. I was waiting for this date.
Well, you are correct. Jill Gillette is county attorney in both Elk and Greenwood counties. They are both in the 13th Judicial District. However, I do not know what happened in the other county, and Mr. Dean is the attorney on this case for the state. Apparently you haven't talked to Ms. Gillette or Mr. Dean about handling this the way you did in Elk County.
No, I have not.
So again, on the issue of attorney, are you still planning to hire an attorney or to represent yourself or apply for court appointed? What do you have going on here?
I'm wishing to take some type of a plea bargain or something where it can be resolved as soon as possible.
Okay, you still didn't answer my question about attorney. Are you planning to waive your right to an attorney and represent yourself? Is that what you did in Elk County?
Yes.
All right, so that's one order of business. You're going to waive your right to attorney. Is anyone making you waive your right to an attorney by any threats or promises?
No. It would be advantageous to have a court appointed, or if I could get the paperwork to fill out to see if I could be have the application and be approved to get a court appointed attorney at this time.
Well, you told me you're working. Where are you working?
I'm working construction in Bartlesville, in the Bartlesville area. I've been doing that, landscaping, deck work. But then since this tornado's been in, we've been doing a lot of cleanup and stuff.
So where do you live?
I live in Independence, Kansas with my grandmother at 408 North 9th, and come down to Bartlesville. That's where my children are, and that's where I have a lot of friends and I have a lot of business because I started doing that prior to getting a divorce.
Well, Mr. Dean, I'm going to come back to you. We are here not because we thought he was going to show up and try to resolve his case, but because he failed to appear and he needs to go to law enforcement, and we need to decide on the issue of bond. So first of all, I need to get jurisdiction over his body. I mean, I do have jurisdiction over it, but he's in Bartlesville. Mr. Kirkman, have you heard from him since he's been in Bartlesville?
Yes, yes, he's been keeping pretty good contact with me. He told me that he would be here today. I didn't have to go to Bartlesville and get him or anything, and he showed up like he said he would.
Well, I still need him to turn himself in on that warrant. He hasn't done that. I need a body, or I need something. So, Mr. Dean, I'd like to hear from you on that.
Your Honor, if Mr. Kirkman's satisfied, I think I'm going to be satisfied at this point in time. But it sounds like Mr. Dow would maybe like to possibly enter a plea today. If we could have a short breakout room, I want to see what he's thinking, and perhaps we can come back and just have resolve this matter right now.
All right, we'll give you the breakout. Take a recess.
Thank you, Your Honor.
You're welcome.
Now, do you know how to join a breakout room?
There it is. I just pushed join.
Yep.
Missy, do you have any indication whether the defendant called in on May 1st or attempted to attend a hearing on May 1st?
The notes do not say anything about that.
Yeah, we'll take it up with them on the record.
Okay, Your Honor. I believe we have resolved the case and we'll be able to do a plea, but we won't be able to do it today because I need to verify the proof of insurance that Mr. Dow states that he has, and I've given him the contact information for our office so he can provide it to us. So I'd like to set this to the very next court date that we have available so that we can verify and then enter the plea.
Mr. Dow, I can't help but tell you I'm a little frustrated because these tickets date back to December 19th, 2023, the Kansas statute for no proof of insurance directs that you have but 10 days once you're stopped and you do not have liability insurance to present to the officer at the time of the stop. You have 10 days to get proof to the officer to get this ticket dismissed. Now, prosecutors and judges are pretty generous in allowing you to not only let that 10 days run, but to get your insurance in. That was December 19th. You were supposed to have that proof of insurance to the officer by December 29th. It is now May 10th. And it sounds like you're just now presenting your proof to the prosecutor. I'm also frustrated that you got your court dates confused. Now, sir, if you thought your court was May 1st, why didn't you call in on May 1st?
Because I got a letter in the certified letter in the mail that said you didn't show up to court March 1st. Therefore, I have a new docket, May 10th. And I called and they said that's the only docket that I was on. It was the May 10th docket. And that's after I missed the March 1st.
All right. Well, you have a warrant out for your arrest, and I need you to turn yourself in on that. You can do that in Oklahoma. So I'm directing that you turn yourself in on that in Oklahoma, and I will set your date. What date did you want to do this on, Mr. Dean?
Whatever our next court date is,
June 7th at 9.
Mr. Dean, are you suggesting that I set aside that warrant and continue this until June 7th, or are you taking a position on that?
obviously, earlier I'd stated that I was satisfied with, if Mr. Kirkman was satisfied with the contact he'd had a chance to speak with Mr. Dow. I am agreeable to it, but if the court believes we need to do otherwise, obviously, I'm not standing on top of my conference room table pounding my fists or anything over the deal. But if the court does require him to turn himself in on this, I do believe it would probably be appropriate to modify the current bond that we set at the last non-appearance, which was $5,000. I guess it was cash for surety. I'm sorry, I thought it was only marked cash.
Well, the first bond was $2,500 professional surety. That's why we have Mr. Kirkman, and then I ordered it forfeited when he failed to appear and raised it to $5,000. Mr. Kirkman, if I set aside that warrant, will you continue on the bond and take personal responsibility to get him here at the next date, or make sure he shows up at the next date?
You want to reinstate the $2,500 bond is what you want to do?
I'm asking you if you're willing to do that. No, I'm wanting to have him turn himself in and pay the new $5,000. But if you're willing to take responsibility, I can reinstate that bond and continue him on it. But it's only if you're willing to take responsibility again that you'll get him here.
Yes, I will.
All right, Mr. Dowell, do you think you can take better notes about your next court date?
June 7th, 9 a.m., I believe, ma'am.
All right. Strike what I said. I'll go ahead and withdraw the warrant. I will allow reinstate the $2,500 and allow Mr. Kirkman to get him here for the next hearing.
Thank you, Your Honor, for your grace.
All right.
I want him here in the courthouse, Your Honor.
Mr. Dow, make sure you get that information to my office.
Yes, sir.
ASAP. I don't want it the morning of, and I'm sitting here scrambling, trying to call people and say, please verify this, because I'm likely to not take the time to do it at that point.
Roger that, sir. Thank you so much.
You've caused a lot of extra headache for a lot of people by not getting your court date right. Yes, Mr. Kirkman, I want him at the courthouse because, well, I want him here. All right. All right, in person at the courthouse. And Missy, what time did you want him here, June 7th?
9 o'clock.
9 o'clock. And if you're not here, don't expect me to set aside any warrants in the future.
Thank you, Judge. Thank you for your passion.
You're welcome. And you may go, sir, and Mr. Kirkman, you may go unless you're here on someone else.
No, he's the only one.
All right, thank you. We'll be in recess.
Thank you, Your Honor.
You're welcome. Then Mr. Buchanan, you are excused at this time. Thank you, sir.
Thank you.
We'll now be on the record in Hopper, 2023 TR 960, State of Kansas versus Ginger K. Hopper.
Yes.
Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paulie Dean.
Ms. Hopper appears via Zoom at a separate location than counsel, Richard Paw.
Announcements, if any, sir.
Judge, we are here on a diversion control. Ms. Hopper, I had sent her the information to the Centralized Court Payment Center. She's been having difficulty using that site. She does say that she does have some of the money to start this diversion. Judge, I'm just going to leave it to your discretion at this time.
Well, you know, this is her 7th control hearing.
I understand, Judge. That's why I'm leaving it to your discretion.
Ms. Hopper, you've been telling me since September 26th of the year 2023. Well, you didn't tell me that day because you failed to appear in a bench warrant issued. But you've been telling me since October 24th of 2023 that you were going to apply for diversion.
I think he did apply in his
Okay, what happened? You applied?
Honestly, I didn't know it was still an option.
Judge, she's applied. There is a diversion agreement. She just needs to pay that money so it's officially put on diversion, Judge.
When was the contract given?
That time lapse because I didn't understand it was still available, actually. That time that it lapsed. So I'm sorry about that.
April 16th, Judge, is when I sent it to her.
Okay. And how much money do you need to come up with to turn that in, Ms. Hopper?
Judge,
I can pay 100 today.
Judge, she needs to come up with $200.
When does she need, how much time does she need to come up with that?
I would say 30 days, Judge.
Ms. Hopper, can you come up with the full money in 30 days?
Yeah. The 200 or the whole amount?
Yes, the 200.
Yes.
Whatever you need to come up with.
Yes, ma'am.
She's got the 200 now, which I thought that's what she was saying, and could pay it today.
I got 100 today.
Okay. Pay half it today. So we would just ask for 30 days, Judge. Thank you for.
Well, hold up. Does she have the money, Mr. Dean, or not? Do you know?
Sounds like she has half of what's required to start the diversion.
So she can't start the diversion today. She needs more time to come up with that.
Right.
Apparently where we're at.
Ms. Hopper, I'm inclined to say no more. This has gone on way too long. You do have $200 today?
I have $100 for sure today. I just have another 100 to my name for the week, but I just started my job. It's only part-time. During that time that the months went by, I think I wasn't even sure it was available still. So that was my fault for keeping it going, or not getting it started. But now that I understand I can, I appreciate that. So I can give you the other 100 of the 200 pretty soon. About that. So I can pay 100 today for sure, and maybe 100 next week.
Where are you? Are you in Eureka where you can drive it down and pay it, or are you in another state?
I'm in Howard, and I could drive there and pay it on today.
Do you have a legal license and a valid car?
Yes, ma'am, with insurance.
You can have it here by noon?
Yes.
Mr. Dean, will you take a partial payment? I understand you won't start the diversion until she gets it all, but
Yes, I think it's probably to her benefit to pay the $100 so that it's been applied. And I
That'd be
know
great.
sometimes things pop up and then we think, well, we need to reprioritize things, but
yes.
Thank you. I appreciate
All
that.
right, Miss Hopper, I'm not happy to do this, but I will do this.
Okay. Thank you.
So you get that in there by noon to the county attorney. This ticket goes back to August 27th of 2023. So you're about to have an anniversary in a few months, and I don't like anniversaries in this business.
Okay, I understand. Thank you.
I'm gonna set this over 30 days, Missy. When is that? There will not be any more continuances. I've probably told you that 3 times now, but this is, it's like a parent keeps saying, telling a kid no more. Well, this is your final.
Yes, ma'am.
Let's go to June 21st at 10 o'clock.
Yeah, she's given you a little more time than I would have, but June 21st at 10 o'clock.
Okay.
Now, if you have that contract on file and the county attorney doesn't require you to be here, I won't require you to be here, but you either be diverted or you be here.
Okay, I understand. Thank you.
I understand finance can be tough, but this has gone on a long time. Mr. Dean?
Your Honor, so we're setting that June 21st, 10 a.m. just to confirm that. I'm setting it for diversion control. I'm also going to set it for trial to the bench just to be safe.
Thank you.
And Ms. Hopper, what that means is as soon as you, I need to actually address this to Mr. Paul, but it seems kind of ridiculous when we're saying we're going, and Richard's right here.
You can address her, Paul. That's fine.
As soon as you get that next $100 that you can pay to apply to this, pay it so we can take this off the docket. Because if we are here on June 21st at 10 a.m. and you're telling me you're going to drive to the courthouse to pay the other $100, and I'm sitting there as a subpoenaed officer ready for trial, there probably won't be a diversion available to you. I can tell you there probably won't be. There won't be a diversion available to you. We're going to do a bench trial and we'll see what happens.
Okay.
So if you get the money next week, I'd pay it next week and just be done with it. And you know it's taken care of.
Thank you.
Great. Thank you both for your indulgence.
Nothing further. Ms. Hopper is excused.
Okay. Thank you.
You're welcome. Cedric Pelham, are you here?
Yes, he is, Your Honor.
Let's take up Mr. Collins' case. We'll be on the record in Sanchez. That's Rito Sanchez III. So we are on the record in 2023 TR 834, State of Kansas versus Rito Sanchez III. Please announce appearances.
You're on the state of Kansas, appears by through Assistant County Attorney Paul Dean.
Kent Collins appearing for the defendant, who appears by Zoom also.
And that's the defendant there to your
Yes.
right? Okay. We are set for status or review, and I have a note that the defendant was applying for diversion. Did he do that, Mr. Collins?
Not yet. We just determined we were eligible yesterday.
No, sorry, Your Honor, and I don't mean to dispute you, Mr. Collins. He actually, because Mr. Collins is a new counsel, he had been previously approved for diversion clear back in February when he was being represented by Nathan Geffrey. But that would obviously Mr. Collins wouldn't have received that information. So
I didn't know
the contract has been sent out, and we could resend that contract if that's what he still wanted to do.
Okay. Mr. Sanchez, your first appearance was September 12th of 23. That's when you first said you were going to apply for diversion. We came back for a diversion status hearing October 13th of 23. Mr. Sanchez, you then had Attorney Geffrey. And the matter was continued to December 8th. On December 8th, your third hearing, you were still with Mr. Geffrey, and he said he was waiting on discovery of videos. So we set the matter over to February 2nd, 2024. And the matter was set over to March 15th. We came in here March 15th, and you brought in counsel, Mr. Ken Collins. So we've had, this is our 6th hearing, and we're not getting very far.
I apologize, Your Honor.
Well,
I think this will be the last
okay.
hearing we need.
All right, so if I continue this to a 7th hearing, I would expect it to be the last or set for trial. Now that you have Mr. Collins and you've been approved for diversion, we need to start getting this thing wrapped up.
Your Honor, may I inquire?
Please.
Mr. Collins, do you know if your client's wanting to proceed with the diversion?
Yes, I believe he does.
Okay, Your Honor, if I could go ahead and if they want to pick a date. One, I realize I don't have a pen sitting here, which is extremely unusual, almost unheard of. But I'm going to just go ahead and hand this packet to my assistant and have her scan and email it to Mr. Collins right now.
Sounds good. And in the meantime, we will give him another court date. Missy, what do you have about, I don't know. Do you need about 30 days, Mr. Collins, since you're...
That should be sufficient.
Okay, thank you. Missy?
How about June 21st at 11?
June 21 at 11. Of course,
And that's for diversion review, correct?
Correct. And of course, if he's diverted, Mr. Collins, and it's on file, he won't, neither of you will need to be here.
Thank you.
All right. But Mr. Sanchez, you understand that. You need to stay on this. In fact, last time in March, I'd issued a warrant because you failed to appear, but your attorney managed to convince me that you were at work and to set this over to today. So you're gonna have to start showing me a little more responsibility and more concern about this case.
I will, Your Honor.
All right, thank you. Anything further, Mr. Collins, that we need to address?
No, Your Honor.
All right, Mr. Dean's out taking care of that paperwork. So at this time, let me just give him a minute to come back to his desk, make sure he doesn't have something else we need to address.
Okay.
Mr. Dean, is there anything further we need to address before I let Mr. Sanchez and his counsel go?
The only thing I need to know is what date we move this to.
June 21st at 11. Is that pen still missing?
I have to get a refill. For whatever reason, of course, normally I can just pop one of these refills out, but since I'm on Zoom and we're in court, I had to struggle with the package.
Yeah, an attorney.
June 21st.
Yes, June 21st at 11.
Right.
Attorney without a pen, that's serious stuff.
I usually have about 4 of them in my pocket, but
not today. Huh? All right, then if there's nothing further, this matter is continued to June 21st at 11. You are continued on that original bond of $1,000 then, sir, until that time. Now, if it's diverted, officially filed, Mr. Collins will let you know if you need to appear here or not.
Your Honor, and I can let everybody know, my assistant just brought the file back in and she has scanned forwarded and emailed the same to Mr. Collins.
Very good. So it could be filed today for all we know. But gentlemen, thank you. You are excused at this time. Unless, Mr. Collins, you have someone else on the docket today.
No, this is it.
All right. Well, thank you, sir. You are excused.
Have a good day.
You too.
You too.
Mr. Dean, you too.
Oh, it's one of those Fridays.
Okay, thank you.
You're welcome. Cedric Pelham, are you here?
Yes, he is, Your Honor.
We're on the record in 2023 TR 3000024, State of Kansas versus Cedric Lynn Pelham. Please announce appearances.
State of Kansas, by through Assistant County Attorney Paulie Dean.
Richard Palm, on behalf of Mr. Pelham, who appears at a separate location via Zoom than counsel.
Mr. Pelham, can you hear us okay?
Yes, ma'am.
Thank you, Mr. Paul. Announcements?
Judge, after speaking, Mr. Pelham failed to appear back in April. That was his first time up. I've spoken with the county attorney, and based on Mr. Pelham's basic lack of record, he's going to allow him to apply for a diversion. I sent him the diversion paperwork this morning as soon as I got confirmation from Mr. Dean, and he is going to be filling that out and sending that in next week.
I'm not sure what you mean by first up, but he had a December 5th, 2023 first appearance that he failed to appear for. Bench warrant, 5,000 cash surety bond. March 12th, 2024, first appearance, applying for attorney, Richard Paul appointed. 4/12/24 status conference, failed to appear. Council's request for continuance denied. April 30th, 2024, he was back on the first appearance docket before Judge Ricky. Judge reinstated a $2,500 bond. That's not comporting with what I see on the first appearance. In any event, Mr. Paul is still appointed and we were set for today. So, Mr. Pelham, you've used up a lot of court time and you haven't gotten anywhere. So, what's he going to accomplish if I set this over again?
Judge is going to apply for diversion. Mr. Dean's going to accept it, and this case will be finished.
Call me skeptical.
That's your middle name, Judge.
Sometimes 30 days. Nah, might be my first name. Mr. Dean.
Yes, Your Honor. Everything I've seen would indicate, despite the lack of court appearances, would indicate that he is eligible for diversion. And because of the fact that, in all honesty, it is a benefit to the county and the sheriff's department for these cases to go diversion when they're eligible, even though we have this history, I'm still keeping that available to them, but it needs to be done by this next setting. So don't let grass grow under your feet on this one.
So we do this like the last one, he'll either be diverted or go to trial?
I think that's probably a good idea.
Okay. Missy, what was that date?
June 21st at 10.
That's gonna be for trial. June 21st at 10. Be diverted or go to trial or enter a plea of guilty or no contest. Any questions or comments, Mr. Paul, Mr. Dean?
No.
None by the state, Your Honor.
All right, Mr. Pelham, this is basically going to be the put up or shut up. You'll either really mean you're going for diversion or you'll go to trial.
Understood. Hey, Cedric, after you get out of court, call me, okay?
Yes, sir.
Thank you.
All right.
I have nothing further.
You are excused. Your client is excused. We'll be in recess on Pelham. We'll now be on the record in 2023 TR 3000082, State of Kansas versus David Deshawn Hughes. Please announce appearances.
All right.
That's 358 cash bond. All right, Mr. Shingle, I'm not sure how we overlooked you. We'll be on the record in 2024 TR 121. State of Kansas versus Michael James Shinkle. Paul E. Dean for the state, Mr. Shinkle appearing in person and pro se. Mr. Shinkle, you have the one count before the court of operating a motor vehicle without a valid license. We have been here once before on April 9th of 24 for your first appearance. You said you were going to hire an attorney and you were to be processed with a $1,000 OR bond. Did you get your bond and picture and prints done?
Yes, ma'am.
Okay, I don't see an attorney. Did you decide you didn't want to hire an attorney?
No, I do want to hire an attorney. I just had some unexpected expenses and I was kind of asking for a continuance, maybe a month, so I can get my finances back in order so I can get an attorney hired.
Okay, you can do that. Did you want to look into the diversion program where you
They
can
told me I wasn't eligible for
you
that.
weren't eligible? Okay.
Sir, have you looked into getting your license reinstated?
I have. Yes, I have.
Okay, I show that you've been eligible for reinstatement since December 21st, 2022. And I don't want you to make any statements because I don't want, obviously, if you say something here, it could be used against you in future proceedings. In any event, that's what I see on the certified driving record. So I'll just let you know, and again, I'm not asking you to make any factual statements about it, that if you get this if you get your driving privileges reinstated, I generally amend this to a no driver's license in possession. That's a fine of $100, 108 court costs. It looks like you're in a position where that could be done. But in any event, just letting you know that's out there. And the no DL and no driver's license in possession does not, it's not considered a major offense. So it does not cause any type of a suspension or restriction on driving privileges. So that's always an alternative as well. Usually one I recommend people take up.
I have been trying to get my license back.
Okay.
All right, well, Mr. Shinkle, I will grant a continuance for you to continue to try to obtain an attorney if you want, or to consider the proposal Mr. Dean would make. And that would also give you time for any other matters. If you thought you needed to apply for court appointed, it would give you time to even do that after court hearing today. So how much time do you want us to set this over? How many days?
Did he have a proposal for me?
Well, I think he said that if you, well, say it again, Mr. Dean, what you typically do.
Oh, if you can get your driving privileges reinstated, I will reduce the charge by it's what we call amending the charge from the current driving while suspended to no driver's license in possession, which does not, a conviction of that does not impact your driving privileges. In other words, driving while suspended, I believe, now the court doesn't do it, but if you get convicted of driving while suspended, the state is going to suspend you for at least an additional 90 days. On your driving record, I'm just going to show you what I see right for you. I'm not trying to show, I'm trying to not purposely show all your driving records to give any confidential information, but I see this is a eligible for reinstatement date right here. And it says you've been eligible clear back in 2022. So that's why I'm saying it would appear that perhaps you could get with the Department of Motor Vehicles, who is very, very slow to deal with. You've got to, in any event, if you want to get it reinstated, I would do that amendment. The court cost is 108. That's the court cost whether you get convicted as charged right now or based off the amendment. And the fine is $100 either way. But obviously, it would be far to your benefit to have your license reinstated and the fine and the charge reduced than to be convicted of that. But other than that, I can only offer you to plead guilty or no contest to as charged on the sole count. We 108 court costs, non-reporting probation, $100 fine, and court would give you 6 months on, or I would recommend to the court 6 months on reporting probation, I'd probably ask for a 30-day controlling sentence, suspended, which means that's a 30-day jail sentence, suspended for payment of costs and fines, no new law violations, etc. During the time period of your non-reporting probation. Or we can set it for a bench trial and do that.
I've just acted for another 30 days.
Okay, no problem. How about if we set that over to June, a little more than that, June
21st, maybe?
Yeah, we can do it the 21st. Would that be all right?
Be fine.
And what time, Missy?
And what's it gonna be for?
Well, is it gonna be for trial or?
Pre-trial, I'm assuming at this point in time, since he's wanting to
Trial,
consult with an
that's true.
attorney, I don't think we want to set it for trial yet.
Okay, status or control.
Let's do 9 o'clock on June 21st.
Okay, you will need to be back here 9 o'clock, June 21st with your attorney. I probably won't continue it again. I will continue the $1,000 bond that you posted with the added condition that you reappear June 21st at 10 a.m. and with attorney if you want an attorney.
At 10 a.m. or 9 a.m.?
9 a.m.
Whatever she said.
Yeah, we had it at 10 and then Missy,
Okay.
the judge's administrative assistant asked that we move it to 9.
All right, you may go, sir.
Thank you.
You're welcome. Missy, would you look at Pelham? He's going to apply for diversion, so we set it over to record in 2023 TR 300082, State of Kansas versus David Deshawn Hughes. Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paulie Dean.
William McClendon for the defendant, David Hughes, who appears via Zoom from the Green County Courthouse.
And how does he intend to proceed today on this one count of registration or tag?
Your Honor, for the sake of time, I'd ask for a continuance to have the opportunity to discuss with my client a potential plea deal from the prosecution and some other alternative resolutions to this case. This is my first appearance I've had with him, and due to some contact issues, I haven't been able to really discuss the case much with him.
How did you end up replacing Mr. Paul?
I don't know. I just take the cases when they come, Judge.
All right, so it wasn't where he went out and hired you?
No, Your Honor.
I think it seemed like there might have been some kind of a conflict that arose in this case. I don't remember, Judge.
Mr. Hughes, did you have a conflict with Mr. Parr, or do you know?
Yes, that's what it was.
Well, Mr. Hughes, your first. This ticket was issued November 14th of 2023. You were here December 12th of 23 and Mr. Paul was appointed. January 19th of 2024, you failed to appear. Mr. Paul asked for continuance and it was denied. January 3rd, March 1st of 2024, you failed to appear. Mr. Paul's request for continuance was denied. You were ordered to pay a $408 cash only bond. Did you do that?
Yes, I did.
April 2nd, 2024, you appeared. Mr. Paul was still your attorney and something happened where you were appointed a new attorney. This new attorney is asking for a continuance. You miss every other hearing. If you miss again, you lose $408 cash to the state of Kansas for your bond and won't even be.
I was only aware of one failure to appear.
Well, that's probably why you didn't appear the last time that you failed to appear. You've got 2. So I will grant this continuance since Mr. McClendon was appointed late in the proceedings, but you better be here because if your record maintains, you'll miss the next appearance, every other one. And I'll hold you without bond if that happens again. Mr. McClendon, how much time do you want to set? How many days?
We can use the June 6th or whatever
Either-
that Friday is.
I better show up, just be safe.
Was that you, Deputy Hanson? The better shut up to be safe?
Yes, ma'am, I'm sorry.
Are you here as a witness on this case?
Not on this one, on another one.
Okay, thank you, sir. All right, Mr. Dean, what do you think that?
And Your Honor, to clarify, I think it wasn't shut up to be safe. I think he was repeating my message that my assistant had gotten from me that he better show up just to be safe. I think we have the case resolved.
Not shut up. Okay. All right.
I
Okay.
wanted you to know Deputy Hanson wasn't telling us all to shut up this morning.
Okay, sounds good. All right, so June what? June 21st, will that work? Missy, what do you think?
I'd go the June 21st, make sure we've got enough time to get this done, because we'll probably do what we just did on the last one and set it for trial. At this
Okay.
point.
Missy, set this for trial, June 21st?
Yeah, let's do this at 11 then if it's going for trial.
All right, you must be back here, Mr. Schinkel, or Mr. Hughes, I'm sorry. Mr. Hughes, you must be back here June 21st at 11, ready to go to bench trial unless you're diverted. If you want diversion, I want you to be serious about it, get in there and get it done, or it will be denied, it sounds like, and you'll go to trial. Okay, clear?
Yes, ma'am.
Okay, and I will continue your bond with the added condition that you appear, and you do have that $408 cash bond. So I presume at some point, Mr. Dean, he might be able to use that on his case.
Hopefully we could just use it to pay his diversion. We could put this thing to bed.
But now he's one that had a 2,500 posted November 15th with AAA. I don't know, we probably set that aside so there's no judgment taken, but that's.
That sounds familiar, Your Honor. I'll look at the journal entries.
This doesn't say, oh yeah, it does, okay. All right, any questions, Mr. Hughes? I don't want you to be confused in all of this.
That was June 21st?
Yes, June 21st at 11. Now, again, if you're diverted, you won't have to be here. But unless the county attorney tells you you're diverted and you don't have to be here, better safe than sorry. Okay, if there's nothing further then, Mr. McClendon, your request for continuance is granted till June 21st at 11, and the defendant is continued on his cash bond. So the defendant is excused. Mr. McClendon, do you have anyone else on the docket?
I have an 11 o'clock. I'll just hang on for.
Well,
Your
maybe.
Honor,
You are, yes, and we are on YouTube. Okay. 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Now calling case number 23FB2421. This is the State of Michigan versus Kenneth O'Keefe Henry French. Appears for the record.
Thank you. Assistant Public Defender Sonia Chanot on behalf of Mr. French.
Thank you. And sir, state your name for the record, please.
Kenneth French.
Okay, thank you. So today is the date and time set for an arraignment in this matter. What I am seeing is an alleged probation violation. It appears. Okay, so it appears that on 5/9 you did violate the exclusion.
Every day in the USA, people find themselves in court.
You are, yes, and we are on YouTube.
Okay.
Okay. 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Now calling case number 23FB2421. This is the State of Michigan versus Kenneth O'Keefe Henry French. Appears for the record.
Thank you. Assistant Public Defender Sonia Chanel on behalf of Mr. French.
Thank you. And sir, state your name for the record, please.
Kenneth French.
Okay, thank you. So today is the date and time set for an arraignment in this matter. What I am seeing is an alleged probation violation. It appears. Okay, so it appears that on 5/9 you did violate the exclusion zone for your GPS tether, and it also appears that you were discharged from your anger management class. I'm seeing that there are a number of missed tests with community corrections as well. Okay, and at this time I'm not asking you to agree or disagree with anything. Okay, I'm just, this is what you are currently being arraigned on. So Attorney Chenault, do you wish to address bond?
Yes, thank you, Your Honor. We stand muted to the charges. And regarding bond, I was able to speak with my client today. He did provide me with good contact information. My client did express that he was currently receiving CMH services for therapy at this time, and that he's working on his mental health. He did tell me that he completed drug and alcohol treatment in February of this year at Home New Vision Treatment Center. He did express, Your Honor, that he is able to abide by all the bond conditions going forward. He will appear for subsequent court hearings and that he is taking this matter seriously. I do not believe he is a flight risk, neither a danger to the community. Therefore, we are asking for a personal bond at this time.
Also, I would like to state that. Thank you. The court does appreciate that. My understanding, Mr. French, is that you were in transitional housing in Livonia. It was Livonia.
Okay, I was in a recovery home for men in Brighton, Livingston County, and I chose that place myself from here to get away and extend my sobriety and my recovery. So I put myself in treatment. I also put myself in an extensive program to give me more time clean and work on self. I even did a vision board. I built a bonfire pit.
Okay, I'm cutting you off a little bit, okay, because you can go into more detail at your next hearing in front of the judge if you want to. But so at this point, when did you leave that transitional housing?
I just left 2 days ago. I just came back here, and my mom's birthday was on Monday. So because of the stipulations, I was unable to attend the party. I wasn't welcome because of this. But so I was trying to just have a friend give her some.
Okay. So again, I'm just, I don't want you to say anything that you don't have to say at this point. Are you going back to the transitional housing? Is your plan to go back to the transitional housing, or you have left there completely?
I've left there completely, but I have a job in Howell.
Okay.
Yeah, I found a job while I was there, but I'm back here because the tether, everything was never transferred to Livingston. I did everything by email through Livingston County, CMH, Community Corrections, all those things. I had that information transferred while I was there, throughout the time I was there, here to my probation officer, who is Miss Straub. It was originally Miss Johnson, now it's Miss Straub. Okay. But they get all this information. But I'm back here doing the same thing I dropped yesterday at Community Corrections here in Washington County. So I'm just back on board in this county. Yeah, okay. But I work in Livingston County, mind you.
Department might be 9.
Yeah.
Okay. Okay. And you're saying you just tested yesterday at Community Corrections?
I did, yeah, of course. I'm just doing my business, handling my business for myself, so I can be better for not only myself, but for others. Yeah, the answer is yes.
So, okay. Give me a moment.
Truth of the matter is, the only reason why I'm before you, because I was at least trying to give my mom some.
Mr. French, I'll advise you to not speak.
Okay. All right, thank you.
So at this time, the court is going to set you for a violation of probation hearing. That will be on June 6th,
Okay.
2024. That will be at 10 a.m. over Zoom before Judge Washington.
I thought that was May 30th with her.
No, it's going to be at 10 a.m. over Zoom. Do you have a device that you can use to access Zoom?
Is it Zoom or Dual?
Hmm?
Zoom or Dual? Dual?
Zoom.
Yeah. The answer is yes. I said Zoom or Dual. You actually did. No, I didn't know. One. Okay, Zoom. Okay. Okay.
Okay. So if for whatever reason you do not have a device that you can use to access Zoom, there is a tablet located in the lobby of the 14B district.
Okay.
Okay. You said you went to community corrections yesterday?
That is. Yeah.
What did you say that you did at community corrections?
I dropped full panel and I blow. I don't know what the question is.
That was the question.
Yeah, that's what I did.
You said you've got a job in Howell.
I do, yes. I start actually May 13th.
What hours do you work? Wait, when?
Well,
So wait, you haven't started it yet?
so here's the thing. For the first 2 weeks, I should have started Monday, but
Yeah, okay, yeah, yes or no? Have you started working in Howell yet?
I start May 13th.
You start May 13th. Okay. So that is Monday.
Yeah.
Okay. What? And your hours are what?
So for the first 2 weeks of training, it's 6 a.m. to 2:30. And after that, it'll be 3 o'clock to 11.
3 p.m. to 11 p.m. Okay.
Right, yeah.
Okay.
But for the first 2 weeks, it'll be 6 a.m. to 2:30.
I was actually there to get my mail. And I said,
So the court is going to set bond with the following conditions. So at least until your next hearing, which again is June 6th, you are to report to community corrections for daily testing.
For what?
Daily testing.
Hey, somebody's next door, ma'am. That's why I can't hear you. That's fine.
Ms. Chenault, did you hear me?
Yes.
Do you have to pay for that?
Yes.
The daily testing?
You will need $12 and a photo ID. And you are to report to community corrections within 24 hours of your release. Your tether is obviously staying on, and let me be abundantly clear. You have an exclusion zone, sir.
What is the proximity?
And okay. And that you'll have to talk to your public defender because I don't have that readily available in front of me right now. So that's information that we should be able to get for you. I don't have it in front of me right this second, but that's also probably something that you can ask community corrections is how far, like what the exclusion zone exactly is. But you know that you are not to go to your sister's address or
That wasn't at my sister's address. It was my mom.
and your parents' address. Okay. Okay. You are not to go. When the court tells you not to go someplace, that means you don't go. Even if you're personally invited, even if you're trying to do something very nice, like drop off flowers for your mother's birthday, you don't go in.
Never went to that.
Sir, if you cut me off one more time. Okay. So don't go into the exclusion zone. That's what that means. Okay. Do you understand that?
Yeah.
Thank you. Now, at this time, the court will set a $5,000 personal recognizance bond. Ms. Chenault, if you want to explain that.
Yes, Mr. French, a personal bond just means you'll be released without having to pay today. However, if you should violate any of your bond conditions or you fail to appear for subsequent hearings, that $5,000 will attach at that time to get released.
Yeah, I'm just thinking about the everyday drug testing, $12. That seems like a stipulation.
I understand.
So once again, your next court date is June 6th. That will be at
I'm gonna
10
get paid for
a.m.
it.
Mr. French, you have to stop cutting the magistrate off, please.
This hearing.
Every day in the USA, people find themselves in court.
We have Mr. Gerald Lovelace is here for motion for new trial. Is that correct? Filling the docs, there's a motion to continue that.
I think that was an old motion. I think we're ready to.
All right, we'll come back to it later.
I don't know, really. And it's on YouTube too, right? It's YouTube operating?
Yeah, it's supposed to be YouTube. I don't know if it's, is the sound working on YouTube right now?
Clerk and, you know, he's watching. He said it's working.
And I'm recording it myself.
So we have.
You're recording it and I'm recording it. Okay.
All right, well, we verified that there is sound.
All right.
All right, State versus Gerald Lovelace, we have a motion for new trial.
Yes, Your Honor.
Let's bring out Mr. Lovelace. I believe he's here. And this is the amended motion for new trial, correct?
Yes, sir.
All right, go ahead.
Thank you, Judge. General, as you know, I was not the trial attorney in this matter. I was appointed to draft and file a motion for new trial following Mr. Stevens leaving the defense bar. In this case, there are several issues we are asking the court to look at. The primary and first issue is the court order which denied the pretrial motions to suppress statements of Mr. Lovelace. As you know, this was litigated in a motion to suppress whether or not Mr. Lovelace unequivocally and unambiguously invoked his right to counsel in this interview. There were two separate interviews, one occurring on March 27, one occurring on March 28. there was an invocation made multiple times. Most importantly, the invocation for counsel was made after he was given his Miranda rights and at that point knew he was entitled to an attorney. Looking, we have drafted a fairly lengthy argument and fact recitation about this issue. As you know, the court, state and federal courts have looked at this issue a number of times as to whether or not the invocation can be made by saying, can I have an attorney? Should I have an attorney? We argue that Mr. Lovelace most certainly invoked when he said, following his Miranda rights waiver, can I have an attorney? We believe at that point he knew he was entitled to an attorney. He was no longer asking questions ambiguously about whether or not he was entitled to one, but was in that part actually invoking his right and commanding the detectives to bring forth an attorney who could assist him with making a decision about whether or not making statements was in his best interest. The court did overrule that motion to suppress, and those statements were heard at trial. We believe this was an error and would ask the court to reconsider the court's ruling on that and grant a new trial, specifically as it refers to that ground. The next ground I would ask the court to look at is whether or not there was sufficient information when the affidavit of complaint was signed by the clerk or judicial commissioner. As you know, in this case, the investigation occurred from approximately June of 2016 through late March 2017. The affidavit of complaint is ambiguous in that it states that in approximately on approximately March 10, 2017, Mr. Perry, who was tried separately, advised detectives that he had in fact driven Mr. Lovelace and another co-defendant into the area on the night the murder was alleged to have occurred. Following that information, there is no additional information identified as to why Mr. Lovelace was picked up and questioned. The affidavit of complaint was signed on March 28, 2017. At the trial in this matter, between March 10 and March 28, there was no additional information that came into Detective Atkins' hands that he recited to this court. He indicates in the affidavit, witnesses stated that Mr. Perry, Mr. Lovelace, and Mr. Powell intended to rob him. Witnesses further stated Powell was the one who shot Cooksey. There's no identification of the witnesses that were investigated between March 10 and March 28. And so we do not believe there was sufficient information for this affidavit to have been brought by Detective Atkins or signed by the clerk as being sufficient probable cause. Additionally, there was a pretrial ruling allowing the testimony regarding prior drug purchases of Mr. Lovelace to be heard by the jury. We believe that this evidence should have been suppressed. We believe this was not relevant evidence, but instead prejudiced the jury by hearing that Mr. Lovelace had prior drug activity. While there's an allegation of robbery in this murder, the drug activity previously shown would not have helped the jury in making a decision regarding this robbery and or this murder. We would state that that bad act information sufficiently prejudiced the jury to overrule the other sufficiency of evidence grounds that they would have had when making their final decision. Additionally, we're asking the court to grant a new trial as the court erred in allowing testimony of Amy Haskins as it related to habits and prior bad acts of defendant Lovelace, which would be similar to the last argument that this information was prejudicial and was not helpful to the jury in making a decision. Final grounds we've set forth are that the jury verdict is against the weight of the evidence, and we're asking the court to exercise its right as a 13th juror to decide that they did not have sufficient evidence to find him guilty of murder, and their verdict was likely influenced by passion and prejudice as a result of the prior bad act information that came in through witnesses and through the officers who testified in this case. Again, Judge, looking at the suppression issue, there is abundant state and federal law wherein defendants have made statements almost identical to that made by Mr. Lovelace. We've set forth those cases in our brief. We would point one additional case for the court to review, which is U.S. v. Joseph Zakari, Z-A-K-H-A-R-I. That case was decided on October 23rd, 2023, and we believe it would be helpful to the court as well. Thank you, Judge.
As far as issue number one, dealing with the suppression of the statements or the motion to suppress the statements, as the court knows, because there is an abundant amount of law on this, a statement to request an attorney must be an unequivocal statement. And there, in the motion to suppress, I cited a case that went through a number of statements that were equivocal and a number of statements that were unequivocal. The statement that Mr. Lovelace made was an equivocal statement. In this case, Mr. Lovelace said, "Can I just have a lawyer with me that can help that way, that can help me out on maybe what the expletive I need to be doing?" And if you note in the defendant's brief, as well as in the record, that is ended with a question mark. It's ended with a question mark because that is a question. Can I just have a lawyer with me? And Agent Adkins, in response right after that, said, "I mean, that's up to you. The only thing I need is the dang truth, Joe." It ends with a question mark because it's a question that means it's an equivocal statement. It doesn't say, "I want a lawyer, I need a lawyer, give me a lawyer." Statements that have been held to be equivocal: "I think I need to talk to a lawyer." "Do you think I need to talk to a lawyer?" "I guess I need a lawyer, don't I?" "Don't I need to talk to a lawyer?" Statements that have been held to be unequivocal: "I want an attorney before making a deal. I want to call a judge and a federal public defender. I'd be willing to cooperate. I'd like to have a lawyer at this point. I'd like to have a lawyer before I discuss that." This was not an unequivocal statement. It was a question. Agent Adkins answered that question and said, "That's up to you." And this is after reading Miranda. He had read him Miranda before. And as it goes to voluntariness, we look at the totality of the circumstances. And as the court knows, there's a variety of factors that the court looks to in going through that. In this case, I believe at the time of the questioning, Mr. Lovelace was 38 years old. He said that he had run a business or ran a business at the time. He had repeated involvement with the police. This is not the first time he had been in this situation. He was read his Miranda rights. He was given bathroom breaks, water breaks, and there were no threats or really even raised voices. The tone of the interview was fairly calm. So we would assert that Your Honor made the correct ruling in allowing his statements in. And issue number two, that his rights were violated with the search and seizure. Your Honor, I don't recall there being a motion to suppress filed on this, and maybe I'm incorrect because this was a number of years ago at this point. If there was not a motion to suppress on this, I think the issue would be waived. But at any rate, we will address it. The defendant asserts that there was no corroborating evidence to what Mr. Perry said. Well, there was plenty of corroborating evidence. There was a video of a white truck being driven by Mr. Perry that went to an apartment complex that was very close to the trailer in which Mr. Cooksey was shot and killed. Two men dressed in dark clothes we see come up to the truck. We see them get under the hood of the truck, in the truck, and leave. Or I think they get in the truck and then go under the hood of the truck, and then they leave together. That all corroborates what Mr. Perry said. Furthermore, we have Mr. Cooksey is dead. That corroborates what Mr. Perry said. So there was plenty of, and at this point, we're just looking for probable cause. Was there probable cause to issue the search warrant? And we would submit that all of that says certainly there was probable cause. Issue number three, the court erred allowing the prior purchase of drugs by the defendant. And Your Honor, this was not used for propensity evidence. It was not introduced for propensity evidence. It was introduced to prove that these two people had known each other before, which kind of goes back to issue number two, the corroboration, because Mr. Lovelace knew the defendant, or at least knew of him. I think the statement was that he had bought drugs from him in the past. The court gave a limiting instruction to the jury when this happened, and we would submit that as more than sufficient to cure any harm that could possibly have been done. Issue number four, the prior bad acts of Mr. Lovelace. Your Honor, this was not in that the reference by Ms. Hankins that he was suited and booted and kept a firearm under the hood of the truck. This is corroborated by the video. They go under the hood of the truck. Both of the men that were that walked up to the truck were wearing dark clothing. And that's what Miss Hankins said. She saw them before leaving to go do this. She described the kind of clothes they were wearing, that it matched this. It was certainly supported by the evidence and was appropriate evidence for the court to let to the jury as a habit that Mr. Lovelace would put a gun under the hood of the truck. And then issue number 5, we would certainly submit the evidence was more than sufficient to sustain a conviction.
I'm going to need to take it under advisement in order to review the case law that you cited. So I'll be glad to hear anything else you want to add to it. If you want to respond.
Just briefly, Your Honor, I would like the court again to focus on, and I understand Mr. Turnbow's argument that this may have not been filed in a pretrial motion, but I do think the issue of the affidavit of complaint was raised during the trial.
The grand jury's action traditionally cure any defects in the affidavit of complaint for the lower court. If the grand jury is an independent body, they're returning of an indictment. I've always understood, at least the law is, that if there's a problem in the indictment, once the grand jury returns its actions, it's independent of the affidavit itself, and therefore the grand jury's indictment would cure any problems that would have occurred at the lower level.
It could, Your Honor. My concern with this one is whether or not the subsequent arrest and statements made by Mr. Lovelace would have ever been made if that affidavit were signed. We know that Mr. Perry didn't make any incriminating statements during his March 10 interview. During that time, he simply said, I drove these 2 gentlemen to the area. He didn't admit anyone had died or he had done anything or anyone was robbing anybody. And I think testimony was elicited from, could have been Amy and or Tiffany, testified that they overheard a conversation Mr. Perry had. So it wasn't even a direct conversation they had with one of the co-defendants. So I think at that point, had that affidavit not been signed, creating additional investigation, we would have never been presented to the grand jury. So I think I'm asking the court to go all the way back to that point. And again, to review the suppression issues.
As I indicated, you need to review the authorities that you signed, especially that newer case that you cited. And I'll review that and give you a ruling as quickly as I can. All right, I need Mr. Lovelace to step back out so that we can take up the next matter. So. Mark, you have something? Do raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm the testimony you give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You filed a motion to waive or reduce your fines and court costs in this court. You've been paying in general sessions. I understand that. You're almost through with paying that out, but you have alleged that you're unable to pay your fines and costs in this case. Why is that the case?
Your Honor, I have 5 children. I'm a single income family. I have 3 kids that play ball. Yeah, pretty much year round. My work is about an hour and 15 minutes away. I'm tapped every week. My check comes in and it goes as soon as I get it.
For Turnbow, do you have any position on this?
I don't, Judge. I don't know anything about the history.
All right. My policy has always been that somebody's making a good faith effort to make their payments on their fines and costs, and they still need some help. I'm going to give them the consideration that they tell me you've been making regular payments and almost have paid your general sessions case off. So as a result, I'm going to remit your fines in this court with the exception of, and the cost with the exception of the litigation costs. I'm not remitting the probation fees. You'll still have to pay that as long as you're on probation, but your actual fines and court costs of this court, I'll remit those.
Thank you, Your Honor.
Good luck to anybody that's got 5 kids is getting punished pretty good anyway. So
Thank you.
I grew up in a family with 5 children, so I can say that. So. 2024 CR 26, Derek Edens. In touch with you, and then if we can't get it resolved, then we'll give you a new date. All right, thank you. Dorothy Martin. Martin, you're here to be arraigned on 1 count of voluntary manslaughter. You have the right to an attorney. Do you look to have a lawyer representative? Public defender have a conflict with this?
Yes, Your Honor. I believe, yes, sir.
And the conflict is involving the co-defendant.
Jason Weaver. Heather.
Have you already been appointed on Jason Weaver?
Yes, Your Honor. And I know we represent special.
Well, I'm going to appoint Mr. Chris Clark to represent this defendant. Ms. Martin, we're appointing a lawyer to represent you. He's not here in the courtroom yet. And that means that he will be here. I'm going to provide him with a copy of this indictment. And we'll go ahead and ask that Mr. Clemens, as the public defenders, will stand in for purposes of arraignment. And that's really all we're doing today, is just to show that you've been formally advised of the charge.
Your Honor, on behalf of the defendant, acknowledge receive a copy of the indictment, waive the reading, enter plea of not guilty.
Plea of not guilty is entered. We're setting a trial date on the general.
Yes, Your Honor, September 17th.
September the 17th for trial, September the 16th for the last day in the 2022 CR 74A State versus Xavier Osborne, Mr. Finley.
Yes, sir. Mr. Osborne, present in court. He was in another accident, Judge. I swear if he didn't have bad luck, he'd have no luck, but he was very severely injured and he's wheelchair bound right now. Your Honor might recall, we entered a settlement, but we were going to sentence him today. I've asked that we push that to your next term. Just, he's in real critical shape right now, and he'll need some surgeries that are scheduled to come up.
Judge, the proposed settlement we have has him spending some time in jail, and I'm sure the jail does not want him in a wheelchair.
So with him spending time in jail and in his physical condition right now, is the jail suited to be able to provide the care he needs?
I don't believe so.
All right, we'll put it for the, we'll put it on the VOP day in November.
Your Honor, I talked with Mr. Finley about his injuries, and I think he's going to be in a wheelchair for some time.
I think that's true, but we could check it on in November.
Well, let's set it for the November 12th. That's the real, I mean, that's the docket call, right? November 12th, just to check on the status.
Yes, sir.
Thank you, Judge.
Thank you.
I do have a Wisner that was set for arraignment, but I fax filed a waiver.
Moving to page 11, 2020 CR 18B, David Farr.
Your Honor, I'm sure Your Honor recalls, we had a sentencing hearing with Mr. Parr. Your Honor sentenced him to 15 years to serve. Mr. Parr filed an appeal from that. I think made parole in the meantime.
Yes, sir.
Mr. DeWerff represented him at that. the Court of Appeals, basically, because there was a superseding indictment done after Judge Wallace had originally took the plea and then recused himself. I don't really fully understand the Court of Appeals opinion, but I don't know if Your Honor wants to appoint Mr. Parr an attorney so we can kind of all figure out where we're at, or.
Well, what the Court of Criminal Appeals said is that because Judge Wallace actually accepted a plea originally and then I think recused himself afterwards, that plea was res judicata as to whatever it was that I did in this case. So he was actually bound by the original judgment that Judge Wallace entered.
Yes, in the last paragraph of the opinion, they said there's case number, I believe it was 20 CR 49 is still active and 20 CR 18 is dismissed. So, I mean, I'm not looking for more jail time out of Mr. Parker or anything like that, but I don't know how to move forward without Mr. Parker having an attorney.
Are you working, Mr. Parr?
Yes,
Now that you're,
I was Gregory Smith was the one appointed to me.
who?
Gregory Smith out of Clarksville, and he kind of knows all that. And like I said, Mr. Dorff passed away. And if I could get Gregory Smith still on it because he knows the stuff. I'm new at all this. I just, like I said, I'm on parole, been up about a year. I've got knocked down to reporting only every 3 months. Got a full-time job.
Greg Smith on our list.
He has been.
We'll appoint Greg Smith to represent him. See if we can at least come to some sort of understanding based on what happened. So,
Yes, sir.
all right. Contact Mr. Smith and tell him he's been appointed to represent you, and we'll go from there.
Okay, will he let me know a court date or?
Let's go ahead and set it. Judge Wallace has recused himself, so probably does need to come back in front of me. I guess we'll just set it in November.
The doctor called date.
Just, and I don't recall the specifics of everything that was said, but it does strike me that what they were saying was whatever Judge Wallace did in the original case is res judicata as to anything I had done because of that, and therefore we're really just looking to see what, if anything, still has to be done about the case of Judge Wallace. So.
And that's, from what I understood, Judge, basically that plea is still there, although Judge Wallace can't hear it. So I don't know how you move forward from that. That was the part that really confused me from their opinion. So. Mr. Smith wrote the appeal though, so I'm sure he probably is more knowledgeable about it than I am.
All right, well, I'm just thinking about timing to set a date for it so it doesn't. I mean, he's basically been paroled, so there's no question about him having, he's not going to be picked up and taken back in. There's no warrant out there or anything for him. Right?
No.
All right, just put him on that November 12th date. And we'll hopefully get that completely resolved by that time. All right, thank you. 2022 CR 119, State versus Quande Maurice Portis.
Your Honor, I believe Ms. Phillips has a plea on Mr. Hutchinson.
All right.
She has no report.
What name?
Joseph Hutchison.
Okay.
I may pass forward the. Mr. Hutchison.
All right, I've been handed a document indicating Mr. Hutchins is going to enter a plea of no contest to animal cruelty. A Class E felony counts 2 and 3 will be dismissed. He will receive a sentence of 2 years suspended supervised probation after serving 30 days. May be served on consecutive weekends. This is going to be entered pursuant to 40-35-313. The post-trial diversion, he will order to pay restitution of $9,387.54. To Segley's Biker Bully Farm, payable at $50 a month. Surrender any companion animals, and you will have a lifelong prohibition from having companion animals pursuant to 3914-212E. Mr. Hutchison, raise your right hand, place you under oath.
Do you solemnly swear or affirm the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
State your full name for the record.
Joseph Hutchinson.
Mr. Hutchinson, speak up so we make sure we can record everything that's being said. You're here today charged with a 3-count indictment of animal cruelty, but have you seen or been shown a copy of those charges, gone over with Ms. Phillips, those documents, and discussed with her the range of punishments you're facing, as well as any possible defenses you might have to the charge?
Yes.
Plus indicated you want to enter a plea of no contest or nolo contendere. That simply means you understand what the facts are. You're not going to admit you did anything, but you're not going to deny it. And as a result, the state will tell me what their evidence would be if this case went to trial, and I'm going to use those facts to find you guilty according to this agreement. Now, you're also entering this under 4035-313. Ms. Phillips is a good lawyer. I know she's explained this to you, but that means that you're going to be on probation for this period of time, 2 years. And at the end of that time, if you have successfully completed everything you're supposed to do, complied with all the terms of probation and not violated the law in any regard, then you can apply to have this removed from your record because of the fact that you are a first offender. You understand that?
Yes.
However, if you violate the terms of this agreement and you brought before the court, this will become a permanent conviction and will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. And the law allows that you could be resentenced within the range for this particular offense if you were to violate your probation. You understand that? All depends on what you do from here on out. You understand that? All right. You understand that you have a right to plead not guilty and have a speedy and public trial by jury. You understand that trial, you have the right to have a lawyer and to have one appointed if necessary.
Yes.
You understand if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted.
Yes.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state might call to testify, and you could bring in your own witnesses by the use of a subpoena. Do you understand that if you went to trial, you'd be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal, and all I'm going to do is approve what your lawyer reports out.
Yes.
As I explained to you, you're going to be on probation for a period of 2 years. At the end of that time, if you're successful, you can apply to have your record expunged. If you're unsuccessful, then this will become permanent on your record and will be there in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. Do you understand everything I'm explaining? When you wish to plead no contest according to this agreement, give up your right to a trial.
Yes.
Is your decision to plead no contest today voluntary?
No.
It is voluntary?
No.
No. All right.
Sorry.
Let's just say this. Anybody forcing you to do this against your will?
No.
And that's what voluntary means. So you are doing this voluntarily?
Yes.
All right. Gets a little confusing.
No.
Okay. I think I went over it with the judge and asked him if anybody's coerced him or forced him, so. Okay.
All right. You understand that I can't accept your plea unless I'm satisfied there are facts that support it and that you are in fact guilty.
Yes.
And I want you to listen as the state tells me what their evidence would be if this case went for trial.
Your Honor, on November the 20th of 2022, Stewart County deputies were dispatched to Mr. Hutchinson's residence for 2 dogs that have been left outside for no food and water. The dogs are actually confirmed by Dr. Rita, veterinarian here in Stewart County, to be neglected. They don't have the body weight, half the body weight it should be. It was also very cold that day. Mr. Hutchinson was advised. He also had cats on the property. They needed to be taken inside during the temperatures. They were not, and one of them died that night when Stewart County deputies went back up.
All right, Mr. Hutchinson, I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if you went to trial.
Yes.
You understand everything I've explained to you?
Yes.
Are you satisfied with your attorney services?
Yes.
Feel like Ms. Phillips has done a good job of representing you competently.
Yes.
Ms. Phillips, you don't have any reason we should not enter this plea.
No, Your Honor.
Anything further from the state?
Judge, the only thing, I've not had one of these cases with the prohibition against owning companion animals before. And just so we're all on the same page, my understanding of how that would work is if Mr. Hutchinson's found to have a companion animal, it would be, the burden would be on the state to file a contempt petition in front of Your Honor due to it being your order.
Well, what that means is that because of the fact that these animals were not properly cared for, the state's as a condition of your probation, is saying you cannot own a companion animal, you can't have a pet, dog or any other kind of animal. And what that means is that when your 2-year period is up, even if this gets expunged from your record, this court's opinion is that would still continue to be a lifelong prohibition. And that means that you could be brought back to the court for contempt of court if you were found to have an animal in your possession. So you can't take care of them, you can't own them. That's what it amounts to. You understand that?
Yes.
Your Honor, the only other thing, I think the state has agreed for him to begin his weekends on June 7th at 6 p.m.
All right. Then Mr. Hutchinson, Joseph Hutchinson, on docket number 2023 CR 68, upon your plea of no contest to count 1, counts 2 and 3 are dismissed. Court finds you guilty, sentences you to, court sentences you to 2 years suspended sentence. And that will be under supervised probation after serving 30 days in jail. You began serving that June 7th at what time?
6 p.m.
6 p.m. You can serve that on consecutive weekends. This will be under 4035-313. Restitution is $9,387.54. That will be paid to Segley's Biker Bully Farm. And that could be paid at $50 a month. He will surrender any companion animals, and he will have a lifelong prohibition from having any companion animal pursuant to 3914-212E. To the probation department.
Thank you, Your Honor. Your Honor, I have Erastus Mummery. I had a motion to continue because I had a jury trial. That jury trial's come on.
All right, we'll go ahead and overrule his motion. Maybe we can check that out.
Trust me, there are times when I'm inclined to make snap judgments like that, but usually I get called on the carpet if I do that. So. I need the Lewis Clary file. And then I also need the Gerald Lovelace file. All right, we're ready on Lewis, Dillon, Clary on the motions.
Yes. Mr. Clary is here. Can I have him?
Yes. Well, we had 3 motions, essentially. 2 of them are motions by the state and motions in limine. So we'll take those matters up first, and then we'll deal with the other motion that the county executive has signed.
Judge, I'll start with state's motion limiting number 1. And basically what we're asking for here, this case was presented to the grand jury by the state the first time, and then it went 2 more times after a no true bill at the victim's request, writing the foreman and asking to go. And the case was, a true bill was presented when it went the 3rd time. My understanding after speaking with Mr. Cox is that his intent is to introduce that at trial. And we filed this motion to basically exclude that from being considered by the jury. I've cited a case in my motion. It is an unrecorded case, Judge. But on the 4th page of that case, in what is section 3, the 3rd paragraph of that, in this case, the state elicited testimony from a victim that she had presented to grand jury, in essence trying to bolster that she had told a consistent story. The defense, after that question was asked, sought to elicit that there was a no true bill returned by the first grand jury. The court sustained an objection in this case to that question, did not allow it to be asked, and the defendant appealed, and the Court of Criminal Appeals judged this on an abuse of discretion standard. They found that the court did not abuse their discretion by keeping out that question. But Judge, what I would like to point the court to is 1 paragraph down for that, the court's reasoning for that. And it says it's well established in Tennessee that the grand jury's findings are irrelevant to the trial on the merits. The fact that a grand jury does not return a true bill shall not be taken as an indication that the accused is innocent. And the grand jury's indictment is pure hearsay and only an accusation formed by a group of men and women considering ex parte evidence. In the next paragraph, as it is well established in Tennessee that a grand jury's findings are irrelevant to the trial on the merits, we decline to find the court abused its discretion. And Judge, if the finding cannot be taken to show the innocence of the defendant, if it can't be presented for that purpose, then there is no other purpose. It's irrelevant and shouldn't be presented. Under 401, the question would not be relevant. And would Your Honor like me to go ahead and argue number 2, or do we want to take them one at a time?
Let's take them up one at a time.
Yes, sir.
Just gotta stand here, you become the lecturer. Now, I don't disagree with anything that the general said about State versus Reed, other than, but it is unreported, it's persuasive, it's not controlling. This case was not, there was no one arrested in this case. It was taken to the grand jury in 21 in Stewart County. I may be wrong, maybe in 22. It was a no true bill found there. It was taken, and then the second time, I believe that the alleged victim in this case with private counsel. I do believe the state was there, but private counsel is the one that introduced it the second time. Another true bill was found. Then the third time, private attorney took to the grand jury on behalf of the alleged victim, and a true bill was found. Now, I think there's the testimony, there's in discovery, there are statements made by the alleged defendant or the defendant's wife of some statements that, or some things that she had told the alleged victim in this case, told her husband, which caused friction between their marriage. There's also in interviews with Detective Saltkill, where the alleged victim talks about things that she said to the defendant's wife about, where's your husband at? Oh, he was at my house all night. Not the night that this alleged happened, but prior to, because she talks about Dylan always just out riding around and doing things. So I think it would be allowable to show prejudice, bias, and motive. And
so are you referring to the fact that there are two issues? One of them is just the mere fact that the grand jury did not indict on 2 prior occasions when they considered it. There was no true bill, there was no true bill. That's one fact. The second fact is what it seems to me you're arguing is that testimony that was presented to that grand jury should be admissible. And that's typically absolutely not the rule. That's what we charge a grand jury is that they're never going to have to, that testimony before them is not usually something that is brought into court unless there's a specific reason for it. So I'm trying to determine whether or not you're actually referring to the mere fact that the grand jury didn't charge, or whether or not you're referring to.
I'm asking that those no true bills be entered to show that twice, or actually 3 times, but 3 separate groups. 1, the law enforcement, and 2, by 2 separate grand juries doing their own investigation, found there was not probable cause to bind us over. I get it's not the all end all. This jury here.
So by that argument, any time then I should charge a jury that the fact that there is a grand jury that has returned a true bill should be considered by them as evidence of the guilt of the defendant, correct?
No, sir, but I think if you take in the totality and if we can show her bias and motive to continue with this prosecution based upon problems these people have had as a group, a couple, friends, then it shows why this has continued to go on after 3 different organizations or 3 different investigative bodies have found nothing happened here, or there wasn't a crime committed. And in State versus Flynn, Your Honor, that they did.
A copy of that case is unreported, right?
Did I not send that to the court?
I have not. There's nothing in the file indicating that there's either of those.
No, I don't.
Either of the cases that you cited, which are both unreported, that I don't have a copy of either one of those.
That's my fault. I thought we'd sent all of that Judge, let me just say this. If the court rules that that can't come in, and I love the part it says here that Mr. Turnbow stated under State versus Unitas. The fact the grand jury does not return a true bill should not be taken as indication that the accused is innocent. The grand jury's indictment is pure hearsay and only an accusation formed by a group of women considering ex parte evidence. But I will submit this, that this court is going to read to this jury. In the Circuit Court for Stewart County, Tennessee at Dover, July term, grand jury 2023, the grand juries of Stewart County duly impaneled and sworn upon their oaths do present that on or about September 11th, 2021 in Stewart County, Tennessee, and prior to the finding of this indictment, Lewis Dillon Clary then and there unlawfully and feloniously sexually perpetrated Tabitha Mounts, and the Lewis Dillon Clary knew or had reason to know at the time of the penetration that the Tabitha Mounts did not consent to the sexual penetration in violation of TCA 3913-503, a Class B felony and against the peace and dignity of the state. Now, we all know that there be instructions, they're not to take this as evidence that a crime was committed. But we also all know that once you say the grand jury of this state, of this county, says that he did do it, you can't take that out of their minds. Therefore, I'm asking this court to do something maybe no other court's done. Allow those no true bills in. The grand jury is the biggest one-sided affair that we have in our legal system. I'm not invited to the grand jury. My client's not invited to the grand jury. Heck, the state wasn't even invited to the grand jury on 2 of these. They go in. We've all heard you can indict a ham sandwich.
I'm gonna let you stay on this. You do know that I know all of this.
Yes, sir, I do, but I just need to say it.
Make the record.
And so we all heard we can indict a ham sandwich, and that's what happens in the grand jury. It's secretive. I have no idea what was told. Maybe if our side of the story got to go, there wouldn't have been an indictment on the 3rd chance. Judge, you can do something here today. Yeah, it'll probably keep going up. We got to change the way the grand jury system works. And if we get 2 different grand juries that investigate and they say there's not a crime being committed, and I get it, they can go to as many grand juries as they want. But how is that fair to the ledger, or the defendant in this case, to have a fair and impartial jury and have a fair trial? So with that said, I renew my request to have the no true bills entered, and if the court rules against me, I would like to expand on for Dyer for that specific topic.
In what way?
If the court rules against me, I think I've done this in the past and I've been allowed. I want to make sure I'm allowed here. I think this jury needs to understand what the difference is between a grand jury and a jury. Not by me saying, hey, they went to the grand jury and no true bills were done. But I think they at least need to know that, one, this is hearsay according to the case law. How the grand juries get their information, that we're not invited to participate in that party. And that even if someone, that you could go back to the grand jury multiple times, even when they're not indicted 1, 2, 3, 4, 5 times. I don't think that would be outside the realm of board hiring questions to make sure they understand the difference. Because truly, when that charging instrument's read with a grand jury, because that makes it sound like this some great panel of people. They're probably nice people, but they're getting one side of the story. But when you say the grand jury, most people don't come into court and have any idea what we're doing in here. And so by reading that indictment that says that he did commit that offense on that certain date, that automatically, regardless of what everybody believes, that automatically puts the burden on the defendant. And I would just ask to be able to travel down that road in Verdire to make sure we understand those differences.
Mr. Turnbull?
Just briefly, as far, just to clear up kind of the procedural history of the case, Mr. Cox and I have talked about it, and it's a little confusing. And to be perfectly honest, I don't remember everything about it because it's been over a couple of years. But I believe the first time it went to grand jury, it was presented by the state and with the victim there at her. And then the second time, the victim had wrote the grand jury foreman, as is the procedure to present it. And it was presented again with, the state was present when she was presenting to the grand jury. And then that was no treatment as well. The third time, the victim as well as private counsel petitioned to take it to the grand jury. It was allowed under the rules to do this. And then I went in with the private counsel and the victim during the presentation to make sure everything was as it should be. Of course, no one was present during deliberations, as it's not allowed. However, with that clearing up of the history, as far as Mr. Cox's argument about this showing bias, there are far better ways and far less, there's far other means to show bias. I mean, he could call the defendant's wife. The victim is going to be testifying. He could call the defendant if he so chose to try to show this bias. I think there's too big of a leap between you don't like this person, therefore you took it back to the grand jury again, because the same leap could be made by the state. Well, no, there was a rape that occurred, therefore she took it to the grand jury because she's upset. So I don't think it comes in as relevant under that theory either, Your Honor. And as is the case that I read to Your Honor, it's simply not relevant for any purpose.
I understand what Mr. Cox is arguing because of the simple fact that for 37 years, I stood in his shoes and felt it was every defendant that I represented had been indicted by a grand jury. I wanted to be able to say the same thing. They only heard one side of the case. I instruct the jury in every jury trial that the indictment of the grand jury is simply the indictment or presentment is nothing more than a piece of paper it's a formal charge, and it does not represent, it's not evidence of anything. I say that in the charge. It is, in my opinion, not. The other thing that I do is I charge the grand jury, and I charge the grand jury to let them know that their proceedings are completely confidential. It's part of our history, our foundation of our whole system is that we don't get to second guess what a grand jury does. The jury, who is a jury trial, and during a jury trial, is the ultimate determining factor of guilt or innocence. The grand jury is simply an indictment. I can tell you, my predecessor in this job, Judge Robert Birch, made the mistake one day of telling me about something he had done when I was still practicing as an attorney. That was to demonstrate that indictment meant nothing. He took his indictment in his opening statement to the jury. He had a photocopy of the indictment. And he said, "Ladies and gentlemen, this indictment means nothing." And he tore that indictment in half. Of course, he didn't pull, he went over and got the court file and pretended to take the indictment out and tore it up. And needless to say, the district attorney was not a happy camper until he found out it was just a photocopy. So that was his way of demonstrating what you're arguing, that an indictment is nothing more than a piece of paper that charges someone. He made a mistake of telling me that, and so one of the first cases I had that I tried after that, the same thing, and he threatened to hold me in contempt of court. So. But there are ways that you can deal with this situation without the introduction of the grand jury's actions on the 2 no true bills. I am of the opinion that absent some compelling case law to the contrary, and I don't have copies of those, but this case is set for the 28th. You demonstrate to me that there's some more current case than the case I read through the Reed case that General Turnbow had supplied attached to his motion. And it does clearly state that the actions of the true bill are not admissible. And therefore I'm going to rule in favor of the state's motion, subject to you demonstrating with more current case law that there's something that would change my mind. But I will allow you to board out of the jury during the jury selection to make sure that they understand that a grand jury's actions are not evidence of anything, that they are simply a formal accusation. And you can even refer to the fact that the judge is going to charge you, that the indictment is not evidence of anything. It's just a formal charge. That is permissible in my opinion, without question. So that'll give you the latitude that you need to try to make sure that you hit home the fact that the grand jury is just, they only hear one side of the case. You can talk about it all you want to. Because I'll be honest with you, when I have a jury come in that I picked the grand jury and the jury, and I did that here, I always tell them that the grand jury hears one side of the case only. They don't hear the other side. And they're instructed when they're the grand jury. They only hear one side of the case. So I think it's fair game to make sure that a trial jury knows that the grand jury only hears one side of the case. And I'll allow that during your board hours for you to bring that out because it is the law. All right, let's go on to the second motion.
Judge, the second motion,
I gotta find it on my docket sheet that I'll throw on half, so.
actually, Your Honor, the very first jury trial I ever had as a prosecutor in Hardin County, the defense attorney did that to me. He walked up to the jury, tore the indictment in half. I didn't know what to say. Fortunately, it was just a photocopy, not the court's copy. The second motion, Your Honor, is simply to keep out the opinion of the truthfulness or not of the victim's testimony by any other witness. In the same way, I cannot introduce testimony that a witness believed that person. Testimony that a person does not believe the victim is also irrelevant to, because the jury is the one, I believe in the court's jury instructions, the court reads to the jury, you are the sole judges of the truthfulness of the victim, if I recall correctly. Therefore, any other testimony by any other witness would be irrelevant, it's not allowed.
Then I'm gonna guess that I failed to send the court undecided case on State versus Cummins.
Correct.
Now, I do have a copy here for you and.
This in relation to indictment, I mean, motion limiting number 2.
Yes, Your Honor. Your Honor, in our response, it would be, in order for Detective Saltkill to opine the truthfulness of the victim or witness, we believe it fall under Rule 701. Lay witness providing testimony in the form of opinion or inference. It's limited to those opinions or inferences which are rationally based on the perception of the witness. And 2, help to clear understanding of the witness's own testimony. Mr. Detective Saltkill would absolutely opine that she was not truthful, and which is why he never, why he closed his file and filed no charges. Under Cummins, Your Honor, and I've got it here and I'll share it with you. I know you don't have it in front of you, but if I could just talk about Cummins for a minute. This is where State versus Cummins, this was the case out of Jackson. And what happened is the appellate in his appeal argued that the sergeant, Shimwell, made improper comments during his testimony that rise to level plain error and require reversal. Shimwell testified without objection. That was probably one problem they had, but that he did not believe certain portions of the appellate statements the police were truthful. And the court said they didn't find any plain error in the argument. They found no error. It resulted from his testimony. Defense was questioning Shimwell. Now, I will say this. Here's what the defense was questioning Shimwell, why he didn't charge him with other things. And the officer said, because I didn't believe his truthfulness, did not, it conflicted with the physical evidence found at the scene. I hand this Cummins case to your court to review. I apologize for not having it before. But I believe it would help the trier of fact if Sergeant Salt or Detective Saltkill can, talk about his investigation and why he didn't bring charges. It's because he didn't find the alleged victim truthful in the matter. And it's based upon his perception of the witness during his investigation of the case and his many years of law enforcement. I'm not trying to say he's an expert, but he is. And he's been doing this a long time. This is what he does in investigations. And that's why he did not arrest or file charges against my client, Mr. Clary.
And Judge, that is the exact sort of thing that the state is not ever allowed to do because it's irrelevant. if this were the case, in every other case I've ever had, I want to put Detective Saltkill on the stand and say, I absolutely believe the victim. I think the defendant's a liar. Because that's essentially what we have here, just reversed. And that's not allowed. And in the case that Mr. Cox cited, the fact at issue was the fact of why he didn't charge other charges. And then the state failed to object to that. Well, I am objecting to that right now because it's not allowable. And the defense can't bring up, why didn't you file these other charges, just to then bring in the fact that he didn't believe the victim. That would not be allowed. So Judge, it doesn't fall under 701 because it's not going to be helpful to the determination of a fact and issue. The only person whose opinion matters, the credibility of a witness, is the jury, and Your Honor sitting as a 13th juror. But it is not relevant for an officer to say what their opinion of a victim's truthfulness or lack thereof, or any other witness is.
Well, I have quickly reviewed this Cummings case. And in that, obviously, the officer testified that, what was going on was that they had an officer testify about why he didn't do certain actions, and that basically said he didn't believe that the appellant was being truthful with those versions. And it goes on to state that in Rule 701 states that lay witnesses providing testimony in the form of an opinion or an inference is limited to those opinions or inferences which are rationally based upon the perception of the witness, and two, helpful to clear understanding of the witness's own testimony or the determination of a fact and issue. They went on to say that they thought the testimony of Sergeant Shimwell was permissible under Rule 701. He testified to believe the appellant was being untruthful because the statements did not reconcile with the forensic evidence. And therefore, accordingly, we find this issue to be without merit. Without hearing the testimony of the purported witness that he's indicated that might be giving his opinion, the court is of the opinion that it's difficult for me to reconcile this finding in this case with what the general rule is that there are methods by which you attack the credibility of a witness and the truthfulness of that. Generally, you're not allowed to have a witness take a stand and testify that they know that person is lying under oath. They have the right to bring someone in to testify that a witness's reputation in the community for truthfulness. That's the way I've always understood that you attack that. So this case, in my opinion, it's a 2002 case, but it sure seems to me like that goes against the general rule that does not allow a witness to say, I know they talked to me and I thought he was lying, or I think he's lying under oath when he testifies. So because as General Turnbow stated, if we open that door and we start going into those types of situations, then that would be allow the state to then try to bolster the testimony of any of their witnesses by saying, I talked to him and I believe he was telling me the truth, and that's why we did certain things. So at this juncture, I'm going to simply say that I'm going to preliminarily grant this motion, but at the trial, I'm not prohibiting you from the witness that you want to testify about that issue. When they testify, we'll have a jury out hearing before you offer any type of testimony that goes into whether he believes she was or was not being truthful. Because I want to compare what that testimony is compared to this case and any other case that I may run across between now and then to determine whether or not that's admissible. Right now, it sure seems to me that it flies in the face of what I've always understood in all my years as being the method by which you can attack the credibility of a witness. And that you're not allowed to just simply have someone say, I think that witness is lying. So we'll cross that bridge when we get to it and see whether or not there's evidence in at the time of the trial to determine that. This is set later this month, right?
It's set on the 28th.
And
We were just talking about that, Your Honor. It's probably going to take 2 days, which I'm fine with doing the 28th, and then 29th is VOP day and coming back and finishing on Thursday. That's all right with you.
What do you have on the, well, I mean, we can move it to the 30th and 31st, which is 2 days of trials. Is there anything set that's going to go on those 2 days?
I don't believe so.
Are you available on the 30th and 31st, Scott?
Yes, sir. I just checked with my wife. I thought I had put myself in Boyd State on the 31st. That's the week before. So
Why don't we do that? Let's move it to the 30th that way. I'm hesitant to move our VOP day because everybody else, and I don't want to start a trial and then have to skip a day and then come back on the 30th anyway. If we started on the 30th, is that a problem for you?
The only issue, Judge, I issued subpoenas like a month and a half ago. I will try to, and I did not issue those for the 30th and 31st, but I will try to reach out to all my witnesses and make sure they.
Find out. We can keep it, if you're gonna have a witness problem, we'll keep it on the 28th, and if need be, we'll bump the 29th to the 30th. So
just that we do have one nurse that we don't have observed, they sent it to the right place and they said, no, it's the wrong place. So
There's one hanging out there anyway. And I'll do that as soon as possible, Judge, and let the court know.
all right, and then there was a motion that county attorney has filed.
no, he filed a motion twice. I had subpoenaed the 2 no true bills. I know he's not here to argue, but
In view of my ruling, I would say that his argument is probably going to prevail.
probably, but
Grand jury proceedings are secret and are not admissible, and what goes on is not necessarily something that would be there. So in my opinion, I'm going to preliminarily say that you're not entitled to that information, especially in view of my ruling.
can I just say one thing, just to under 4032-101, and that is the destruction or release of public records. All public records of a person that has been charged with a misdemeanor or felony shall, upon petition by that person, having jurisdiction of the court, having jurisdiction of the previous action, be removed and destroyed without cause to the person if the charge has been dismissed, and B, a no true bill is returned by a grand jury. So that, to me, the legislator said it's public record. And even if I can't use it, if my client's indicted, he gets a copy of that, obviously. If he's not indicted, he does it. But let's just take for argument's sake that he didn't even know he was being indicted. Because there's those things happen all the time, secret indictments. So how could you ever get it expunged or get a copy or know about it if we can't get it? But the courts here in 4032-101, or the court, the all-knowing legislators, say it's public record. That would be my argument, Judge. Obviously I can't use it in trial. There's nothing secret about it. It's just, I would guess it's just a circle says no true bill, what he was indicted to.
I know you don't represent the county, but it's still, in my opinion, it still boils down to the fact that a grand jury proceeding is different than others. And what you're talking about is if someone was considered or had a criminal action brought against them, and then there was no true bill, be able to get a copy of the no true bill so that you could somehow use that in the effort to expunge the record or whatever. That's a different scenario than getting that information about what takes place in the grand jury. So what are you asking?
I'm just asking for the copy of the 2 no true bills. I'm not asking to know what the testimony was. I'm just asking that it's being held in the clerk's office. There's a no true bill in his file. I'm asking just.
Well, I don't really want to take that up without the county attorney being available, but maybe, I don't know what good it'll do you in view of my ruling, unless you want to make them the no true bills as an exhibit to your record so that it goes up on appeal. You have that.
I could make it offer of proof.
But all you're going to have is just a no true bill on the indictment. And I think the state's stipulating on the record that those things occurred. So it seems to me redundant where the state stipulates that that was in fact the fact. You now have on the record that there were two no true bills. And therefore it establishes the same thing as having the actual no true bills in physical form. So we're just going to, at this point, say that you're not entitled to it, but you are entitled to have it recorded in the record that there were two no true bills issued by the grand jury in this particular case. And that's the stipulation that the state has made. All right, thank you. And that resolves that motion, whether or not the county attorney ever appears or not. So, all right.
Thank you, Your Honor.
All right. What are we doing, Mr. Edie?
This is the best interest plea, 24 CR4, 24 CR5, and 24 CR6. I passed the forms up a while ago. There they are. Okay, yes, you have them. In 24 CR4, it's a best interest plea to count 1 DUI third, it's name misdemeanor. 1129 suspended to supervised probation after serving 180 days. While he is on probation, he's to enter within the next 30 days a 6-month inpatient program of some sort. It's $1,100 fine and lost license for 6 years. Counts 2 to 6 are dismissed in settlement. On 24 CR5, count 1, it's best interest plea DUI third. 1129, again, suspended supervised probation after serving 180 days. Again, he has to enter that 6-month inpatient rehab within the next 30 days and complete it. It's $1,100 fine and cost, lost license for 6 years. That's all going to run concurrent with 24 CR4. Counts 2 and 3 will be dismissed in settlement. And then 24 CR6, it's count 2 is a DUI third. 1129 suspended supervised probation after serving 180 days. He's got to enter the 6-month inpatient rehab within 30 days of going on probation, complete it. It's $1,100 fine and cost, lost license for 6 years, concurrent with 24 CR4. And then he'll also be pleading guilty to count 1. It's a vehicular assault felony. It'll be 2 years suspended to supervised probation. That's consecutive to count 2, the DUI third, and to 24 CR4 and 24 CR5. And he has to complete the inpatient rehab that was required. He does have credit from October 6th of 23 to today. So I believe that does put him out today. So effectively, he served his 180 days and he'll have 2.5 years roughly of probation to complete that 6-month-long inpatient that he's supposed to enter in the next 30 days.
Right, Mr. Edie, raise your right hand, let's make sure on the road.
Do you solemnly swear or affirm the testimony you give in this case for the truth, the whole truth, and nothing but the truth, so help you God?
Yes. State your full name for the record. Mr. Edie, you've heard your lawyer go over what the agreement is for the 3 different indictments that you have, but have you seen or been shown a copy of those charges? Talked it over with your lawyer, you and Ms. Wilkinson discussed the range of punishment as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to these charges according to this agreement. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand that you would have the right to have a lawyer and have one appointed for you if necessary?
Yes, sir.
You understand if we went to trial, you would be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt. For the satisfaction of all 12 jurors and their verdict will have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed through the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer worked out. You understand that? That's going to result in a number of convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. I'm required by law to make sure that you are advised of the enhancement provisions of the law regarding driving under the influence. You're entering pleas to third offense driving under the influence. Any person convicted of a third offense driving under the influence shall be fined not less than $1,100, or more than $10,000, and shall be confined in the county jail or workhouse for not less than 120 days, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for not less than 6 years. Any person convicted of a fourth offense shall be guilty of a Class E felony, shall be fined not less than $3,000, no more than $15,000. Shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class E felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a fifth offense shall be guilty of a Class D felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class D felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a sixth or subsequent offense shall be guilty of a Class C felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class C felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of any offense while accompanied by a child under 18 years of age, the person shall be fined $1,000 in addition to the fine for the DUI offense. It shall be confined for a mandatory minimum period of 30 days, which shall be served in addition to any period of incarceration received for the DUI offense. If the child suffers serious bodily injury as a proximate result of the DUI offense, the person commits a Class D felony and shall be punished for vehicular assault as provided in TCA 3913-106. If the child is killed as a proximate result of the DUI violation, the person commits a Class B felony and shall be punished for vehicular homicide involving intoxication as provided in TCA 3913-213-B2. In addition to the required sentencing, a judge may order substance abuse treatment, substance abuse assessment, by conditions of probation, and or monitoring with periodic reporting using one or more of the following: transdermal or other alternative alcohol or drug monitoring device, electronic monitoring with random alcohol or drug testing, global position monitoring systems. In determining whether a conviction is a second or subsequent offense, it does not matter whether the prior offense occurred in Tennessee or in another state. In determining whether a conviction is a second or subsequent offense, all prior convictions within the past 10 years from the current conviction shall be considered. If the person's current conviction is within 10 years of the previous conviction, the person shall be considered a multiple offender. If the person is considered a multiple offender, then all convictions within 10 years of the date of the immediately preceding conviction shall also be considered in determining the number of prior offenses. For purposes of determining if a person is a multiple offender, the state may use a conviction for an offense committed in another state that would constitute the following if committed in this state: driving under the influence, boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide. The state may also consider an offense committed in another state as a prior conviction if the elements of the offense are the same as the elements of the comparable offense in this state. For purposes of determining if a person convicted of DUI is a multiple offender, prior conviction for boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide shall be treated the same as a prior conviction for DUI as long as the person was convicted of the prior offense before committing the instant violation of DUI. A defendant's automobile may be subject to seizure and forfeiture upon a second or subsequent conviction of DUI offense. Unless a person convicted of violating TCA 55-10-401 is determined to be indigent, the minimum applicable fine shall be mandatory and shall not be subject to reduction or suspension. All fines are to be paid on the date sentence is imposed unless the court makes an affirmative finding that the defendant lacks the present ability to pay. The court shall then order a date certain before which payment shall be made. Should the defendant fail to comply with the order of the court, the clerk shall notify the court of the failure for further proceeding. Payment of restitution to any person suffering physical injury or personal loss as a result of such offense if such person is economically capable of making such restitution, shall be imposed as a condition of probation under TCA 55-10-410. I need you to sign a form here that you and your lawyer indicate that you have both reviewed this, and that has been explained to you in open court. All right, you understand everything I've explained to you thus far?
Yes, sir.
You wish to enter the plea according to this agreement?
Yes, sir.
Are you satisfied? Do you understand rather that I cannot accept your plea unless I'm satisfied there are facts to support it that you are in fact guilty?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this? You understand that if you plead guilty, the court of the state may ask you questions about this offense. And if you answer those questions under oath on the record in the presence of your lawyer, your answers can later be used against you in a prosecution for perjury.
Yes, sir.
Then I want you to understand that I have to find out from you, are you guilty of these 3 DUI offenses?
No, he's entering a best.
Pardon?
He's entering a best interest plea.
The best interest plea, all right, then I want you to listen as the state tells me what their evidence will be.
On September the 9th of 2023, Mr. Edie came to the sheriff's department for a custody change. It was determined that Mr. Edie had driven there and that he was under the influence of alcohol there. The filter right test went unsatisfactorily. There were 3 open containers in the vehicle, and he did not consent to the flood at all. He had 2 prior DUI convictions at that point. And then in 24 CR5, October the 6th, Mr. Edie was driving a vehicle in the area of Chapel Road. Officers got a report of an impaired driver. They observed the vehicle matching the description. They pulled that vehicle over. Mr. Edie was driving that vehicle. It was determined that he was under the influence of alcohol at that point as well. He agreed to give a blood sample that day, and it came back over the legal limit. He had 2. The prior DUI had not been a conviction yet, so he still just had 2 prior convictions at that point. Then 24 CR6, October 22nd of 2022, a year prior to those 2, Mr. Edie was involved in a crash where it was determined that he was the driver. And in that crash, his father was seriously injured. Mr. Edie's blood was taken, and it was well over the legal.
I'm not asking that you agree with those facts, but you understand that's what the state's evidence to be if this case went to trial.
Yes, sir.
You sure wish to enter a plea according to this agreement?
Yes, sir.
Are you satisfied with your attorney services? Feel like Ms. Wilkerson's done a good job of representing you confidently.
Yes, sir.
Ms. Wilkerson, you know of any reason you should not enter this plea?
No, sir.
Anything further from the state?
Your Honor, obviously, we consulted the victim on the victim assault. He wrote a letter to our office in response to correspondence we send out. This is actually more than he wanted to see happen, but it's the least the state.
Understand. That victim was the defendant's father?
Yes, Your Honor.
Then Dakota Edie and docket number 24-CR4 on your plea of guilty of best interest plea of guilty to count 1, counts 2 through 6 are dismissed. I find you guilty, sentence you to 11 months and 29 days in the county jail, suspended to supervised probation after 180 days in jail. You must enter a 6-month-long inpatient rehabilitation within 30 days of going on probation and complete that rehabilitation as a condition of your probation. In order to pay a $1,100 fine and cost, your license to drive is suspended for a period of 6 years. Count 24 CR5. You're found guilty of count 1, counts 2 through 3 are dismissed. 1129 suspended to supervised probation after 180 days. Same thing, same requirements for inpatient rehabilitation, $1,100 fine, loss of license for 6 years. That will be served concurrently. Count docket number 24-CR6, count 2, you're found guilty, sentenced to 11 months and 29 days, supervised probation after 180 days. Same requirement for inpatient rehabilitation, loss of license 6 years. That will also be concurrent. Count 1, vehicular assault, is sentenced to 2 years at Tennessee Department of Corrections, suspended to supervised probation, but that will be served consecutively to count 2. To count 2 of 24-CR4. and 24 CR5. You must complete the inpatient rehab as required by Camp 2. Essentially, you're on 3 years probation after your release. That's the judgment of court. We'll need to see the probation department if he wants to before he is returned to jail. All right, thank you. You have anything else?
Your Honor, on page 1, Gary Van.
Every day in the USA, people find themselves in court.
All right, Christopher Reyes, can you hear me?
Yes, ma'am.
Oh, good morning. Okay, this is in the matter of Nicole Deanne Jupe versus Christopher Thomas Reyes, file number 2015-41906 DM. Looks like you had a court-appointed attorney, did you not?
I do not have one, no.
All right, so Mr. Reyes, we're here today on a show cause that was adjourned from April 8th. On April 8th, you were to, we talked and you were supposed to make your March and April payment and those were not made. Are you able to make those today?
Your Honor, I'm finishing up a big job. That's the only thing that held me up. I'm almost done with it. The end of this month is kind of when I was hoping that I'd be able to have it before this court date, but I mean, I don't have any extra money. I'm pretty much broke until I finish this job. It's kind of screwed me up.
So Mr. Reyes, I appreciate people who are go-getters and go work for themselves and do these things, but you need a job where you make payments. You're going to get charged with a felony. You understand that, don't you?
I don't understand why. I understand what you have told me that, but
in the state of Michigan, once you reach about $10,000, the Attorney General reviews these cases, or I report them to the AG, and they will charge you with the 4-year felony, which means they'll arrest you on a warrant, they'll put you in jail, they'll require you to put a minimum 20% down, and then you get placed on probation and to pay that down. So if you're not able to pay your $256 a month in child support doing what you're doing, then go get a job at a factory, do something else and do side jobs.
No, I understand, Your Honor. I'm literally trying to get to the point where I can pay off a large chunk of this. I mean, even though I was pretty much homeless when all of this came up.
Right.
But I'm trying to take care of it all now. I've already tried to reach out.
So you're telling me you're going to pay 700 and I don't know, 750. You're going to pay $800 by the end of the month.
Once I finish this job, I'll be able to pay off, until next month. That's all I've been working on this month. I've been working on this job.
So my question was, at the end of the month, you're going to be able to pay $800 to pay for March, April, and May.
Yes, I will 100% have, all the money to pay for all of it.
All right, Miss Adams, can I get a date for June 3rd? Do we have anything open June 3rd?
June 3rd. We don't, except you do have a motion for summary at 11 if you want to squeeze it in at 11:30.
I don't have any front of the court show causes at 8 o'clock.
Oh, show causes. Yes, I'm sorry.
All right. Okay, thank you. So Mr. Reyes, I'm going to adjourn this to June 3rd at 8 a.m. And I want you here in person. Do you understand?
To come down there in person, okay, I can.
And you better
yeah.
have either paid it, unless you paid the 800. You paid
Yeah,
the 800.
I'll have it. I'll have it
Hey,
paid by then.
Mr.
but I
Reyes, Mr. Reyes,
Yeah.
you keep telling me you're gonna have it and you don't have it. So listen to me. If you pay the 800 in person, if you pay it 2 weeks before that date and Miss Stevenson can verify it, that's great. But you either show up that day with $800 or understand you're facing jail.
You're right. I understand that. Your Honor,
Okay,
yeah.
so I'm gonna set this over to June 3rd at 8 AM. And where are you? Let me see here. Let me see something. Yeah, leave by 6:30 to get here, because you know it's a long drive. But if you paid it a couple weeks in advance and Miss Stevenson can verify you paid the 800, then she can adjourn it again. All right?
Yep, but that's yeah.
Okay.
I was hoping.
So, Mr. Reyes, like I said, if you can't, you know, it's nice to be able to say that at least your kids are eating, even though you're not paying your child support. But if you can't make monthly payments, then get a different job. So we'll see you back on June 3rd at 8 AM in person. Thank you.
Maybe I'll get to see my daughter by then too. All right, have a good day.
Bye. That's a separate thing.
Hello?
All right, Ms. Mosier, hold on 1 second.
Why aren't you in it? Because you're getting mine.
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And we're here in Tire v. Chalker et al., file 23-9009CZ. Counsel, you want to state your appearances, beginning with plaintiff?
Thank you, Your Honor. Daniel Lesnick on behalf of Mr. and Mrs. Tyer, who are present in the courtroom with me.
Okay, and Ms. Chalker, good morning. You're here representing yourself in this matter, is that correct?
Yes, Jennifer Schaefer, I believe, is going to be joining via the telephone.
Yes,
I mean,
but she's not representing you, is that correct?
She is as of right now.
Okay. All right, Ms. Schaefer, you want to place your appearance on the record?
Thank you, Your Honor. Jennifer Schaefer here on behalf of all of the defendants. I previously filed an answer on behalf of all defendants except for Ms. Chalker, and as of this time, I am entering an appearance on behalf of Ms. Chalker as well.
Okay, all right, very good. And do you seek to, well, this is up for pretrial then, so this is a great first question. And do you seek leave to amend Ms. Chalker's answer?
I actually, no, Your Honor, I'm quite satisfied with her answer.
Okay, and we've construed her letter to the court as a letter answer for a self-represented litigant. That answer will stand then. Mr. Losnick, are you satisfied with the pleadings?
Yes, Your Honor.
Okay, so amendments would require leave of the court. Is this a case subject to initial disclosures, and have they been filed or?
I believe it is, Your Honor. Plaintiff has not filed theirs, and we've waited for that purpose. I'm happy to file ours, obviously immediately. We've been trying to discuss with plaintiff some form of resolution. And so I think the initial disclosures went by the wayside while we were trying to discuss that, but we're happy to do that now.
Okay, well, why don't I give each side 21 days to file the initial disclosures. And how long do you need for discovery, Mr. Losnick?
I already requested a couple of depots be set. That would probably be the only discovery I need. This case involves a dock in a canal on the Indian River. It's navigable waters, according to the United States government. The dock is right in front of my client's house, who own a lot in Constance Park subdivision. There's issues of riparian rights. There's issues of a nuisance in our complaint. So I don't think discovery is going to be extensive. Maybe some government records and the statements of the history of use by depositions. So yeah, I'd say 90 days would be plenty.
Okay, Ms. Schaefer, does that sound fine with you? 90-day discovery window?
90 days discovery. I certainly disagree with some of Mr. Lozniak's statements about these are absolutely not navigable waters. This is a man-made canal. There's no riparian rights. And so I think we might actually, if we can't resolve something very quickly and I guess cost efficiently, we might be filing a motion for summary pretty quickly.
Okay, so we'll have a 90-day discovery witness list within 60 days. Well, I'll say 45 days. How about that? And do you want me to order this to any mediation or no? Just let you guys continue to talk and go mediate it if you wish.
I believe we'll mediate it if we wish. We're going to take a look at the law again. The law may very quickly resolve it and not need any mediation.
Well, I won't order any formal ADR at this time. Then, well, this is a non-jury matter, right? Estimated length of trial, Mr. Losnick?
A day.
Okay.
I'd agree, Your Honor.
Okay. So at the close of discovery, if there hasn't been any dispositive motions resolving the case, would you all prefer a final pretrial on the record or a settlement conference in chambers with counsel and with your clients available for consultation?
Settlement conference, Your Honor.
Mr. Last, any objection to that?
That'd be fine.
Okay, so let's see, that would be until say August. Let's schedule this then for a settlement conference on August 14th at 11 a.m. All right, anything further for purposes of scheduling order, Mr. Losnick?
You're gonna send us out a copy of that order
Yes, sir.
with all those dates on it?
Yes, sir.
Thank you.
Ms.
Your
Schaefer,
Honor.
anything further?
Yes, I know this is a bit unusual, but it just came up very recently. There was an incident last week between Ms. Garner and Mr. Tyre, where Mr. Tyre was very aggressive and intimidating toward Ms. Garner while she was near the property that's in question. And so I'd asked the court if there's possibly an order that can be entered as part of this, that there not be any assaultive, aggressive, intimidating, harassing behavior between the parties while this is pending. Certainly that should go without saying, but because we did have this incident last week, it came very close to the police being called. And I think perhaps it'd be best to just put that on the record to make sure that everybody's clear on that.
I have no problem with that, Judge, if it also includes they not use the dock in front of my client's house.
Yeah, see, that's why then, you know, I'm not inclined to grant just sort of verbal motions that aren't noticed up or stipulated. So I'm going to leave that to, sounds like Mr. Losnick's okay with that, but he has a stipulation that you might or might not be okay with. So if you guys can agree on a stipulated order, go ahead and submit one. Otherwise, Ms. Schaefer, you are welcome to file a motion and notice it up. You can contact my assignment clerk for a date. If there's anything that you believe fits the court rule requirements for emergency relief, you know, you can take advantage of whatever remedies under the court rule you think are appropriate.
Thank you very much, Your Honor.
Okay, thank you.
Thank you, Judge.
This is 240644 FY, the state of Michigan versus Amir Al-Maradi. Oh. All right, this is 240644 FY, the state of Michigan versus Amir Al-Maradi.
Good morning, Your Honor. Ed Bookbooking on behalf of the people, P86266.
And good morning, Judge Hannah Barron, P85265, representing Mr. Al-Maradi. Mr. Al-Maradi, can you say your name for the record?
Amir Al-Maradi.
Okay, everyone can be seated. So it's a time and date set for preliminary exam. Are the people ready to proceed?
We are, Your Honor.
Okay. Are there any preliminary matters that need to be addressed before we start taking testimony?
Just ask for mutual sequestration. There's an exception from officer.
Okay, any objections?
No objection, Judge.
All right, so it'll be granted, and I see that there are two family members and Mr. Al-Maradi's in the courtroom. Is there any expectation that either of them could be witnesses at a later date?
No, Judge.
Okay, ma'am, can each of you please stand? And can you tell me your name, your first name in the green?
Yes, Your Honor. Huda Al-Maradi.
Can you spell your first name for my court recorder?
Yes. H-U-D-A, last name Al-Maradi, A-L-M-U-R-A-D-I.
Thank you. And ma'am, in the beautiful headscarf, can you tell me your name?
Thank you. Iman Alawadi.
Can you spell your first name?
I-M-A-N.
Okay. And last name's the same spelling?
A-L-A-W-A-D-I.
Okay, all right, wonderful. Everyone can be seated then. Thank you. All right,
Just one more, if I may, Your Honor.
yes.
The people, I did put Ms. Barron on notice that if the proof showed people would add one counter, receiving and concealing stolen property over 20,000, it's a 10-year fine.
Understood, Judge.
And with that, people would be ready to call their first witness. Mr. Jonathan Gale.
Okay. Sir, can you come on up? Can you stand and face me? Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, sir, if you can have a seat right there in that witness chair. I'm going to ask you to speak loud and clear, and before you start, can you say your first and last name and then spell your first and last name?
It's Jonathan Gale. First name Jonathan, last name Gale, Gale.
Okay, thank you. Your witness.
Thank you, Your Honor. Mr. Gale, I'm gonna get right into, I'm gonna direct your attention back to March 15th of this year, 2024. On that date, were you at the location of 14100 Telegraph Road?
Yes,
Is that in the city of Taylor, County of Wayne?
it is.
And what is at that address?
It is a Harley Davidson dealership.
Are you affiliated with that dealership in any way?
I am the general manager of the facility.
Okay. And were you there that day around 12 o'clock noon in your official work capacity?
Yes,
And what were you doing around that time?
I was doing a facility check that I do once a day, at least once a day, sometimes twice.
And what's a facility check?
It's just a walking each of the buildings that are on the premises facility, just making sure everything is as it should be.
Okay. And while you were doing that facility check, did anything stand out to you?
My trailer was missing.
Okay. So what kind of trailer?
It's a 7x16 enclosed cargo trailer.
And where was that trailer parked at the time? Before, where was it, where should it have been parked when you noticed it was missing?
Trailer, when I left the day prior, was located up underneath a pavilion that overhang is attached to our storage facility warehouse and the back part of the property. So it's up underneath the pavilion.
Was the trailer hooked or hitched up to anything at the time?
No, it was up underneath the facility with locked, stored.
And when you, going back now to the 15th, and when you notice it's missing, what's the first thing you do?
Well, I contacted the property manager to see if it had been moved, just with everyday transactions, bikes coming and going, trucks coming and going, to see if they moved it first. There was nothing there where the trailer sat, the blocks, everything was sitting there, everything was gone. So my first thought was that they actually moved it or tried to move it. I was confused, so I contacted him first.
Okay, and before I ask any further questions, now you're the general manager of that Harley Davidson. Was this enclosed trailer yours personally, Jonathan Gale's, or the dealership's Harley Davidson's?
It was mine person.
And why was it parked there at the dealership at the time?
I have a home in Myrtle Beach in South Carolina, and running this facility since the first of the year, I've been traveling back and forth. So I was bringing personal property back and forth, and just a week or so prior, brought some stuff up there and set it there. As a matter of fact, 2 of my bikes were in the shop. I had road bikes that were in the trailer that were in the shop being worked on, that I planned to put back in the trailer before I moved off site.
Understood. So you said the property manager?
Yes.
Okay. And without telling me what the property manager said, did you deduce whether or not your trailer had been moved on property anywhere else?
Yes, there was, no, logically, there was no way to move it. But I thought since everything was gone, I had to check with them first before I contacted PD.
Okay. So after you speak to your property manager, what's your next course of action?
Went to the cameras, our security cameras, our surveillance to check the night before, as I know when I had done the facility walk the evening before, the trailer was there. So I knew that it had to happen sometime from the time I left in the morning. So went to surveillance cameras and found the vehicle entering the property and leaving the property with my trailer.
Okay. But before I get into the videos, I want to ask you this. So you said you had done a property walk the evening before. Would that be March 14th?
Yes.
Do you recall about what time that evening you did a walkthrough of the property and noticed your trailer was there?
I do. It was about 4 o'clock in the afternoon because the Red Wings were in town, and I left that evening shortly after that to go catch the game.
Okay. So at 4 p.m. on the 14th, your trailer was there. Yes. And at noon, the 15th, your trailer was no longer there, correct?
Correct.
One moment, Gunnar.
Are you sharing a screen, Mr.
Yes.
Shadra?
My colleague is going to
Okay.
share his screen now.
I don't see you in the courtroom.
Yes, ma'am.
All right. All right, so we're back on record on 240644, the state of Michigan versus Amir Al-Maradi. All parties are present in the courtroom. Can you call your next witness?
Yes, I think we call Detective Oliver.
All right, Detective Oliver, come on up. Detective, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, if you can have a seat. And just start with your first and last name, we know how to spell them.
Detective Corporal Matthew Oliver, the City of Taylor Police Department.
All right, your witness.
Thank you, Your Honor. Detective, how long have you been with Taylor PD?
9 years, sir.
I'm gonna direct your attention to, we're here today. Are you in any way involved in the case of People versus Amir Al-Muradi?
Yes, sir. I was the officer in charge.
Okay, and as officer in charge, what are some of the things you've done as it relates to this case?
As the officer in charge, I'm assigned by Detective Lieutenant Frank Kenny to investigate the crime that occurred. After reviewing the report, I contacted the victim as one of my first steps.
Okay, and who specifically did you get in contact with?
Mr. Gale.
Okay, and you had a conversation with Mr. Gale?
Yes, sir.
And based on your conversation with Mr. Gale, what do you do?
Mr. Gill, during our conversation, described to me his specific trailer, the very distinct markings on it and the damage.
Objection to hearsay. All right, what did you do with that information?
Thank you, Judge. So with that information Mr. Gale gives you, what do you do?
I provided him with a link to submit video. He submitted video to me.
Okay, did you watch that video?
Yes.
And what video specifically did you watch?
The 2 prior videos that were played in the courtroom, sir.
Okay, so did you watch the video of the kind of the back of that dealership with the gate and the pickup trucks?
Yes, with the structure, or with how the dealership's laid out, that's the southwest quarter of the dealership.
Okay.
Where the theft occurred.
Okay, and when you watched that video, that's People's Exhibit 1.
Yes.
When you watched that video, what did you see in it?
It's a very distinct blue Dodge Ram, 4-door. It has like aftermarket upgraded wheels, as they're not like the stock 5-spoke wheels. That vehicle in the area of where the stolen property was parked.
Okay, and did you watch any other video? You said you did watch other videos.
Yes, the second video.
Okay, and that would be People's Exhibit 2.
Yes, sir.
And what did you see when you watched that video?
Again, the same specific blue Dodge Ram 4-door.
I just object if this video is in evidence. I think this is beyond the scope of this officer's testimony.
I'm just trying to get into what.
All right, overruled. Go
Thank
ahead.
you. So you watched that second video and you were in the middle of talking. You said the same Dodge. Please go ahead.
From my observations of reviewing the video, I believed that it was a blue Dodge Ram 4-door with aftermarket upgraded wheels carrying or pulling the trailer that was described to me by Mr. Gale.
Okay, and so you have the make and model and the color of the vehicle. So what do you do with that information?
So in the city of Taylor and in numerous jurisdictions around here, there's a system called Flock, which is a documentation system that takes photographs of license plates and vehicles as they pass specific points wherever the cameras are posted. With the license plate that is registered to Mr. Gale's trailer, I was able to observe that the vehicle was traveling northbound at Goddard Road after the
I
theft.
object to a lack of foundation. We didn't receive any testimony about what plate was on that trailer. And it would incorporate hearsay as well, to officer's testimony.
Okay, I'm curious about the hearsay objection before I respond. What is the hearsay objection?
Well, it does seem like a back door to get in hearsay because this officer can't testify to what the plate was on that vehicle as he is not the witness to that.
Well, I would argue under 1101B8, he could testify to the plate as the property that was stolen in this case. So Michigan court rule that would allow hearsay to be admissible on preliminary exams for that very purpose. So if he does know it, I would ask him that.
Well, why don't you ask him that? Does he know it? I mean, I don't know where the investigation led, other than it led to charges. So I don't know if the trailer was ultimately located yet. And if it had a plate on it at the time, I don't know that to, respond or to, for now, it's overruled. Let me see what he's got.
What, do you know what the plate was on that trailer?
I do not know the specific plate off the top of my head, because we have access to lien and talent, which tells us all registration information to vehicles, property, and the registered owners of said vehicles or property.
And Judge, lien is hearsay. So again, I do think that this is a backdoor to get hearsay into the system.
I wholly disagree about lien being hearsay, Your Honor. There's no declarant. It's a computer software. There's no person. It's a simple bar exam question. There's no declarant in it, so it's not hearsay.
The declarant is whoever put that information into lien. That lien does not exist in itself. It gathers that information from different declarants.
Is he just testifying that he used this as an investigatory? Are you just trying to lay a foundation for his testimony about what he did?
Absolutely.
I'm going to allow it strictly for that purpose. I'm not allowing it. I'm not, for the truth of the matter asserted, I'm using it. I'm just going to allow it for him to testify as to what he did based on whatever information he received.
Thank you. Going back, so you said there's flock and you have the license plate for
Yes,
the
sir.
trailer. So where does flock, describe to me, what does flock show?
Okay, so flock are cameras that are stationed around numerous jurisdictions at intersections within many cities. They take pictures of vehicles and property as they pass the cameras. It's a documentation system. So with that system, I can search license plates, makes and models of cars, colors, numerous different things that I can search to specifically look for certain vehicles or pieces of property. With this system, I was able to observe that Mr. Gale's trailer was traveling northbound on Telegraph at Goddard Road after the theft. There are numerous flock trail cameras up and down Telegraph Road. Because of this path of travel, I searched Telegraph Road's flock cameras for vehicles.
Okay. And when you did that search, what if anything did that show?
I was searching for a vehicle that was consistent with the vehicle that committed the theft. A blue pickup truck, which is a Dodge Ram, because Dodge Rams have very specific and distinct taillights in them, even in the nighttime.
Okay, and all right, and when you do that search and you're looking for what you said, these very distinct taillights, what if anything do you see? Or what if anything are you brought by flock?
Okay, so searching up and down Telegraph Road through flock camera systems, and based on my training experience of people going northbound on Telegraph at a late hour, I believe that the vehicle was possibly heading towards I-94 or in the area of I-94 as a major intersection.
Okay.
So searching the cameras, I searched for pickup trucks going north and south on Telegraph Road in the approximate time before and after the theft.
And what did you see?
Prior to the theft, I located a blue Dodge Ram that was license plate ELP 4007, traveling southbound on Telegraph near Gardner Way. I believe the intersection is actually Champaign or Hayes, about 1:45 in the morning.
Just want to make sure I heard you correctly, guys. ELP 4007?
Yes.
And do you do anything with that license plate information that you now have?
So I also found, yes, with that specific vehicle, I searched the same camera system, flock. I searched it during the daytime prior to the 15th, which is the day of the theft, and observed that it was attached to a vehicle that was consistent with the vehicle that committed the theft.
Okay, and what was that?
It was a blue Dodge Ram 4-door with upgraded wheels. It had a dent in the back bumper and a blue tarp with something under it in the bed of the truck.
Yeah. And when you saw this same in the flock camera during the daytime, that was before the theft, correct?
Yes.
So there was no trailer hitched to it at that time.
No.
Right? So now that you have, now that you see it in the daytime, what's your next course of action?
So I continue searching for more vehicles to check all my routes. I located another plate hit on a flock camera on the same camera. I believe it was at right after 2 a.m. It was a business plate. It was DE. I would have to review the report to refresh my memory on the specific plate.
So you don't remember the exact plate?
But it was a business plate because it's different than your normal personal plate.
Okay.
Because it starts with 2 letters and then 5 numbers.
Understood. So you see this now business plate, so it's not a regular plate. And are you seeing this during the daytime or is this at night?
This is approximately 20 minutes after I saw the ELP 4007 on the morning of the 15th.
Okay. And now what's the actual picture show?
It just shows the rear end of the Dodge Ram.
Is
There's
it
very distinct lights, but it shows the license plate. So I did the same exact thing that I did with the first plate, and I searched it the daytime. This time I searched it after the theft, and it was the same vehicle that I observed with the ELP, because it's a very distinct package. It's a blue 4-door Dodge Ram, aftermarket wheels with a very specific dent in the rear bumper, and also the blue tarp in the back of the bed. So based on my training experience, it appeared to me that the license plate had been switched between the first flock hit and the second flock hit.
I just want to make sure I'm understanding your testimony.
Yes, sir.
So you do the search for the ELP 4007 plate, and you said it came back to the blue Dodge Ram with a very distinct package, the upgraded wheels, and the dent in the back. Is that
Yes.
correct? And you said 20 after the flock camera hit for that plate and that scenario that you just described.
Yes.
There was a same exact vehicle with the very distinct plate, or excuse me, the very distinct package, the color, the blue upgraded wheels, and the same dent. Now attached to a plate that starts with the letters DE and it's a business plate. Am I understanding that
Objection
correctly?
to leading.
I'm just want to understand.
Sustained.
He just testified to all. of
I
it.
know, but now you're trying to summarize his testimony in the form of a question. I mean, I heard his testimony, so we've seen the vehicle.
And I know the court's taking notes and everything. For my own understanding, I want to make sure I understood him correctly. That's all I was asking.
Okay, we'll ask him to tell you chronologically.
Okay, chronologically, could you please summarize what you just described? Because it was
Yes, sir.
very,
So to not pigeonhole my investigation, only look for one car, I saw the ELP 4007. I conducted a search of that in the nighttime. Noticed it was in the area prior to the theft. I searched that in the daytime, observed that it was a blue four-door Dodge Ram with specific wheel, with upgraded wheels, and a very specific dent in the rear bumper. Now, to continue the investigation, to not pigeonhole myself into one vehicle, I continued the search and found it, located another vehicle that was a business plate. The specific business plate I did not remember off the top of my head. I searched the same business plate as I did the first vehicle, but in this instance, it didn't come up prior to the theft. It only appeared in flock after the theft. And because it appeared after the theft, and being the same vehicle as in the color, the package, the wheels, and the very specific dent and the blue tarp in the bed, based on my training experience, it appeared that the vehicle's license plate had been switched between the I believe it was like 145-ish was the ELP hit, and then the business plate hit right after 2 a.m. So in that time frame, based on my training experience, I believe the license plate was switched prior to the theft. And that's why the ELP plate no longer hit on flock or any camera systems after the 15th.
so what do you do next in your investigation, if any?
So with this information, and seeking more information, as the business plate was improperly plated. So a lean check of the business plate came back to a Ford F-150, which this is obviously not a Ford F-150, it was a Dodge Ram. So with this information, I sent out a bulletin to neighboring jurisdictions requesting assistance in any other investigations that were consistent with this vehicle being involved in thefts.
Okay, and when you put out that bulletin, do you get any notifications at all?
Yes, sir. I was contacted by Officer Matthew Baker of the Dearborn Police Department.
Okay, and based on the conversation, now do you converse, without telling me what you said, do you converse with Detective
Yes.
Baker? And based off of that conversation, what, if anything, do you deduce?
That the suspect was possibly Mr. Amir Al-Muradi.
No, that's, yeah. Go ahead.
Judge, objection to trying to get in hearsay, to a lack of foundation.
Yeah, it's sustained. So back up. So you contacted Dearborn.
I was contacted by Officer Matthew Baker.
Okay, is that Dearborn or Dearborn?
Yeah,
Heights?
that's Dearborn.
Okay, and then based on that, what did you do?
Okay.
That's my question.
Okay,
just for the
well,
record.
that's,
Forgive me.
go ahead.
Thank you. So what did you do based off of, without telling me what he said?
Okay,
What did you
so-
do based off of that conversation?
Officers of the Dearborn Police Department and their Special Operations Unit had a suspect in mind for a person who could possibly be responsible for the thefts. Based on this information, they were able to locate the vehicle in Romulus.
Objection, this is all hearsay.
I also went to Romulus.
Okay, well then I would ask that this officer simply testify to his own observation.
So so there's a vehicle in Romulus, you go to Romulus.
I was notified.
This is all effect on the listener. It's obviously leading him somewhere. It's a.
No, I understand that, but it's still hearsay if he's saying
But
they
it's
did
admissible.
this,
It's
they
admissible.
did that. I mean, it's hearsay.
It's admissible hearsay under effect on the listener. That's all I'm just trying to get it in for. Why does he go to Romulus in the first place? If he would have just testified that he went to Romulus, you'd be objecting to lack of foundation.
No,
All right.
it doesn't matter. This officer went to Romulus. That's enough foundation to then testify to what happened in Romulus.
All right, let's do that. So you go to Romulus.
Went to Romulus, Your Honor.
Where specifically in Romulus?
A Merriman, I believe it's 8,400 Merriman or 84, I don't remember the specific average. It's right next to the airport, right off I-94 on Merriman.
And what is in that general area? Like where specific is it?
It's a strip of hotels and businesses, and a gas station.
Okay, and describe to me when you go there, what do you do? What do you see first?
In the area, I observed a blue Dodge Ram, 4 doors, aftermarket wheels, the business plate that was located, that I observed on Flock, in a hotel parking lot of the Magnuson, approximately 100 yards in a connecting parking lot away from that vehicle, I observed Mr. Gale's stolen trailer parked.
Okay, and what do you do after first seeing that, if any?
At that time, Dearborn Special Operations took over the investigation and conducted surveillance.
Understand. 1 second. One final question.
Yes, sir.
I want to go back to the flock camera. You said after the second time with the business plate, when you did the flock search that time, was the vehicle in question towing anything?
No, this was prior to the theft.
No further questions.
Judge, I need just a moment.
Okay. I'm going off record for just a moment while she talks. Ms. Phelps, have you met with your client?
Yes, Judge.
Advocate will reach out to you, okay?
Okay, thank you so much.
All right, you're all set, sir. Thank you.
Thank you.
All right, are we back on? Are you ready?
Yes.
All right, we're back on.
Before cross, could I just, and I know this is not something, can I just ask a couple more questions? If the court would mind.
I don't mind. Go ahead.
Thank you. Where I left off a moment ago, you told me that Dearborn PD took over the investigation.
Yes.
Did you at any point re-enter this investigation?
Yes.
And where did you re-enter the investigation?
After Mr. El Maradi was arrested and pieces of stolen property were recovered from the adjacent parking lot.
Okay, and describe to me, how does that happen? How does your involvement kind of start there?
So I was notified by them that Mr. Gale's trailer and numerous pieces of his property were some of the things that were.
Objection to hearsay.
Effect on the listener. Just how does he get back in, Judge?
All right, well, he just for effect on the listener, so he gets information.
Yes, and he gets back.
That Mr. Gale's property is in a storage facility now located in Dearborn Heights because it was recovered. How would you like me to say it, ma'am?
What, no,
I'm sorry.
no, she's got to protect her client. We're all going to get through this. All right, these are valid objections. So.
The hearsay, Judge. That's my.
It is hearsay, but the prosecutor's indicated he's just using it to get to what the officer did next. So it's just being used, so he gets information that there's property in a storage locker. What's he do next?
Based off of this information, what do you do next?
I went to a tow yard or storage area that was located in Dearborn Heights, located Mr. Gale's stolen trailer, which was now empty. All of Mr. Gale's property was in another trailer that was recovered on scene with.
I mean, go ahead.
All of Mr. Gale's property was now in another trailer. His motorcycle that has his name on it, all of his gear, all of his property was now in another trailer that was discovered to be stolen out of Ohio with Mr. El Maradi's personal mail and business mail.
No further questions.
All right, cross.
your last piece of testimony. So just to clarify, you observed that trailer that you're testifying about, is that right?
Yes.
Okay, and you observed those belongings that you're testifying about?
Yes.
You observed everything that you just testified about in your last comment?
Yes.
Okay. So going back to your testimony about Flock.
Yes.
So this is a question for me. So is Flock, it doesn't take any video, is that right?
Depending on the cameras that you subscribe to, but no, none of ours do that I'm referring to.
Okay, so the Flock that you used, it just took photographic stills, is that correct?
Yes.
Okay, so you testified that you picked up what you suspected was a blue Dodge Ram a number of times on the night of March 15th, is that correct?
They're very specific taillights, so yes.
Okay, and so when you picked up that specific vehicle on the evening of March 15th, those were dark, it was dark, is that right? The block still was dark?
At 1 a.m., yes.
Okay, so all you could see was the taillights, that's why you're testifying about taillights, is that correct?
Yes.
And it was your understanding that the alleged theft took place at 2:20 or 2:30 in the morning, is that correct?
Approximately.
Okay, and so the only times that you picked up this alleged blue Dodge Ram, that was at 1:43 in the morning, is that right?
Prior to the theft.
Okay, at 1:43 in the morning, prior to the theft that evening?
Yes.
Okay, and then again at 2:07 in the morning, is that correct?
That's prior to the theft when the plates were switched.
Okay, and so that evening, those are the only times that you picked up the suspected blue Dodge Ram that night on March 15th, is that correct?
Yes.
Okay,
In our city.
okay, but those are the only stills that you personally observed from Flock, is that correct? Say that again?
On that morning, yes.
Okay. So you did not observe on Flock that alleged Dodge Ram pulling a trailer, is that correct?
The license plate was covered by the size of the trailers.
So the answer is no, you did not view that, is that correct?
Yes.
Okay. So the only time that night that you viewed the suspected Dodge Ram was approximately 20 minutes prior to the theft, is that right?
Yes.
Okay. And so you never viewed, again, you testified that these images were very dark, is that right?
At 1 a.m., yes.
Okay, so you never viewed the driver of the vehicle, is that right?
No.
Okay, and there's no surveillance on which you viewed the driver of the vehicle, is that correct? Okay, and so you testified that you did respond to the hotel at some point, this hotel, is that correct?
Yes.
What was the name of that hotel again?
He was arrested at the Magnuson.
Okay, and you were there for the arrest?
No.
Okay, but you responded later on, is that correct?
Prior to.
Prior to. And when you responded prior to, were you wearing body camera footage or body camera?
No, undercover in a car.
Okay, and you said that you did respond afterwards and you viewed these trailers, is that right?
Yes.
And were you wearing body camera at that point in time?
Are you talking about when he was at the storage facility?
Yes.
Okay,
Thank you.
Don't think so, but you have pictures of all the pictures I took at the storage facility.
Okay, so you did take pictures, is that right?
Those are all the pictures.
Okay, but you weren't equipped with body cam to your memory?
No.
Okay, and so at the storage facility, that's the only time that you saw these trailers, is that correct?
No.
Okay, what's the other time?
When they were parked behind the other hotel that was adjacent to the Magnuson.
Okay, but you never looked inside the trailers on scene, is that right?
No, they were towed as is from the location.
Okay, so when you observed them, it was your understanding that they were as they were when they were at the hotel lot, is that correct?
Yes.
Okay, that no one had touched it before you, is that right?
Mr. Gales was open, but the other one was locked. It had to be ground open.
Okay.
The back door had to be ground, the lock had cut off it.
Okay, Mr. Gale's trailer was open when you first looked at it, is that right?
Yes.
Okay.
At which location?
At the storage unit?
It was-
Okay,
we-
is that right?
We opened it up, but it was open as in the door could be open.
Okay. Okay, I'm sorry, I don't understand that. So as unlocked unit.
It was
unlocked.
unlocked.
Okay, but you opened it. Okay. And you testified to observing a few things inside of that trailer, is that right?
All of Mr. Gale's property.
Okay, specifically what?
A dirt bike, numerous pieces of clothing, boots, helmets, straps, tools. I mean, it was a vast amount of things that all belong to Mr. Gale.
Okay, and you testified that this was in a lot adjacent to another hotel, is that correct?
The Magnuson is where he was at, and then this is, they all connect in parking lots, so.
Okay.
About 100 yards.
But
the different parking lots.
Okay. But again, you were not there for the arrest of Mr. Al-Muradi, is that correct?
No.
Okay. But you did surveillance in an area with connected hotels, is that right?
Yes.
Okay. All right, just one moment. Nothing further, thank you. Any redirect?
Quick redirect, Your Honor. When you were at the storage facility and at the end of your testimony, was Mr. Gale with you?
He did come to the location, recover his equipment.
Okay. And did he take ownership of the things you just testified to?
All of it.
And did he indeed take it with him?
Yes.
Any cross based on that? No.
Your Honor, I just wasn't.
Oh, I'm sorry, go ahead.
Was there any other pieces of evidence that would go towards identification that you found inside the area, the trailer or the trunk?
Yes.
What did you locate?
The trailer where all of Mr. Gale's property was located, there was personal mail for Mr. Al-Muradi in the trailer.
Was it just loose or like where was it?
It appeared somebody had moved out of a house because there was tools, there was different mail, there was
Objection to
clothing.
speculation. All right, well, it's okay, go ahead. Overruled.
There was tools, mail, personal piece of items. There was like a game system. So it was appeared to be someone's personal belongings.
I would just object again to the speculation. All right, it's noted for the record. Okay.
No further questions, thank you.
All right, are we all set with this witness?
The people are.
Are you all set? All right, thank you, Detective Oliver, you're all set. Who is our next witness?
Detective Baker, Your Honor, and that would be my final.
All right, what's the last name?
Baker.
Baker, okay. Officer. Face me and raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, have a seat. And can you start by saying your first and last name and then spelling your first and last name?
Matthew Baker, MATTHEWBAKER.
Your witness.
Thank you. Mr. Baker, where are you currently employed?
Dearborn Police Department.
How long have you been with Dearborn PD?
Just under 9 years.
In your role as a detective with the Dearborn Police Department, did you become involved in the case of People versus Amir Al-Muradi?
Yes.
How did you become involved in that case?
Dearborn had a trailer left on Schaefer back in March involving a blue Dodge Ram, and that's when I started investigating it.
Okay. And how did you become linked to any possible cases in the city?
I received a bolo from Detective Oliver.
And what's a bolo?
Just be on the lookout, or do you have any cases of similar nature?
Okay. And when you got that bolo, what did you do with when you first received that?
Well, I contacted Detective Oliver and said that I had a possible suspect.
Okay, and why did you believe that you had a possible suspect for Detective Oliver's case?
Just the Dodge Ram matched. It was a kind of distinct blue Dodge Ram that had aftermarket wheels on it, and it was involved in ours.
Okay, so you share your information with Detective Oliver?
Yes.
Okay, and what do you do next?
We followed up on a flock hit that happened in Romulus.
Do you specifically follow up on this flock hit?
Yeah, me and my team, yes.
Okay,
Go out there.
and how many people are in your team?
4.
Okay, and who are they police officers as well?
Yes.
And what are their names?
Sergeant Nichols, Corporal Champagne, and Corporal McCullum.
Okay, and what are the 4, what do you specifically do?
I went to the area of Spring Hill Suites in Romulus, where we located the Dodge Ram.
Okay, did you go during the day or during the night?
During the day.
Do you recall the date when you went out there?
I don't recall the date.
Okay. Was it after March 15th?
That had to have been.
Okay. So you go out there, you said during the daytime, and what do you?
Probably about 4 p.m.
Okay, and what do you see when you go out there?
Behind the Spring Hill Suites, we found a trailer that was in the Bolo from Taylor. It was like an enclosed trailer with a specific dark colored panel replaced. And then I had a longer enclosed trailer and a jet ski trailer, or 2 jet skis on a trailer that are behind the hotel, with the Ram was parked next to them.
When you say next to them, what do you mean by next to them?
So technically, like, there's a parking lot behind the Spring Hill Suites. His car was to the west. It was to the west of the trailers, that's the way I can describe it.
About how far away, feet wise, was the truck parked?
6 or 7 feet.
Okay. Are these, you described 3 trailers, am I correct?
Yes.
Are they parked just in parking spots or are they just in the middle of a parking lot? How are they?
No, it was more like it's like a pool parking lot. So there's a parking lot and then there's an additional like pool parking lot. So they were in like kind of like random parking lot. It was empty besides the trailers.
Did you see anybody around when you first got there? Human being ones.
Huh?
Did you see any human beings around when you first observed what you just described for the court?
When I got there, I seen Mr. Almirati up against the jet skis.
Okay, so wait, so you see a person near the jet skis?
Yes.
That person that was near the jet ski, and just for the record, was the jet skis were next to these other trailers in this truck, is that correct?
Yes, they were all in a line.
So you see a person there, the person that you saw there, do you see anybody in the courtroom here today that was there that day?
I do.
Could you please point to that person, identify them by an article of clothing that they're wearing?
Green shirt, Amir Almirati.
Thank you. Your Honor, may the record reflect that witness Detective Baker has identified the defendant.
Record shall so reflect.
So you see Mr. Almirati, you said near the jet skis?
Yep.
And what's he doing? As you observe?
He's near him when I observed him, so that's the only thing I can testify to. He's just near the trailer.
Well, what do you mean by near? What?
In the vicinity, like standing next to the jet ski, a foot away from the jet ski.
Okay.
His truck was parked about 10 or so feet just to the south of him.
And
on the other side of the trailer.
what kind of truck was that was parked?
His blue Dodge Ram.
How do you know it was Mr. Almirati's blue Dodge Ram?
He had received a ticket in it when I ran him through our systems. He had received a
Objection.
What sort of system, and if I may
On what
just,
basis? Well, let him clarify. Go ahead. Clarify your question. Did you have a follow-up?
I was just gonna ask what system, because I guess that would go as to my response as to what I'm assuming is a
Go ahead.
hearsay objection. What system did you run, Mr. Almirati?
Clemens. That's our police database that we write reports on.
Judge, I would object to hearsay. Whatever is in that system is hearsay. As I previously stated, it does come from a declarant. This isn't just something that exists in a vacuum.
Okay. All right. Are you using it for the truth of the matter asserted?
Absolutely. And it's not hearsay, Your Honor. There's no declarant in Clemens or Lien. It's a computer software, as he just testified to.
And Judge, I don't know of any published case law on point, but I would cite to an unpublished case on People v. Smith, 2021, Westlaw 70574.
Wait,
Yes,
221
sorry.
Westlaw 70.
Yes, 70574.
Okay.
It's, if I may respond, it's unpublished, so the court, it's not binding on this court. But if this court wants to accept that as precedent, then anything officers really rely on, whether it's traffic stops.
Well, they're investigatory tools, right?
Absolutely.
So if they use them to continue their investigation, I think it's allowable for those purposes, but not necessarily for the truth of the matter asserted, right?
I would disagree.
Okay, well, let's respectfully disagree then. All right. It's the stain. So go ahead.
Okay, so you see Mr. Almirati near all these things, correct? Yep. And so what do you do next?
I actually took an outer perimeter spot, as one of my other teammates watched him. And then I observed him, travel to the speedway, just on the corner of Merriman and I don't know the cross streets over there.
How did he travel to that speedway?
He was in the blue dot Ram. He was the driver. I watched him get out of it.
Was there anybody else in the vehicle with him at the time?
No.
Okay. So do you continue your surveillance?
Yes.
And what, if anything, do you observe next?
He goes in the speedway for a couple minutes and then comes back out and he eventually just travels to the Magnuson Hotel.
Okay.
Parking lot.
And you're continuing your surveillance throughout this time?
Yes.
And what do you do next?
Once he parks at the Magnuson Hotel, he parks on the south side. He goes in. Shortly after I go in, I confirm that he's checked in to the hotel.
Okay. And what if anything, do you do next?
We just continued surveillance the entire time until later on we arrested him.
Were you present for the arrest of Mr. Almirati?
Yeah.
One moment here. So you testified that Mr. Almirati was eventually arrested, correct? And you were present for that?
Yes.
What, if anything, happened to that blue Dodge Ram?
Impounded it.
Were you, was it inventory searched before an impound?
I did not search it, but it was searched. I don't know who searched it.
Okay. No further questions.
Cross.
Good morning.
Hello.
So officer, you testified that you received information about a blue Dodge Ram with aftermarket wheels. Is that right? Is that a yes?
Yes.
And you located a blue Dodge Ram that you believed had aftermarket wheels. Is that correct?
Yes.
Okay. What do the standard market wheels look like on a blue Dodge Ram?
Well, most of the Dodge Rams that I have encountered that year are silver. This one just had like a distinct, it was just like the distinct blue color was more for me, but they had the same rims, those wheels in the Bolo that he sent.
Okay.
All the agencies.
So you're not sure what the
No.
standard market wheels look like? Okay, you just
She's
happened to
aftermarket,
notice
yeah.
that these had a specific kind of rim,
Yes.
but you can't actually speak to whether that was market or aftermarket. You just know it was a silver rim or
No,
what was?
they were black.
Okay,
I would
black
say normal rims are probably silver.
Okay. And you testified that you were conducting surveillance at this hotel, is that right?
Yes.
And that was on March 18th, is that right, of this year?
I don't recall the date, but it was in March.
Okay, would it refresh your recollection to look at a report prepared by your team? You can free to look wherever.
Yes.
Okay, does that refresh your recollection? That refresh your recollection?
Yes, ma'am.
And it was on March 18th that you did surveillance?
If that's what's in the report, yes.
Okay, and so that was the first time that you observed this blue Dodge Ram, is that right? Okay. And you testified that at some point you saw Mr. Almirati driving the vehicle, is that right?
Yes,
And at another point, you also saw a woman drive the vehicle, is that right?
I did.
Okay, and that was without Mr. Almirati inside of the vehicle, is that correct?
Yes.
Okay. Okay, one moment. Nothing further, thank you.
Any redirect based on that cross?
When you saw this female driver in the vehicle, were you ever able to figure out who that female was?
Yes.
Who was that?
First name was Aya, last name started with R. She also had a ticket prior to the vehicle. I just from running her prior.
Do you know what relation she may have with, or may not have with Mr. Almirati?
I believe it was his wife, girlfriend.
No further questions, Your Honor.
Anything based on that?
No, Judge, I just object to a lack of foundation, last comment.
All right, overruled. Anything else? All right, sir, you're excused. Thank you, Mr. Baker.
Thank you. We have no further witnesses on the rest.
Counsel, defense counsel?
No witnesses, Judge.
Okay. The people?
Yes, Your Honor, the people who move for a bind over on all counts. Sorry about that, Your Honor. The people would move for a bind over on all counts. And as for a bind over on the added count of receiving and stealing stolen property over 20,000 or more. I'll first mention this is a very circumstantial case. As Your Honor knows, circumstantial evidence is weighted exactly the same as direct evidence. And in a case like this, usually all we have to rely on is circumstantial evidence and following the breadcrumbs kind of left by perpetrators of crimes such as this. So we have Mr. Jonathan Gale, who testifies that he has this trailer, has all of these personal belongings to him within it. He described a multitude of things from a dirt bike that was aftermarket modified, a lot of his tools, his personal things that involve what he needs to actually ride, the helmets, braces, boots, gear in general, all of which he testified to the values of about $6,400 for the trailer, about $10,000 for the bike before the modifications, $1,200 for the riding gear, $1,500 for the braces, $1,200 for the boots, and about $1,800 for the helmets, at least from what I have here. He testifies that he had that parked back behind that Harley Davidson, and then there one evening doing his normal rounds, sees it's there. The next morning or afternoon area time, he notices it's gone. When he goes into the video, he sees, and what I played in court with People's Exhibit 1 and 2, what he described as a late model Dodge Ram in that back kind of area where in the middle of the night, about 2:30 in the morning. And then he sees in a different angle that same Dodge Ram hauling off with his trailer. And he knew it was his trailer because it had a very distinct marking from that different colored panel. Well, then Detective Oliver comes into play. Detective Oliver does a multitude of flock camera hits. He sees that the plate ELP 4007 hits in the daytime before and never hits after the theft. But that on that same aftermarket, Dodge, bright blue Dodge Ram with the aftermarket wheels and that dent, what he described in the back of it. And then after the theft, that same truck hits with a completely different plate. And it's a business plate, and all Detective Oliver could remember was the first two letters of that plate, which was DE. He gets a tip from Detective Baker, who also testified here today. They were investigating Mr. Almirati from a separate case that happened in their jurisdiction. And all together, through all these various flock hits, they find Almirati's vehicle and him, along with Mr. Gale's stolen trailer and two other trailers in the back parking lot, pool parking lot area of this hotel. Detective Baker testifies, identifies Mr. Almirati as being near the jet skis, which is near these trailers and his truck. Testifies to seeing Mr. Almirati drive with that truck to a gas station or 7-Eleven or something like that, and then back. And then I'd also point to the mail that was found in the back of that trailer with Mr. Gale's personal belongings being addressed to Mr. Almirati. So I don't have any direct evidence here of Mr. Almirati caught red-handed, hopping in the truck, hooking up the trailer and driving away. But there's a lot of circumstantial evidence here that would point that Mr. Almirati probably was the person that committed this crime, and this crime did happen in the city of Taylor. So with that, Your Honor, the people would humbly ask for a bind over on all.
Counsel? Judge, the prosecutor really hit on some of the reasons that there aren't probable cause that Mr. Almirati committed a theft in Taylor, Michigan. There is no evidence that Mr. Almirati was in Taylor, Michigan at all. We didn't hear from any of these witnesses that they saw him there. And there's no other evidence that he was ever physically present there. Detective Baker testified that he located this blue Dodge Ram 3 days later, 3 days after the alleged theft in Romulus, Michigan. So that would be plenty of time for this allegedly stolen property to make its way into different hands, potentially unknowingly. So Judge, there is no evidence that Mr. Almirati committed a theft in Taylor. And I would just also point out, so the government is moving to add a count of receiving and concealing stolen property that really is essentially the same charge as the count one, the larceny. Judge, the receiving and concealing, the 2 counts of receiving and concealing, the motor vehicle and now the $20,000 of theft, the evidence that the government has is that this occurred in Romulus. Mr. Almirati was located in Romulus. That property was located in Romulus. And Mr. Almirati is facing charges in Romulus for these allegations. I think that these would be properly tried in Romulus. I do not think that receipt of stolen property would be properly tried coming out of this court. And understanding that a trial will end up in the circuit court regardless, Judge, but Mr. Almirati is facing those charges in Romulus, and this is not a proper venue. Judge, I would also just note the government is moving for bind over on forgery of a license plate, possessing a stolen registration plate. I don't think we heard any evidence as to that.
Okay, thank you. Do the people have a brief response?
Yes, Your Honor. As to the Romulus cases, I didn't bring them up, but since the doors have been open, the prosecution in the Romulus cases is for the 2 other trailers that were stolen in that case, the jet ski trailer and the longer enclosed trailer. He's being prosecuted for receiving and stealing stolen property of those 2 trailers there, specifically not for this trailer, because we're proceeding here. The allegation here is that Mr. Almirati was in that truck based off circumstantial evidence that he's seen in that truck later. He's ticketed in that truck, and so I understand so is this female. The officer was able to deduce that that's most likely his girlfriend. So that's the allegation in this case. In Taylor, we're prosecuting the taking. In order to take, you have to possess. In Romulus, what's being prosecuted is the possession. So that's a completely separate case. And the reason that people didn't bring that up is we didn't think it would be appropriate in this case. Since the door's been open, it's a completely separate prosecution over there.
Okay, so there are no charges in Romulus relating to the property that was alleged to have been taken in Taylor.
That is correct.
Okay. All right. So I've heard evidence from Mr. Gale this morning. Jonathan Gale, as well as Detective Oliver and the Dearborn police officer, Matthew Baker. I agree the case is circumstantial. But what we have heard, or what the testimony showed, is that the vehicle involved in this was an easily identifiable vehicle. It had special wheels and some other characteristics. We also heard testimony that the trailer in and of itself was identifiable. And I understand that the defense counsel's position is when the Mr. Baker testified, or Officer Baker testified, that he went to Romulus, that over the course of 3 days, the property could have changed hands. But he specifically saw Mr. Almirati driving the vehicle. When he goes out there, the truck is within 6 feet of 3 stolen trailers. And he sees Mr. Almirati out by the jet skis.
So he sees him, in close proximity to the stolen property and driving a motor vehicle that matches the description of the video that we've seen, as well as testimony of Officer Oliver. So, when we look at the jury instructions that will ultimately come into play in this case, 23.2 states that if you find someone in possession of recent stolen property, you may infer a defendant committed that charge. This is a probable cause conference or a probable cause standard today. It's certainly not beyond a reasonable doubt. For a probable cause standard, I do believe the people have met their burden. I think that I'm presuming that these counts are all the alternative. If the added count for receiving and concealing over $20,000 is added. There was testimony from Mr. Gale, extensive testimony about the value of all of the items that he had taken from him or that were inside that trailer. It's well over $20,000. I didn't do the math, but just the trailer and the bike almost met the limit. And then he testified about some suspension conversions, the exhaust, knee braces, riding boots, helmets, one of which was $1,000, $2,000 worth of tools in his riding gear. Certainly is over the $20,000 limit. There's further evidence of identity in that Mr. Almirati's documents or mail were in the stolen trailer. So certainly for a probable cause standard, the people have met their burden with respect to count 1 and count 2 and count 3. Count 4 will be dismissed. There was no evidence to support count 3, and there will be an added, or I'm sorry, count 4, license documents, plates, forgery. There was no evidence. That will be dismissed, but a count will be added per the people's request for the receiving and concealing stolen property, $20,000 or more. Will the people be able to get my clerks downstairs a amended complaint today?
Oh, yeah, I can create that now, and then I just ask the court for use of your printer, if that's okay. Or I can email.
Yeah, if you can get on them, or you can email it downstairs to the clerks and we'll print it. So I do find for a probable cause standard, certainly the people have met their burden. And the matter will be bound over. Is that still 750535 for the new account?
Sorry, Your Honor, I had my colleague in my ear. What was that?
The added charge, do you know the section? I know it's 750, is it 535?
535 parentheses number 2 and then parentheses lowercase a.
2A. Okay, so we'll send that downstairs, sir. You're bound over on the charges and in the information with the exclusion of count 4, which was dismissed, but there's an amended count that is added based on the testimony I heard today. The arraignment on the information, you'll be bound over to 3rd Circuit Court for all future proceedings. The arraignment on the information date is May 20th.
Judge, I would ask to address bond.
Okay, does he still have a hold in Romulus?
Yes.
Okay.
So Judge, I'm asking for a lower bond or a personal bond for this case. Mr. Almirati is not a danger to the community. He is not a danger of failing to appear. I believe that Your Honor put the bond in place because of the potential of failing to appear. I don't think it was because of him potentially being a danger to the community. So very briefly, these are nonviolent offenses. He doesn't have any history of violence. And as to failing to appear, Judge, Mr. Almirati has very strong ties to Michigan. He has incentive to appear. As Your Honor is aware, his family is here in court today, his sister and his mother. They've been heavily involved in his case. And Judge, he has 2 young children who are currently residing with his mother. And the current bond has been unaffordable thus far for Mr. Almirati's family. The bond in Romulus is $10,000, 10%. So at this point, Mr. Almirati has to make both bonds. in order to be released and be able to be reunited with his family and the community. If he were to be released, he would be residing with his mother, where he'd be able to be again with his young children. And Judge, we would at the least ask that the bond in this case match the one in Romulus. I would just note, I know that the government said that these are different charges than the one in Romulus, but this is, in my view, essentially one allegation. This is not a long history that Mr. Almaretti has. These aren't disparate allegations. And so Judge, for all those reasons, we're asking for a lower bond.
Judge, if people would object to any reduction in the bond, as I'm looking at Mr. Almaretti's criminal history, there's no assault of felonies at all, but from what I can see, but there are a multitude of theft and drug cases. And then now there's habitual status for offender receiving and concealing back in 2019. 2 of those actually for motor vehicles, and then a controlled substance possession charge. And now we have this receiving and concealing case here with tens of thousands of dollars worth of items, and then the Romulus case where more drugs were actually found. He's also being charged with possession up there for that. So I would disagree with opposing counsel. This is a repeated pattern of the same types of crimes, theft and drugs, and it's going to keep continuing, which is why the people would ask that the bond stay the same. Whether or not you can afford the bond is irrelevant to the actual, what we actually need to do when we do this analysis. So people object.
Judge, it's not irrelevant whether someone can afford a bond. All right, but I heard enough. I know the bond rule. I agree. Here's the problem. Mr. Almaretti has a habit. When I arraigned him on this, he had bench warrants all over. He's got a history of failing to appear. He's got a history of convictions for theft. All over. He goes to Wayne County, Oakland County. It's lengthy. He's got history for all kinds, drug charges, theft charges. He's got this case, a Romulus case. Looks like he might have another Dearborn Heights case. I've heard the bond arguments. I think after hearing the testimony, the fact that it's almost a criminal enterprise for Mr. Almaretti. He has not 1 stolen trailer, not 2 stolen trailers, but 3 stolen trailers. People's stuff. And people in the community should be able to, like, I don't know, go to bed and think maybe their stuff won't be stolen while they're sleeping or while they're not at work. And Mr. Almaretti's pattern of criminal behavior, from what I can tell from his criminal history, and the facts in this case are quite concerning, and I'm denying a bond modification. They can change it in circuit court. And we're all set. Thank you. All right. And we have other exams, Mr. King. Do we need a moment to talk to the prosecutor about your 2 cases?
No, Your Honor.
All right, are we holding?
I believe in one we are.
All right. All right, are we ready? This is on Mr. Newby. This is 240908FY, the people versus Craig Newby. Can I get appearances?
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
Good morning, Your Honor. Maggie George on behalf of Craig Newby, P85651, and we consent to our appearance via Zoom today.
All right, I see Mr. Newby's here as well. So first and foremost, this is a time and date set for probable cause conference. What is the status of discovery?
Your Honor, we've received written discovery.
And digital discovery was tendered to the email address on file.
I'm sorry, I have that too. My apologies.
All right, so discovery appears to be complete,
correct,
though continuing. All right, so we have an exam date right now.
Your Honor, we're going to waive the exam.
Are you waiving it now?
Yes, we are.
Okay. Can
I voir dire your client on that, or would you like to do so, Ms. George?
You may voir dire.
All right, Mr. Newby, you've had a chance to consult with your attorney, is that accurate?
Yes.
You understand you have a right to a preliminary exam where it must be shown that a crime was committed and probable cause exists to charge you with that crime?
I do.
All right, are you voluntarily waiving your right to that preliminary exam with the understanding that you'll be bound over to circuit court on the charges in the complaint and warrant?
Is it possible I can talk to my attorney about this?
Sure, we can talk.
Yep, all right, we'll put you back in a breakout room. I will be continuing with my exam, but I want to make sure he knows what he's doing. So, okay, we'll put you back in a breakout room. And then Mr. Gazicki, I see we have Mr. McDaniel here. So this is 240821, the People versus Roger McDaniel.
Morning, Your Honor. James Gazicki on behalf of Mr. McDaniel. Waive reading of the complaint, stand mute. Your Honor, he's currently incarcerated at Carson City. On this matter, I'm still asking for a personal bond. I believe he has a parole hold.
All right, well, I've signed the request for discovery. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. If you cannot afford an attorney, one will be appointed to represent you as Mr. Gazicki was appointed today. I don't have the second page, but I will sign the ex parte order to preserve evidence as well as the request for court appointed attorney. I just need the second page on that. So, he has a hold for this violation,
Just,
alleged violation.
Yeah.
Okay. So you have 2 dates within the next 14 days or 21 days. The first is your probable cause conference, and that is set to occur next Monday, May 20th. And you can appear at that via Zoom. Following that, you have the right to a preliminary exam. That is set for May 29th of 2024. So 2 weeks from today on Monday, and that'll be an in-person hearing, unless you speak with your counsel and agree to waive that. So those are your 2 dates coming up. It's a serious allegation. He has a $30,000 10% bond with GPS tether. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact. Unsupervised with the minors. And to comply with whatever terms you have of parole. And we're all set. We'll see you back on those 2 dates, sir. And Mr. McDaniel, you're all set. And then back on Newbie, did you have a chance to speak with your client?
Yes, Your Honor, we're all set on the waiver.
Okay, so Mr. Newbie, do you have a chance to consult with your counsel on those issues?
Yes.
All right, and so I'm going to ask you again, sir, now do you understand your rights for a preliminary examination?
Yes.
Are you waiving that right?
Yes.
And you understand you'll be bound over to the Third Circuit Court on the charges in the complaint and warrant?
Yes.
Okay, and you've had a chance to discuss those charges with your counsel?
Yep.
All right. Is everyone satisfied with the waiver?
Yes, Judge.
Yes, Judge.
All right, can I sign your names with permission on the waiver form?
Yes, Judge.
Okay, so I will be able to have my. All right, is there anything else?
Yes, Your Honor, we want to address the matter of bond.
Okay, did you receive the report from the pre-sentence or pre-trial investigative summary?
No, I haven't.
All right, there was a recommendation that bond be reduced to $75,000 based on Mr. Newby's lack of prior criminal history and community ties. It's currently set at 300,000 cash or surety, and they recommended a reduction to 75,000 cash or surety.
Your Honor, if I can address that, I'm sorry, go ahead.
No, go ahead.
Okay, I'd like to request a personal bond for my client. Mr. Newby, like you mentioned, has no criminal record. He's extremely closely bound to his community and his parents, especially his father, who's currently going through his second battle with cancer. Mr. Newby is a diesel mechanic. He saved for many, many years to open his own business as a diesel mechanic, and he's been working in that field to cultivate his own client base, which he has, but cannot service right now while he's in custody. It's really important to him that he be able to support his client base, continue his work, support emotionally his family, and he has retained counsel. He has strong ties to the community. He's not a flight risk. He intends to avail himself to the jurisdiction of the 23rd District or the 3rd Circuit Court. And for that reason, we're requesting that you please allow him to be released on personal recognizance bond.
Ms. Johnson, anything?
Judge, I'll leave it to the court.
Okay, well, I sent this out. We did for a review for determination as to whether or not my bond that was set by this court, not by myself, but to see if it was excessive or if it was appropriate given the circumstances. They reduced it and believe that $75,000 cash surety is appropriate. So he will have a $75,000 cash surety with the GPS tether bond reduction. All remaining conditions will stay in place. And he'll be bound over to the 3rd Circuit Court for all future proceedings. And his arraignment on the information will be on Monday, May 20th, 2024 at 9 a.m. at the Frank Murphy Hall of Justice.
Your Honor, it's just not feasible that my client he doesn't have $75,000 to post a bond, but he's losing his income and his client base and his employment that he's self-employed with by being held in custody. He has no criminal record whatsoever.
These are very serious allegations. I think the bond's appropriate. The people who authored the report down at the 3rd Circuit Court agreed that it should be reduced, and I'm reducing it to the amount that they believe is appropriate given the circumstances, and that's my ruling.
All right, thank you, Judge.
Okay. All right, Mr. Conley, you're gonna have to sit tight. You're super okay. We'll put you back in a breakout room. And then Mr. Gazicki, I see we have Mr. McDaniel here. So this is 240821, the People versus Roger McDaniel.
Morning, Your Honor. James Gazicki on behalf of Mr. McDaniel. Waive reading of the complaint, stand mute. Your Honor, he's currently incarcerated at Carson City. On this matter, I'm still asking for a personal bond. I believe he has a parole hold.
All right, well, I've signed the request for discovery. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. If you cannot afford an attorney, one will be appointed to represent you as Mr. Gazicki was appointed today. I don't have the second page, but I will sign the I signed the ex parte order to preserve evidence as well as the request for court-appointed attorney. I just need the second page on that. So, he has a hold for this violation,
Just,
alleged violation.
yeah,
Okay. So you have 2 dates within the next 14 days or 21 days. The first is your probable cause conference, and that is set to occur next Monday, May 20th. And you can appear at that via Zoom. Following that, you have the right to a preliminary exam. That is set for May 29th of 2024, so 2 weeks from today on Monday, and that'll be an in-person hearing, unless you speak with your counsel and agree to waive that. So those are your 2 dates coming up. It's a serious allegation. He has a $30,000 10% bond with GPS tether. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact. Unsupervised. The minors. And to comply with whatever terms you have of parole. And we're all set. We'll see you back on those 2 dates, sir.
There we go. Is that better?
Yep, there you are. Okay, good afternoon. Who are we going to see first?
This is Ms. Nielsen.
All right. This is 21-1386, 23-1917, 21-0985, and then there's this 2 civil infractions as well that she's here on today.
Good afternoon, Your Honor. Jeffrey Fant on behalf of Ms. Nielsen, waive for all reading with request all warrants to be recalled.
All right, I'll enter a not guilty plea on your client's behalf. I've signed the request for a court-appointed attorney as well. So it looks like the warrants will be recalled. She's got a no attention to a fire case. And it looks like she just never showed up for her PSI on that one. On the drug paraphernalia that she was arraigned back in 23, she never showed up on that one. And then the disturbing the peace, she's been in warrant status 4 or 5 times on. And it looks like she did enter a plea, but then never appeared for sentencing. Is she, and Mr. Fanto, is she still pending other charges or?
It looks like she's pending, not pending here. Those were denied.
Okay.
Doesn't appear she's pending a matter in Westland.
Yeah, so she's here on all of these bench warrants for failing to appear at all of these hearings that she was previously required to appear at. She's assigned to me. I'm going to guess based on the charges in front of me, her lack of appearance in court and her criminal history that she has a substance use problem here. As to bond.
The court kind of went down the
Yeah.
history.
Okay, so Ms. Nielsen, I am not giving you a personal bond. I think you need help. And you're a continued flight risk. You just don't come to court, ma'am. And I see that you have warrants out of Allen Park, Redford, Lincoln Park, and Dearborn Heights. So you're not just being held on these cases, but you have been arraigned. We'll set aside the warrants. She has a $1,500 cash bond on each case on the 3 misdemeanors. And then the 2 civil infractions ending in 2155A and 2155B, there was a $450 cash bond set on all of those, and those will just remain in place.
Judge, is it possible that we could hold her in Taylor tonight and have her meet with the treatment court folks tomorrow?
My only concern is that she's got all these other matters. She needs it. I'm gonna put on her jail paperwork that she needs to be assessed for Matt, and then when we have the pretrial date, we'll try. I'm gonna say bring her in person and we can discuss all that. Is that okay?
Yes.
All right, Miss Nielsen, do you need me to let the jail know? Are you having any withdrawals?
Yeah, I have been. Yeah, I have been.
All right, I'm gonna let the jail know your paperwork so that they can assess you and see if there's any medically assisted treatment you could have at the jail, and just to keep an eye on you and let them know that you are withdrawing. And we're gonna get you back here right away. Ms. Nielsen, we have a program here. It's a treatment court program to help people with substance use problems like yourself. And you don't have violent offenses, you just have continued offenses, and you can fail to show up for court. So that's something you can think about. And when we come back in, if you're interested, we can see if that's a program that would work for you.
Yeah, that'd be nice. That'd be nice.
All right, it would be nice. You could get your life back.
Yeah, it would. It really would.
All right. We'll see you back. I'm gonna let them know to get you here soon, okay?
All right.
Thank you, Judge.
All right, thank you. All right, this is 240836 FY. And there's also a misdemeanor that's up as well today, just following the felony. So, okay, can I get appearances?
Good morning, Your Honor. Jessica David out for the people 3867.
Good afternoon again, Your Honor. James King, P number 85229. I'm here on behalf of Mr. Beatty. Please say your name for the record.
Michael Beatty.
Okay, everyone can be seated. So it's a time and date set for preliminary exam. The people have indicated they're ready to proceed. Is that correct?
That is correct, Your Honor.
Okay, and Mr. King, you indicated you had a preliminary matter you wanted to address on record?
I do. I think it's a strange predicament here because Mr. Pate has been held since the 19th. So I'm not asking to adjourn, but I believe that there is digital discovery that I'm not in receipt of. So I just want to put that on the record so that it can be addressed after today's hearing. But because I'm assuming the court is not going to dismiss, because this is the first time that both the court and I believe the prosecution is hearing this argument from me. I don't know if the lay matters because Mr. Pate is held, so I just want to put it on the record.
Okay, what is do you know what he's talking about, Ms. Davidoff?
I do not know, Your Honor. I believe last time we were here, his colleague stepped in for him, and she did say that they were in receipt of digital discovery. I also further would indicate that Mr. King saw me this morning. He never indicated that he didn't have digital discovery. We also adjourned this matter from last week. Prior to that, Mr. King didn't let me know that he was not in receipt of digital discovery.
All right.
Right now, I was not aware.
Okay, look, no, but we don't have to, I've had enough cat fights this morning. Nobody needs to argue about it. He's making a record. You've indicated that any digital discovery you have, has it been sent? You're at NDS, right?
I am.
And I know it goes through a filter now, right? It goes to someone else and then it's distributed to whoever's assigned the case.
That is correct.
All right,
If I can have a moment, I'll just confirm whether he has it or not.
all right, yeah, just want to take a second. I mean, it doesn't sound like he's requesting an adjournment necessarily. It's just something he wants as the case proceeds to trial. Discovery's continuing. He's certainly entitled to that. He just wanted to be on record that that's the case. So it sounds like it's a issue that can correct itself.
Absolutely, and just, I mean, everything that Sister Counsel said is correct. That's why I'm not asking for dismissals, because this is the first time she's being aware of it, where I'm saying in front of this court. And to move things along in the process, I just want to put it on the record, just like Norman said.
All right, thank you, counsel. Is there a request for mutual sequestration order?
Yes, Your Honor.
All right, now I know two individuals in the courtroom. The two gentlemen there in the blue and the black, are you here on this case?
No.
No, you're here on an unrelated matter? Okay. All right, so it doesn't look like there's anyone in the courtroom. Detective Oliver, are you the officer in charge on this case?
I am, Your Honor.
Oh, okay. Are you asking for an exception for your officer in charge?
Yes, Your Honor. Additionally, just for the evidence, it was submitted and Mr. King has had the evidence for quite a bit of time right now.
So NDS has it.
Right, so, oh my God.
Okay, look, he has to make his record. I respect that. She said she sent it. Mr. King, she's got documentation that was sent over to NDS. So if you can't locate it there or it's not forwarded to you, just contact Ms. Davidoff, whoever takes over the case downtown, and make sure that link gets resent.
Absolutely.
Okay, is this body cam video?
I believe so, Your Honor.
Okay, all right, okay, so we're all set on that. Ms. Maudlin, how's the mic situation?
So far, okay.
Okay, are you asking for an exception to the sequestration order for your officer in charge?
Yes, Your Honor.
All right, any objection?
Not at this time.
All right, so that's granted. All right, yeah, can you call your first witness? Yes, we're
Yes,
ready.
The people call Dina Fustini to the courtroom.
You just follow the court officer, ma'am. And can you stand and face me? Raise your right hand. Do you solemnly swear or other right hand? There we go. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, ma'am, can you have a seat right there in that chair? And I want you to speak directly into that mic. I want you to start by telling me your first and last name and then spelling your first and last name.
Deanna Fustini, DEANNA, and was in Frank USTI.
Okay, your witness.
Thank you, Your Honor. Well, Ms. Fustini, can you state your name for the record again?
Deanna Fustini.
Ms. Fustini, did an incident take place on April 19, 2024 that brings you to court today?
Yes.
All right, and then that incident take place at 15065 Kirsten Street in the city of Taylor?
Yes.
Is that in the county of Wayne?
Yes.
Thank you. All right. And so how did the incident begin at your home?
Barbecuing, he burnt his finger on the grill.
All right, I'm gonna pause you right there. Who was barbecuing?
Mike.
Okay. And is Michael Pate?
Yes.
Do you see a Michael Pate in the courtroom today? You're pointing to a gentleman. Can you identify him with the article of clothing?
A t-shirt.
Do you know what color it is?
Black.
All right, can you tell me where he's seated?
Right there.
All right.
Your Honor.
Ask for more detail. Identify him.
All right.
Red beard, brown hair.
Your Honor, let the record reflect that the complaining witness has identified the defendant?
Yeah, and I would just note for the record, his shirt is green, dark green, but otherwise she's pointing at him, so the record shall so reflect.
And how do you know Mr. Pate?
We have a daughter together.
And you indicated that you were barbecuing together on that day, is that correct?
Correct.
All right, and while you were barbecuing, you already testified that he burned his finger.
Yes, correct.
And can you describe Mr. Pate's reaction to burning his finger?
Irate, crazy a little bit.
And could you describe what happened next after he burnt his finger?
He put some stuff on it. I asked him if he wanted to go to urgent care of the hospital, and he told me no, that I don't care about him. Just crazy stuff.
And then, so what happened next after you had the conversation about urgent care?
He just went to go lay down in the back room.
Okay. And did Mr. Pate do anything while he was in the back room?
He put a belt around his neck, and Cole and Noah came to the living room where I was sleeping and told me. And then I went to the back room.
I'm gonna pause you real quick. So, who are Cole and Noah?
My sons.
Right. And what did they tell you when they came back?
That Mike was playing dead with a belt around his neck.
And what did you do next when you heard that information?
Went back there and told him, why are you doing this stuff around my children?
And what was his reaction?
Nothing, just laying in the bed.
And so what did you do next?
Took the belt from around his neck.
Right. And then what happened next?
I just walked out the room.
And after you walked out the room, did the defendant have any sort of reaction?
Objection.
She's just asking what happened next. Overruled. Go ahead.
So what happened next?
I was sleeping, and I guess when I came there, he had a knife sitting on the couch.
When you came where?
I was sleeping.
You were sweeping or sleeping?
Sweeping, like cleaning.
Okay. So after you leave the room and you took the belt off his neck, you went into another room and were sweeping?
Yes.
All right, and then what happened next?
He came in the room, was trying to feel on me, told me I didn't care about him, love him, or anything. So I guess I went to the living room.
And what did you do when you were in the living room?
I was sleeping by the door.
Right. And did Mr. Pate enter the living room?
Yeah, he was still in the living room.
And did you guys have a conversation or an argument while you were in the living room together?
No, not really. Just arguing, him calling me names.
What were the names that he called you?
Bitches, whores.
Not sure what is relevant. Objection to relevance.
Your Honor, they're having an argument. I'm getting to the point of the matter.
Yeah,
Describe the
overruled.
demeanor.
Go ahead. Go ahead.
All right. And what happened after? What happened next after he started calling you all these names?
He went to the back room, and I don't know if he grabbed a gun or a BB gun.
But at that moment, what did you think it was?
A gun.
All right. And did he do anything with the gun?
He just put it to my head.
All right.
And put it back in his pocket.
All right.
Then he proceeded down the hallway.
Okay, I'm gonna pause you right there. When he put the gun to your head, did he say anything?
Which I'll give you.
Okay. And did you feel anything on your head?
Cold.
Cold. And can you describe what the gun looked like?
Reddish, black.
Right. And have you seen that gun before?
Maybe one other time.
Have you seen the defendant with that gun before?
Yes.
And so you said he pressed it to your head.
And then he hurried up and put it back in his pocket. And he went down the hallway. And then as his sister was pulling up, he left out the house.
Okay, so I'm gonna pause you real quick. How did it make you feel when he pressed, what was going through your mind when he pressed the gun to your head?
Scared.
And you were saying, what did the defendant do afterwards? You said he went into the back room?
Down the hallway.
All right.
I don't know what he would do down there.
Did he have the gun with him when he left?
I don't know.
And you said his sister was in the home?
Yeah, as she was coming in, she seen him acting crazy, and I told her that he put a gun to my head, and he took off.
And where did he take off? What do you mean by taking off?
As Jennifer walked out the door, he was like, "You really gonna call the police on me?" She says, "Yes, you are out of control."
And so what did he do when he heard that information?
He took off really fast in my car.
And did someone call 911?
Yes, Jennifer.
Jennifer, the sister?
Yes, correct.
No further questions, Jennifer? Cross?
I want to talk about this weapon that you described. You said something on that examination. You said that you didn't know if what you saw was a gun or a BB gun. You remember that?
Correct.
Do you know the difference between a gun and a BB gun by looking at it?
No, not really.
Okay.
I'm sorry, I didn't hear the question, Your Honor.
I asked if she knew the difference between a gun and a BB gun by looking at it. Then, what made you think it was a BB gun?
Because his son said his dad had a BB gun
When was this?
a long time ago.
Okay, and so when you said you also said you believe you saw this weapon before, right?
I don't know if it was a gun or not.
Let me make my question more clear. You said that prior to that, the day of this incident, you've seen that weapon before, right?
Yes.
And when you saw it was a BB gun then?
No, I don't know what it was.
Okay. Well, when did you see it? You know how long ago you saw it before this incident?
Months ago.
Was it close in time to when his son told you that his dad had his BB gun?
No.
Okay. Do you know what type of, or what the BB gun that his son was talking about?
No, I've never seen the BB gun, actually, no.
Okay. So how many times have you seen Mr. Payton what you believe to be either a BB gun or a real gun?
One time.
Okay. You said how long ago was that before the incident?
Your Honor, objection, this was asked and answered.
I seriously don't remember the answer, so she's right.
All right, overruled, go ahead.
No objection to that, I'm sorry. And how long ago did you say it was?
Months ago,
You
maybe
don't
like
know?
4 or 5 months ago.
What was he doing with it?
I don't know, just had it in
Your Honor,
his.
objection, how is it relevant?
I believe it's relevant term as to the charge is ADW to with handgun, and I'm just trying to make sure that the witnesses account direct examination, but she wasn't sure if it was BB gun or a handgun, so I'm just trying to.
Yeah, and she said, but she also said she wouldn't know the difference between the two. And she wasn't sure if it was the gun or a BB gun. She testified she didn't know the difference between them. So let's move along.
And where were you standing? Were you standing or sitting when you believe you had a weapon pointed to your head?
By the front door, by my couch,
Were you standing?
with a broom in my hand.
So you're standing?
Yes, I was.
And where was the gun? Or BB gun pointed at you?
Right here, right here.
Ma'am, can you do that one more time? Right where?
Right here,
All right, the witness is
in
directing.
my head,
All right,
to my head.
ma'am, one sec, let me make the record, okay? Witness is pointing right to the middle of her forehead.
Forehead.
Okay, and then you said right here and right here. So you pointed to the middle of your forehead. Where else?
That's it.
Okay.
Did you see where the weapon was drawn from?
His pocket.
When you pointed to your head, you kind of tapped it. Were you hit with the weapon in your head?
No, he just put it to my head.
Did it leave a mark?
No.
You see, he pulled it from his pocket. So it's a small weapon?
Kind of like a police weapon, smaller. It was a gun, but I don't know.
Okay, do you know the difference between a revolver and like a gun you see like on a cowboy film or a semi-automatic?
Kind of like a police officer's gun, kind of. I believe.
So how fast did this happen?
You just put it to my head, said, "Bitch, I'll kill you," and then straight up and went like that. Went down the hallway. Sister came in the house. You know, seen him act crazy. So he took off in my car again. And didn't come back.
You didn't sustain any physical injuries?
No, I did not.
And you said that there was that Mr. Payton was barbecuing. That's a yes?
Yes.
And so obviously there's food, there's drinks. Was there any alcohol at the house?
Yes, Fireball.
Okay, and so did you drink any alcohol that day?
I had a shot earlier that day.
When you say earlier that day, so we'll get to that in a second. Because we kind of skipped over here in time a little bit. So I want to make sure that there's no confusion. There was a burn. You said that happened to Mr. Pay? Yes.
Yes, correct.
And then at some point in time, you said you went to sleep. Do you remember that? What were you saying that you were sweeping?
Sweeping,
Okay.
cleaning, sweep with a broom.
Okay, and so nowhere in between that time had you fallen asleep?
No.
Okay, and how long after the burn do you believe is when this altercation happened between you and Mr. Page?
When you say altercation, are you meaning the gun on her head?
Yes, sir.
All right, between the time he burned his finger and the time the gun was held to your head, how much time was in between?
Maybe 10 minutes, not even.
The address where this incident happened, Mr. Page lived there with you?
Yes,
For how long?
2 years.
And how many, you said, how many of your kids were there when this happened?
3.
How old is Cole?
Cole is 8.
And how old is Noah?
6.
Were either one of them witness to this incident with the firearm?
Cole seen it
Where was he at when this happened?
in the living room.
Do you have a ring camera at your home?
Do I have a ring camera?
Yes, ma'am.
No, I do not.
Do you have any cameras in the home at all?
No, I do not.
At some point in time, your car was returned to you.
It was a bandit and he took the keys and then They told me they found my car, but then when they found them, they returned my keys to my house.
And your car was searched by the police?
I gave them permission.
Objection, Your Honor, I don't know if she has knowledge of that.
Well, she said she gave him permission.
Yes, I did.
Search for a firearm?
Yes, correct.
No weapon was found?
No weapons were found.
Before this day, leading up, I'm gonna put you in a place and time, maybe like a couple weeks before this incident happened, were you and Mr. Pate on bad terms?
Objection, Your Honor, relevance.
I do not recall.
Both the bias.
All right, I'm gonna allow it, overrule. What'd you ask her? Say it one more time.
Had you and Mr. Pate been on bad terms a couple weeks before this incident?
No.
Is it fair to say that you wanted him out of the home?
I don't want him in my home.
Before this incident had occurred, you wanted him out of the home
I've been wanting him to leave.
because the relationship had soured.
I would object, again, I don't see how this is relevant to her having a gun placed on her head.
He goes to bias again.
I mean, I do think it goes to bias, but I don't think it's particularly relevant. Otherwise, I'm gonna allow him some leeway, but not much more, Mr. King.
I understand. You didn't repeat the question?
Yes.
Okay. You wanted Mr. Pate out of the home because the relationship had.
Yeah, he has no motivation to get a job.
What's the relevance? And then, again, it wasn't you that called 911, right?
No, it wasn't. No.
When you saw Mr. Pate leave the home, you didn't see him with the weapon, right?
No.
All right. You yourself have not found a weapon inside of your home since that incident, right?
2 days ago, I cleaned out my closet and I don't know if it's a BB gun or a gun that's in the case.
Where was the closet located?
In my bedroom.
Did you open this case?
Yes, I opened it, but I did not touch it. I just zipped it up and put it back up there.
Any redirect?
Thank you, Your Honor. Ms. Wistini, you mentioned that you had one shot, correct? Of
Yeah,
alcohol?
that was way earlier.
And did it have any effect on you?
No.
And was the defendant drinking that day?
Yes.
Do you recall, and did you see him drink alcohol?
Yes.
Do you recall how much he drank on that day?
A pint, and then he made me buy another pint.
And earlier you said that after he held the gun towards you, he went to, where did he go?
He went down the hallway.
And when he went down the hallway, where did he go?
To my bedroom.
To your bedroom. Sorry. And then did he exit the bedroom?
Yes.
And where did he go?
Just me and him talking crazy to each other, and his sister walked in the door.
All right.
And I told her that he couldn't.
No, I don't have a question. All right, no further questions. Thank you, Ms. Christie.
Any cross based on that?
Did you notify the prosecution or the police with regards to the case that you found in your phone?
Yes, today.
And very briefly, in doing so, how long was Mr. Payton in the bedroom before he left the home?
Maybe 2 minutes.
Wait, what's the question? I'm confused. After the firearm was put to her head,
Yes,
how long before he left?
he went to the room, correct?
Yes, he did.
How long was he in the room?
Maybe a second or two, not that long.
Okay.
And then he left the home.
Huh?
Then he left the home.
Yes.
No further questions.
Your Honor, please don't move to, the people have no further witnesses.
Okay, so ma'am, you're excused. You're all set.
Okay.
Thank you. And counsel, any witnesses on behalf of defense?
None from the defense, Your Honor.
Okay. Madam Prosecutor?
Your Honor, the total to bind over as charged in Missouri County.
Yeah, I think we have, so with regards to count one, I don't think that there's enough evidence to proceed. The specific allegation is that there was a handgun in count one that's placed to complainant's head. I continue on with count two. Specifically, again, the allegation is that there was a handgun, and by the witnesses on the count, when the prosecution asked the witness what happened, the very first words out of her mouth were, I don't know if it was a gun or a BB gun that was pressed to my head. I understand the descriptions that followed thereafter were gun, gun, and gun again. And I also, Your Honor, this is a matter of first impression for me. I'm not sure if it's this court, but this is the very first time I've been told of evidence while doing an examination that's potentially still outstanding and very critical to the charges that are presented here against Mr. Payton. I think the question of whether or not this is a gun or a handgun can be resolved within the hour. I wasn't made aware.
I mean, I'll say just in response to that, it sounds like there may have been 1 or 2 guns. I mean, the testimony is not clear to me whether or not the only firearm he ever had was a BB gun. She knew that there was an existence of a BB gun that he had received from his son, but there was no testimony that there wasn't also a gun. And she testified that she was cleaning a closet. She notified the police. She found the gun a day or 2 ago in a case. Or she found a case. I don't even know if she testified she opened it, but there was a gun case. There was a gun. So.
Or a BB. And I think if that is the case, that it can, and all of a sudden there's something that's in the closet that she can have someone who establishes a chain of custody, show it to her and say, was this in fact what you saw? And if so, that automatically dismisses counts 1 and 2.
I mean, but for felonious assault, I mean, the elements of felonious assault are, was it a dangerous weapon? And whether or not it's a BB gun or a regular gun or a knife, I mean, it's still a dangerous weapon. And her testimony is that that gun was pointed directly in the middle of her forehead. So I understand that the information says a handgun, but the charge of felonious assault does not require that. he attempted to commit a battery or did an act that would cause a reasonable person to fear or apprehend an immediate battery. That he intended to injure her or to make her reasonably fear a battery. And third, at the time, the defendant had the ability or appeared to have the ability or thought he had the ability. And fourth, that the assault occurred with a dangerous weapon. I mean, she testified she was scared, as any human being would be if someone put a gun between their eyes. And whether or not he had the ability to do it, he certainly appeared to have the ability to do it. The allegations, that is what the jury instruction requires for assault with a dangerous weapon.
And I've had that trial before, and I completely agree with the court. The difference here is that they put it in the charging document. And so when they do that, when they make it specific as with regards, when they say the words "to wit" and then put a handgun, they place themselves in a very compromised position when they come to court and then argue that it could or could not have been a gun.
Well, I don't think they argued that. I mean, that's what the witness testified to, but realistically, what I'm looking for is probable cause that it was a firearm. And she testified she had heard before there was a BB gun. She's testified that the gun that was put between her eyes was about the size and shape of a police gun, which is not a BB gun. And I don't know how realistic BB guns look, but it seems to me that the witness was in fear of a direct and harmful battery. It's a probable cause standard. She testified it was a handgun that he kept pulled out of his pocket and put between her eyes. And it's a probable cause standard. Now, whether or not that's an argument for trial, that's going to complicate matters for the prosecutor is not before this court. But for a probable cause standard, I have a witness that says that a weapon that resembled a law enforcement officer's gun was put between her eyes. And he said, "Bitch, I'm going to kill you." Is that what he said? That's what, "Bitch, I'll kill you," is what she testified he said. And certainly any reasonable person would be in fear and apprehension of a imminent battery when someone makes a statement threatening someone's life and then puts a gun between their eyes. I mean, certainly her response was very reasonable. And I do think that the people have met their burden. And it's count two is also with the handgun. There's testimony that it was a handgun, and whether or not if it was a BB gun, that's for future discussions that are not in front of this court. For a probable cause standard, there's enough testimony for the court to rely on to make a probable cause finding, and I'm doing so. So the case will be bound over to the Third Circuit Court for future proceedings. There's also a misdemeanor count that will follow. So you're bound over to the Frank Murphy Hall of Justice, Third Circuit Court for future proceedings. On count one, assault with a dangerous weapon, felonious assault. Count two, felony firearm, and the count three is a misdemeanor that will just follow that matter. So that's my ruling. The arraignment on the information will be
May 20th. Can we address that?
we can, let me give the arraignment date.
May 20th.
May 20th, 9 a.m. at the Frank Murphy Hall of Justice. And then Esteban, did you have a chance to review the DSU report?
No.
Counsel, if you want to approach you and Madam Prosecutor can take a moment to look at that. Thank you. You two can take that. And I'll just take it back when you're done. Have both parties had a chance to review the DSU report?
Yes, ma'am.
All right, as to bond.
As the bond runner, I just know the issue report indicates that Mr. Page is a low risk where minimal or no conditions are required. I understand the assault nature of these allegations and balancing with this presumption of innocence. I think the court can set forth some conditions that can guarantee the safety of the return court. The recommendation was for a monetary bond in the amount of 50,000 10%. I've spoken with Mr. Page at the Wayne County Jail, and that was literally the number I suggested, and he made it clear to me that if that was the amount that was put in place, that he would not be able to afford that. So I think I'd be asking the court to obviously for a tether and for him to be not allowed to have any communication with the complaining witness or to having assaultive or stalking behavior with that person as well. I think with a tether and with a lower monetary bond of $2,000, 10%, that Mr. Pate would have incentive to come to court, and also the court's concern with regards to flight and safety can be addressed as well.
Your Honor, I would object. I would ask that bond remain the same. The defendant is here on 2 assaultive crimes. One involving a gun that was not recovered. Yes, the complaining witness indicated that there may be a gun at her home, but it's not unknown whether it's the gun from this incident. And not knowing where a gun is puts the complaining witness and her children in a very dangerous situation. Certainly that the defendant had no problem taking a gun out while 3 underage children were home at this time. Further, Your Honor, I'd like to indicate that I believe so that the defendant is on violation, has violated his probation in the past, and is currently on probation. The complaining witness.
What's he on probation for now?
I believe the DSI had probation on Battle Creek.
Traffic involved, disruptive violence.
Okay, traffic.
And then further, Your Honor, I can have a moment. Your Honor, further, he has a warrant out of the U.S. Department of Veteran Affairs in Battle Creek from 2021. It's a felony for a stolen vehicle. There's a warrant request for that. Additionally, the complaining witness did indicate that he is not currently employed. If he cannot return back to her home, certainly where is he to go? And again, underscoring that he does put the complaining witness and the children in danger. I believe bond is appropriate.
I'm in no way suggesting to the court that everything that happened this day is okay. I think when we find out that this is a BB gun, though, the face of this case is going to change.
Why though? If Mr. King, here's my issue with it. If someone, listen, when we're thinking about this, right, especially these types of crimes, it's not just what's in his head, it's what's in the victim's head. Right? And when we're looking at a situation like this, or any situation where someone puts a gun to someone's head, you know, whether or not it's a BB gun or a regular gun, in that moment, at that time, the complaining witness didn't know that. And the jury instructions on what the standard is and what the elements are clear. It's would a reasonable person be in fear or apprehension of an immediate battery. So here's my problem, and I don't need to hear any more from either of you. I've seen the DSU report, I've reviewed it. My concern is this: the allegations in this case are egregious. I can't think of a circumstance that someone would feel more threatened. I mean, it's a firearm to someone's head. And she's got little kids in the house. I don't know how old the 3rd child is, but she testified she's got a 6-year-old and an 8-year-old in the house, and that the 8-year-old was in the room when he put a gun to her head, his mother's head. I mean, the behavior is so appalling. You know, and I'd also just state for the record that there was some testimony, it wasn't objected to, that the defendant's sister was the one that, you know, said enough and was the one that contacted 911. I mean, so other people who are involved in this that have relationships with the defendant thought that the appropriate course of action was to contact police. She didn't say, okay, let me get my baby brother out of here and go put him in the car. She said, we need to call police. And I just can't think of a circumstance where a domestic violence victim would be in more danger than when someone pulls out a gun. I mean, that's what's left. Pulling the trigger, that's it. That's the only thing left. And I cannot, the judges downtown that are a court of higher jurisdiction might disagree with me, and I respect their position, but given the allegations in this case, the testimony that I heard today that I believe was very credible, and the fact that there was a minor children in the home during this allegation, and the fact that the defendant's got outstanding warrants, he's definitely a danger to the community. He's certainly a danger to the complaining witness on this case, certainly a danger to her and her children. I'm not modifying bond. You can take it up to circuit court. And then, did we find Mr. Gazicki?
He's not either. I tried.
All right, Mr. Gazicki's gone. Davidoff, all right, Mr. Gazicki, are you going to, well, you'll be next door, right?
I'll be
Okay.
there. I'll come.
Every day in the USA, people find themselves in court.
See. Hello?
I'm at MDLC.
MDLC. Okay, thank you. So you are Jamie?
Yes.
Jamie Kirksey. Okay, thank you. Today's proceeding, do you want to speak to MIDC, to an attorney?
Yes.
All right, let me give you to the attorney. Crystal, you got a couple in your room.
Thank you.
Yep. Is that Washtenaw County? That just signed on?
Yes.
Who do we have? Is that Jennifer?
Yes.
All right. Washtenaw, do you hear me back there?
Yes.
Do you also have Jessica when we're done with Jennifer?
I'm sorry, who?
Jessica Yoder.
I don't know anything about her.
Oh, we also have her scheduled at 8:30 as well.
At the same time?
Yeah.
I was about to move them over because I figure we should do them first, right? So that we'll have.
Well, down in your waiting room is MDOC.
MDOC, that's what I'm, okay, so I'm gonna do that one first, and I wanted to let you know that I am covering Pablo Dominguez for Daniel Bitar. That's what he was telling me now. Okay, so, thank you.
Jennifer, for today's proceedings, did you want to go forward with an attorney?
Sure, yes.
All right, let me put you in the waiting room.
Apparently, I need to.
Heather, I had no luck with her.
With Tamra?
Yeah, I sent her the call-in number.
Uh-huh.
And then it's like her phone froze. And then I tried to kick her out of the meeting and then it just like kept freezing.
Yeah, she came into the main meeting and I just kicked her out because she didn't
Okay.
have volume or anything. So
Okay.
and just so you know, a minute. So Livingston County should be popping on as because I have Washtenaw, MDOC, Livingston, Macomb, and another Washtenaw. For I already checked in a couple of them, but we're waiting for 2 more counties.
Okay, sounds good.
All right. Thank you, Washtenaw.
Yep, she'll be up shortly.
All right, I'm just gonna put her in the waiting room for, well, I guess I gotta wait for her.
Mute, so when she comes up, she can just go in.
Good morning.
Good morning, Mr. Zotaloff. Good morning, Gregory.
Close enough. Greg is just fine.
Did you need to speak to
James?
James?
Absolutely.
All right. Did I make him co-host? Mr. Mena, if you want to pull him in. I'm gonna guess he's busy, so let me put you in.
I appreciate it. Thank you.
You're welcome. Tamra? Tamra, can you hear us? All right, Mackenzie, let's try again. See if you can give her the call-in number.
All right.
Okay, I need to turn the volume up. I think I hear him. I think I hear you. I need to find my volume now. Say something again.
Yep, can you hear us?
These kids messing with the volume. Microphone. Can you hear me?
Yep, we can hear you. Can you hear us?
This is crazy.
Thank you for joining us, Diana. Hopefully everybody should be jumping on soon.
I don't understand why I have to be at this court date. I don't even know what this court date is actually for, by the way.
It's regarding a motion on the conditional bond. So when
I
everybody,
don't know what that means though.
right, the judge will explain it. Because I know Emily, the probation officer, had reached out to you last week. So yeah, it'll be explained a little bit more whenever everybody gets on, okay?
Okay.
Thank you. I'm just gonna mute you till the case is called, okay?
Okay.
Thanks.
Heather,
Yes.
on Ivaneve, we're gonna do a double parking 350 and dismiss the 2 citations.
Double park 350 and dismiss. Alrighty, thank you so much. I'll go grab the files.
Okay.
Heather, there was no luck. She's gonna try and dial in now.
Okay, good. Mr. Zadopolsky?
Yes, ma'am.
Since these are civil infractions, you are good to go. Do you want, how many days, do you want 14 days for your client to pay?
14 days is fine.
14 days. All right. I will have
Thank
a
you so much.
discode in a little bit. Thank you.
Everybody, thank you so much. Have a nice one. Thanks. Bye-bye.
Yep, you too. Bye-bye.
Okay.
Every day in the USA, people find themselves